Welcome back. We are now on the record, and we will start with item number 1, docket number 2023-033, cause number 130-22, in the matter of request for agency action of OVINTIV USA Inc. for an Order 1, modifying the board's order entered in cause number 139-150 by extending the board's order entered in cause number 600-03 to reduce the north-south drilling unit boundary setbacks from 330 to 100 feet for the drilling units comprised of sections 4 and 9 and 5 and 8 respectively of Townships 4 South, Range 2 West, and 2, establishing an overlapping drilling unit for drilling long lateral drilling unit boundary wells for the production of oil, gas, and hydrocarbons from the Lower Green River-Wasatach Formations. I will now ask for appearance of counsel.
Thank you, Mr. Chairman. Mitch Mayo of Lear & Lear on behalf of OVINTIV USA, the petitioner in this case.
And Gordon Rowe, Assistant Attorney General on behalf of the Utah Division of Oil, Gas, and Mining.
Over to you, Mr. Mayo.
Thank you. Before I begin, I'd like to recognize the board. Thank you for accommodating the change in counsel this month. I'll be handling hearings for Mr. McDonald as he's out, and we did file notice of appearance in each of those matters per the board's request, so I'd like to thank you for that. As I said, Mitch Mayo of Lear & Lear on behalf of the petitioner OVINTIV USA Inc. here today. With me are, as witnesses, are 2 individuals appearing in person. Mr. Jordan Lear, the senior land negotiator for OVINTIV, and Mr. Kendall Brown, the manager, he's behind the TV back there, manager for Uinta Reservoir Engineering. Also with us appearing virtually pursuant to board order is Josh Reamer. He's the geoscience manager at OVINTIV. If I could have all 3 witnesses sworn in at this time, Michelle.
Gentlemen, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Josh?
I do.
Oh, thanks. Thank you for that. The resumes of all 3 witnesses have been submitted collectively as Exhibit A. If separately asked, each would verify the contents of their resumes as true and correct. Mr. Lear will be testifying as a fact witness in this matter only, while Mrs. Reamer and Brown, who have previously been recognized by the board on several occasions as experts in geology and reservoir engineering, respectively, based on their previous recognition and their resumes submitted as Exhibit A, and presuming division has no objections, we request they again be recognized as experts in those areas for this cause.
No objection from the division.
Board, any concerns? Seeing none, they are recognized.
Thank you. And also, to keep with past practice, I want to confirm that it's okay for me to move for admission of exhibits at the close of our case in chief.
Perfect.
Thank you. Today, OVINTIV is before you seeking approval of a 2-part request, both parts of which this board should be fairly familiar with at this point. First, OVINTIV seeks to modify the board's order in cause number 139-150 by extending the board's order in cause 600-03 to reduce the heel-toe setbacks for horizontal wells from 330 feet to 100 feet. These apply to existing stand-up drilling units comprised of sections 4 and 9 and sections 5 and 8 of Township 4 South, Range 2 West, respectively. As to the heel-toe setback reduction, the data derived from drilling horizontal wells throughout the unit basin reflects reduction of the heel-toe setbacks from 330 feet to 100 feet, not only results in additional resource recovery that otherwise would be left in the ground, but also does not adversely affect the correlative rights of the production interest owners in the adjacent lands for at least 10 years, and even then only minimally. The testimony and exhibits submitted today will confirm the same as to the DSUs at issue. True and correct copies of the 139-150 and 600-03 orders were submitted as part of Exhibit B on file in this case. And the second change that OVINTIV is seeking here by this request for agency action is the establishment of a special internal drilling unit boundary well, drilling unit, comprised of sections 4, 5, 8, and 9 of Township 4 South, 2 West, with authorization to drill up to 5 such wells with 100-foot heel-toe setbacks, up to a 330-foot flexibility along the boundary line between the two existing section drilling units. Essentially, OVINTIV is seeking to establish a drilling unit for 2560 development of these 4 sections, and for permission to land 5 wells within that 330-foot corridor on either side of the section line. A true and correct copy. Oh, I'd like to remind the board, this is similar to the relief this board granted in its order entered in cause 130-17. A true and correct copy of the 130-17 order has also been submitted as part of Exhibit B in this cause. Since Indian mineral lands are involved in the requested DSU, a communitization agreement is required, and the agencies, whether under federal guidelines or preferred practice, require a spacing order from the board for such a CA to be approved. This is another reason why OVINTIV is before you today. The board has jurisdiction over this matter pursuant to Utah Code 40-6-5-3B and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested DSUs, to the working interest owners, including unleased owners, in established drilling units adjacent to the affected areas due to the requested setbacks, and to the BIA and BLM being the governmental agency having oil and gas jurisdiction over many of the lands. These mailings were sent to the last known addresses of record. The record will also reflect that notice was duly published in the Salt Lake Tribune on July 2nd and the Uinta Basin Standard on July 5th, and in the Deseret News on July 7th. The Division of Oil, Gas, and Mining filed a response on July 10th, expressing non-opposition, presuming that OVINTIV meets its burden here today. We believe we will do that. No other objections or responses were received. And with that, I'm ready to move on to my first witness. Mr. Lear, can you state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And could you please spell your first and last name for the court
Sure.
order?
It's Jordon, and my last name is Lehr.
Thank you. And briefly describe your position with OVINTIV, especially as it relates to the unit here today.
Sure. I'm a senior land negotiator with OVINTIV, and I have responsibility over the lands at issue, among others in the basin.
Okay. And can you remind the board of OVINTIV's corporate and bonding status?
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and merger of OVINTIV Production Incorporated.
Thank you. Now I'm going to move on to your testimony here. I'm going to show you what we've submitted as Exhibit C, D, E, F, G, and H. Do you recognize these exhibits?
I do.
And were they prepared by you or under your direction or supervision?
They were.
Okay. With Exhibit C, the board is used to seeing some version of this. Can you walk them through what it shows?
Sure. This is just what we refer to as a regional locator plat, and it's showing the DSUs at issue in red, which are located along and south of US 40, approximately halfway between Bridgeland and Mightontown sites.
Okay. Exhibit D.
So Exhibit D is a plat of the existing DSUs and the producing wells within them. We're just basically trying to highlight that there are 2 stand-up drilling units comprised of sections 4 and 9 and sections 5 and 8 respectively, which were established under the 139-150 order. Pursuant to the 139-150 order, a long lateral horizontal well has been drilled and produces on each of the DSUs, and those are the only wells on the subject lands. Currently, the 330-foot heel-toe setbacks were established, later modified to 100 feet under the 600-03 order, but only as to certain lands and not the subject lands here.
Okay. So the 139-150 order established several 1280 DSUs with 330-foot heel-toe setbacks.
Correct.
The 600-03 modified some of those units to reduce those to 100 feet, and this is kind of the next iteration of that.
Correct. We're just, again, extending the 600-03 to these lands.
Okay. Moving on to Exhibit E, the plat of the requested drilling unit, boundary well drilling unit. I'm not sure the full acronym.
Exhibit E is exactly that. It's basically showing the 2560 or thereabouts spacing being all 4 sections there. There are Indian minerals in each DSU, as Mr. Mayo discussed at the opening. And in OVINTIV, in my personal experience, when Indian minerals are involved, a spacing order not only facilitates but is required for BLM and/or BIA approval of a conforming communitization agreement, whether by guidelines or agency practice.
Okay. Exhibit F. This doesn't need much, but can you quickly show the board what this shows?
Sure, we're just trying to show that OVINTIV is the majority working interest owner within each of the existing 1280 stand-up DSUs and the proposed 2560 there.
Okay, so line 1 and 2 are the 1280s, and obviously line 3 is for the 2560 that's being proposed here today.
That's correct.
Okay. Finally, a couple more exhibits for you. Exhibit G.
So this is the status of spacing in nearby areas, visually just kind of showing what we've already stated in that the 139-150 order is kind of that brownish color. The existing or established DSUs that are part of this request here are in red, and then the purple color is the current 603 lands. We've also kind of tried to show for the board where within kind of the neighboring lands that 100-foot setbacks have been approved. And those are denoted in the legend with the asterisks there.
Okay. So if I'm looking at that correctly, it looks like the green boxes, the purple boxes, and the dark blue boxes have been reduced to 100-foot setbacks, heel toe.
That's correct.
Okay. Anything else on this slide that you'd like to point out for the board?
No, I think this is something that the board's probably seen a number of times, and again, we're just trying to show regionally these lands kind of sit very close to where we've already applied for reduced setbacks.
Okay. Finally, I'm going to have you talk through notice with the board. It's perennially important here. Exhibit H kind of reflects that notice. Can you walk the board through what those purple or those dark pink areas and the crosshatch areas mean?
Sure. So the red hatched area, which are the existing DSUs where we're talking about reducing the setbacks, those are the areas where all production interest owners have been notified of this request. And then the pink shaded areas are all the adjacent lands at the heel and the toe where we're reducing the setbacks. And in those shapes or those sections, all working interest owners, including unleased owners in the established drilling units, have been notified of this request.
Okay. Perfect. I'm going to refer you, without showing the board or you, to the original and supplemental certificates of mailing. Those are pleadings that are on file. They were prepared by our offices and submitted earlier in this cause. Are you familiar with those pleadings?
I am.
And have you reviewed those prior to the hearing?
I did.
Okay. And what is that list of names, or where does that come from? Who does that?
The list of names are parties and addresses that were compiled from OVINTIV's internal land records. So obviously the wells are in pay, so parties that are on our pay decks, including title opinions, a search of the BIA and Duchesne County records prior to filing the request by Lone Wolf Energy Incorporated, who's our contracted land service company. So in summary, our own internal records, the county records, and the records of the BIA.
Okay. And in addition to those production interest owners, did you also send it to governmental agencies with jurisdiction over these lands?
Correct. So the BLM and the BIA were part of the parties noticed for this request.
Okay. And I would just like to ask one final question. The RAA was mailed via regular, not certified mail in this case. Is that right?
That's correct.
Okay. That's why there's no Exhibit Z here to discuss the returns of service. With that, I have no further questions for Mr. Lair, if the board or division has any. Otherwise, I'll bring up the next.
Division, any questions for this witness?
Just a couple clarifying on the, first we'll start with Exhibit H. So you obviously noticed in the cross-hatched area as well. Is that true?
Yes, so the red cross-hatched area is where we noticed all the production interest owners.
And how far east and west does that expand beyond the boundary?
So it's just all the owners within those four sections.
Thank you.
I think you're seeing lines there that are probably not, it's probably not drawn on the lines.
Okay.
Right? That,
Yeah,
those red lines don't line up with the little black lines.
I
don't
think
that's what it's-
potentially the wells that are being shown on the exhibit might be throwing your eye a little bit.
Oh, I
but
see. Okay.
The cross-hatched area are just the DSUs that we're talking about in the request.
Great. Thank you for bearing with me on that. And when you said you filed or you mailed out notice before filing the RAA, is that correct?
Well, we filed the RA and then we service notice after.
Okay. I don't have any further questions. You have anything?
Board, any questions? Seeing none, back to you, Mr. Mayo.
Thank you. With that, I'm done with Mr. Lair. I'm going to call my next witness, Josh Reamer, who is appearing virtually pursuant to this board's order. Mr. Reamer, can you hear me okay?
Yes, sir, I can.
And are you ready to go here?
Yes, sir.
Okay. Oh, there you are. Start off, if you would, stating your full name and spelling last name, if you could, for the court reporter, and your business address.
Sure. My name is Josh Reamer. The last name Reamer is R-E-A-M-E-R. I work at OVINTIV, which is on 4 Waterway Square, Suite 100 in the Woodlands, Texas, 77380.
Okay. And your current position with OVINTIV?
I'm the Geoscience Manager of Development.
Okay. And I'm assuming that carries responsibilities over the lands at issue here today?
Yes, sir, it does.
Okay. I'm going to show you what we have submitted in this cause as Exhibits I. Can you see these on your screen okay? Okay.
Yes, I can.
Exhibit I, Exhibit J, wait, not Exhibit, there's Exhibit J. I, J, K, and L. Do you recognize these exhibits?
Yes, I do.
And I'd like to clarify that it's substitute Exhibit L. Not Exhibit L, as I just misspoke. And were these 4 exhibits prepared by you or under your direction or supervision?
They were.
Okay, thank you for that. Returning to the first exhibit, Exhibit I, type log, the board has seen this numerous times, but if you could quickly point out some of the relevant information that it shows for the board.
Sure. Yeah, this is the field type log, the Shell Brotherson 1-11B4 well. It shows the stratigraphic definition for the Lower Green River-Wasatch transitional formations, which comes from the 139-150 as well as the 139-134 orders. This exhibit reflects the primary intervals which will be targeted in the requested DSUs.
Okay. And Exhibit J, this looks like a type log probably. Does it correlate with the type well? I guess maybe that's a question just for my own curiosity.
It does, actually. This is just a type log closer to the application lands. Basically shows that it's correlative to that field type log, highlighting the primary targeted intervals for long lateral wells, and again, highlighting the 5 primary targets.
Okay, thank you for that. Exhibit K, this is the stratigraphic cross section. Can you walk the board through this one as well?
Absolutely. It's a west to east cross section through the area of interest. It reflects uniformity throughout the area. It also highlights that the Lower Green River-Wasatch transitional formations constitute one source of supply in the area and is consistent with the board's designation for those formations as one pool throughout the Uinta Basin.
Okay, thank you for that. Finally, Substitute Exhibit L, there was a slight correction or a slight change in the exhibit that was presented. But can you walk the board through the generalized maximum stress that you see in this area and how it informs both the orientation and the setbacks you're requesting here today?
Sure. Yeah, so the Exhibit L is the interpreted maximum stress direction with the associated rows diagrams on the map. What this shows is basically observed stress indicators, typically from logs or FMI logs throughout the area. And what's highlighted here is that the average fracture orientation is north 70 degrees west, which supports a stand-up or north to south drilling oriented units.
Okay. Do you believe that this is, in your expert opinion, that the 100-foot setbacks requested here today and the establishment of the drilling unit, that they're, what is your expert opinion about the viability of this request?
And it's consistent with what we've done before, and I do think it's the data supports that we can ask for extended setbacks.
Okay. I appreciate that. I don't have any further questions for Mr. Reamer at this point, subject to division and board.
Division?
Nothing from the division, thank you.
Board? Seeing none, back to you.
Thank you for that. With that, Mr. Reamer, I'm done. If you just hang out there for a minute, we may have some follow-up questions for you there, but you can put yourself on mute and just watch for a minute. Thank you.
Sir, I'll be here.
Now, I'd like to call my final witness, if I could, sitting next to me, Mr. Kendall Brown. Could you state your name and spell your name, although it's fairly straightforward, and business address for the record, please?
Of course. My name is Kendall Brown. It's Kendall. Brown, like the color, Brown. I am the reservoir engineering manager for the Uinta Basin with specific responsibility over the development of the lands OVINTIV owns and leases.
Okay. And is it fair to assume that you have the same business address as those other two?
Yes.
Okay, thank you. Moving on, I'm going to show you what we've submitted in this cause as Exhibits M through P. Exhibit M, N, O, and P. Do you recognize these exhibits?
I do.
And were these prepared by you or someone in your office under your direction or supervision?
They were.
Okay. Starting off with Exhibit M, the setback illustration. First off, usual question comes up, is this drawn to scale?
It is not drawn to scale.
Thank you for that. Would you please kind of walk the board through what this shows and how it supports the requested relief?
Absolutely. So what the cartoon description is showing here is the 100-foot setback reduction that OVINTIV is requesting, as well as the east-west setback being 560. What's shown here is what Mr. Reamer testified to, the stress orientation that we've measured in the field, believed to be around 78 degrees in this particular lands for the request. So shown is that due to the fracture orientation being that direction, it doesn't interfere with the north-south setback, thus the request for the 100-foot setbacks. And shown in here is just a cartoon illustration of about what the 5-year drainage ellipse would be estimated to look like. Probably maybe one other thing just to mention on here is not shown on here is obviously the lease line section wells that we would be applying for as well.
That's right. But the same analysis for the setback reduction applies to that.
Exactly.
Okay. Actually, it's probably not a bad idea to refer you to Exhibits D and E that Mr. Lair talked about earlier. Let me think about that. Nope, I lied. Let's just keep going. There we are. Moving on to Exhibit N. Can you please discuss the drainage calculation ellipse and when, if ever, this is going to be impinging on correlative rights?
Absolutely. So shown in the diagram here is what we've testified to numerous times now using Hales and Ever. This is a correlation to estimate drainage based on hydraulic fracture half lengths. So shown in this diagram, the most relevant for this discussion is the B variable in the ellipse. So shown in the table in the bottom right, you can see that that B variable reaches to about 103 feet, but it takes 10 years of drainage to be able to achieve that with the underlying reservoir property assumptions that we have stated in the input table. So due to this, we believe very minimal, if any, impacts will be on adjacent lands based on this support. And just to add note here shown, and it was in the prior document, is just where we're getting our reservoir fluid properties from. So in the red star there is the null 7H. It's directly adjacent to the lands we're talking about here. So we've been able to directly measure the fluid viscosity, which is a key component to this calculation.
Okay, and actually is that the same null 7H, I'm assuming, that is referenced here?
It
No,
is a
it's
different
not.
null than that one.
Is it the one
It's
just on the outside
short
of it
one
there?
to the southeast of these lands.
I see. So very close proximity.
Yes, very close.
So it's fair to say there's no drainage of the adjacent lands at 5 years and minimal drainage at 10 years.
That's correct.
Okay. Moving on to Exhibit O. Oil in place, expected recovery factor.
Yep, so what's shown here is just a standard recovery factor calculations utilizing all the reservoir parameters that we believe to be true with the thickness, porosity, oil saturations, our formation volume factors to determine these, as well as with the number of wells allowed in the spacing unit here. So if we sum those up for 40 wells, that would be a 7.9% recovery factor. With the addition of the vertical wells and 8 allowable short lateral horizontals would bring the total to at 8.8% recovery factor.
Okay. Exhibit P, finally, the economics. Could you please discuss with the board the increased benefits for the state mineral owners if these setback reductions and the additional wells are approved here today?
Absolutely. The primary benefit of reducing the setbacks is increased revenue to all working interests, all royalty owners, and all the tax benefit to the state. So what's shown here is we would get about a 4.6 increase to the lateral length, which will directly tie to the increase in the expected recovery of the well. This directly translates to an increase in the economic outcome of this well as increased royalty payments and severance tax for the state of Utah.
So these 330 to 100 foot heel toe setback reductions, that's about an additional 5% of well bore for you?
Exactly.
That's really helpful. Before we close with you, is there anything else? I'm assuming that in your expert opinion, these wells as proposed are economic and the best plan to maximize resource recovery, reduce waste, and protect correlative rights?
Exactly. I think the move to 100-foot setbacks does nothing more than increase the economic benefit to all owners, all royalty owners in the state of Utah, and it does not infringe upon the rights of adjacent owners.
With that, I'm done with my final witness, Mr. Brown, subject to cross-examination.
Mr. Doucette from the division, I think, just has a couple questions.
Yeah, Dustin Doucette for the division. If you could go to Exhibit M really quick. So on those fracture half lengths, was that derived entirely from microseismic data, or were there other sources that you arrived at that number?
The fracture half length shown here is not derived from microseismic. It's derived entirely from our reservoir team's analysis of history matching the existing producing wells that we have across the basin. And that's what we've determined is roughly the average fracture half length using rate transient analysis to history match our actual production and pressure results that we've achieved.
Okay. That's the only question I had. Thanks.
Board, any questions for this witness? Seeing none, are you
I'm done, but I've realized I probably should ask a couple more questions. If I could have 2 minutes to just see which witness wants to.
Please.
Thank you for that, Mr. Chairman, members of the board. I just had a couple follow-up questions to make sure we'd hit on the drilling unit boundary wells. We haven't really discussed that much, so I wanted to ask a couple follow-ups. For that, I'm gonna continue with Mr. Brown, if that's okay. I'm gonna refer you to Exhibits D and E that were submitted and discussed in Mr. Lair's testimony. There isn't a visual depiction of Exhibit M, like you said, that shows the drilling unit boundary well setback difference. But let's talk about it briefly. You're familiar, obviously, with the requests here today for the establishment of the drilling unit boundary well drilling units. What are the setbacks, or how does that development work generally? What's the channel you're operating in?
Yep, so I think there's a couple of ways that we could approach this. We could request reductions of the east-west setbacks to make sure we're not causing any waste along the section line. OVINTIV's stance and the request here is to not forego changing the 560 setback, but to actually establish the 2560 drilling unit, which would allow us to drill directly down the lease line well, which we believe would be a better way to capture the reserves that are along the lease lines as opposed to reducing the east-west setbacks. So our request here gives us wiggle room of 330 feet along that along that lease line to allow us to space and stack wells in there as we think appropriate.
Okay, and so to be clear for the record, the flexibility, that 2560 well, will be drilled somewhere between 330 feet east of and 330 feet west of that section line that divides these four sections.
That is correct.
Okay, and OVINTIV is requesting up to 5 drilling unit boundary wells in this request, is that right?
That is correct.
Okay, and do the setbacks requested, the heel-toe setbacks and the internal setbacks, are they protective of correlative rights between the 1280s and 2560s in your expert opinion?
I believe they are.
Okay. With that, there's nothing further from me on this.
Division, any questions on this issue?
No, I appreciate the clarification. No further questions.
Board, any questions? Yes, Mr. Church.
So, Mr. Mayo, we're still looking at 560 on the east and the west sides of the entire unit.
That's exactly right. You know, there's a lot of different ways to maximize the value from a section, and a lot of the operators have recognized, I think, from their drilling and experience, that the heel-toe setbacks can move and get really close, and they can get those close and not really encounter the same liability concerns or having to be as precise with that heel-toe as you do with the sides. But a lot of operators try and move their lateral setbacks as close out to the section lines as they can on both sides and just have 1280s developing both units. But several of the operators have realized there's kind of increased flexibility, and given vertical well placement and geologic issues that happen or surface issues, that it makes more sense to set corridors and essentially have a buffer from the section line out where you can drill, and if you drill one there, it's payable on 2560. So OVINTIV has made the decision at this point, at least, that they're not going to expand those lateral setbacks. Instead, they're going to seek creation of those drilling unit boundary well drilling units to capture that resource.
Any other questions? Yes, Mr. Moon.
So these are both held by production, so there's no provision needed as to the timing of the drilling unit boundary well. Is that correct?
Yes, they are both held, but Jordan, do you want to confirm that?
No, that is correct. I don't have the request in front of me, but yes, Mr. Moon, as you're alluding to, normally, at least in the prior one, the 130-17, we did create the requirement that we establish production in each of the existing 1280s, and in this instance, that's already been done.
Yeah, and some of the concerns in the other, you know, I'm aware of other 2560 type orders out there, and some of them have no buffer between the section line drilling unit foot setbacks and the 1280. You know, the 2560 units are anywhere 500 feet off the section line, and the 1280s are anything that's drilled 500 feet and beyond. And given that there was concerns in those matters, I think that the board said we'd like to have kind of tandem completion of all three to make sure that there's no concerns. But because there's a buffer here between the 560 and the 330, there's a 230-foot kind of no-fly zone in each of these sections between the drilling unit boundary well. I don't think that's necessary in this case, and it's certainly not part of the request.
Any other questions? Seeing none, are you done? Or
I'm done with that. I believe we've met the regulatory and statutory requirements, and I'd ask you to approve as requested.
thank you. Division, I'll turn the time over to you.
The division won't call any witnesses today and generally supports the request, particularly considering that this relief has been granted in adjacent lands and upon review of the technical data. Thank you.
Thank you. I know you didn't call any witnesses, but are there any questions for the division from the board? Seeing none, I guess it's back to you, Mr. Mayo.
With that, I would just point out to the board that notice was provided to all interested parties within the drilling unit and outside the setbacks, or outside the drilling unit in offsetting units where the setbacks will be reduced. This is, as has been mentioned several times, request that has been granted, substantively identical request has been granted several times. And this is no new ground, and I think the case is clear here today that this is the appropriate relief, and the request should be granted. On that, I'd submit.
Okay, should we admit these exhibits?
Thank you,
as
yes.
evidence?
It will be easy for this one. I'd just like to move for admission of exhibits A through P, with the caveat that substitute exhibit L rather than exhibit L be submitted.
Division, any concerns?
No objection.
In that case, exhibits A through P, noting substitute exhibit L, are so admitted.
Thank you.
Board, do we need to retire for a discussion, or should we entertain a motion? Then I would entertain a motion.
Okay, I'll make a motion to approve the request for agency action as requested.
Second. Before we vote, any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Mr. Mayo, could you draft the necessary documents?
I'm happy to do that. Thank you, Mr. Chairman.
Thank you, and that concludes our first item.
Give me a couple minutes just to get the next set of clients up and we'll be ready to go.
Sounds great. Let's take 5 minutes, perhaps. Do I need to go off the record for that little break? And we are off the record for those 5. Thank you. We are back on the record. On to item number 2, docket number 2023-035, cause number 470-10. In the matter of the request for agency action of Middle Fork Energy Uinta LLC for an order establishing overlapping special stand-up drilling units for production of oil and gas and associated hydrocarbons from the Mesa Verde Group and the Upper Manco Shale from long lateral horizontal wells. And I would now ask for appearance of counsel.
Thank you, Mr. Chairman. Mitch Mayo of Lear & Lear, PLLC, on behalf of Middle Fork Energy Uinta LLC, the petitioner in this cause.
Thank you, Mr. Chairman. Carter Moore with the Division of Oil, Gas, and Mining. And at this time, I'd like to inform the board that I am representing here today under the Utah Code of Judicial Administration, Section 14807, known as the third-year practice rule, allowing a third-year law student to participate in an evidentiary hearing such as this one. And as long as that's okay with Mr. Mayo and the board, we filed an approval from the division on that as well.
No objection. Excited to have him here.
All right. Welcome, Mr. Moore. We'll try and ask you some challenging questions.
I look forward to it.
Back to you, Mr. Mayo.
Thank you, Mr. Chairman. Again, Mitch Mayo of Lear & Lear with Middle Fork Energy Uinta LLC. With me today testifying will be Allie Schuster, landman for Middle Fork, Ken Babcock, the geosciences manager for Middle Fork, and Rob Zabak, the reservoir manager for Middle Fork. Could I please have the 3 witnesses sworn in at this time, Michelle?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Is that you, Ken?
I do.
Okay, thank you. The resumes of each of these witnesses were submitted collectively as Exhibit A in this cause, and if asked separately, each would verify the contents of the resume as true and correct. Ms. Schuster will be testifying as a fact witness only here today. Mr. Babcock and Zabak have been previously recognized by the board in prior causes as experts in geology and petroleum engineering, respectively, most recently in cause 471-01 in September of last year. Presuming the division has no objections, we'd ask that these 2 witnesses be so recognized again for purposes of this cause.
Division, any concerns?
No objections.
Board? Seeing none? Seeing none, they are recognized as expert witnesses.
Okay, thank you. I'd also like to confirm or note to the board that we recently filed a supplement to Exhibit C, the return receipts of mailings in this cause. And also, I'd like to note that I'm going to be holding off and moving for admission of our exhibits at the end of the case in chief. The request here is, again, a fairly straightforward request, albeit in slightly varied way. Middle Fork is here before you today seeking the establishment of 3 1280 DSUs. These are stand-up overlapping drilling units, overlapping in the sense there are existing 40-acre spacings in place and some 20-acre spacings that will be kept in place. But they're here seeking the establishment of 3 1280 stand-up overlapping drilling units for the production from the Mesa Verde and Upper Mancos groups, as defined in the RAA, via long lateral, more than 1 mile in length horizontal wells, located within Township 8 South, Range 22 East, in the Salt Lake Meridian, Uinta County, Utah. Middle Fork specifically requests to drill up to 4 such wells on each requested drilling unit, subject to the various caveats outlined in the RAA. And Middle Fork will discuss the reason that number, that may seem low to a lot of the board members. There's a reason for that number, and we'll discuss that through the hearing. However, the requested action here today will require the partial vacatur of 4 board orders insofar as they pertain to the lands within and to the extent inconsistent with the requested drilling units here today. Specifically, the board's orders entered in cause numbers 17316, 18709, 187.12, and 475.06 all will need to be partially modified to the extent inconsistent with this ruling, and we'll discuss each of those in Ms. Schuster's testimony. True and correct copies of those 4 orders have been submitted as part of Exhibit B. And I'd like to note this cause is a follow-up to cause number 187.13, which was actually heard in 2019 by this board. In that cause, the board authorized the drilling of 2 pilot long lateral horizontal wells within the west half of Section 14 and Section 23 within the same township for Mesa Verde and Upper Mancos production. A true and correct copy of the 187.13 order was also submitted as part of Petitioner's Exhibit B in this cause. Due to the pandemic and internal business decisions, however, those 2 pilot wells ordered in 2019 were not drilled. Nevertheless, the technical justifications for proposing them is consistent with the justifications to support the RAA here today. The board has jurisdiction over this matter pursuant to Utah Code annotated 40-6-5 sub 3B and 40-6-6 sub 6. Notice was provided to all production interest owners, as will be testified to. The record will reflect notice was also duly published in the Salt Lake Tribune, the Deseret News, and the Uinta Basin Standard and Vernal Express in July. The Division of Oil, Gas, and Mining filed a response on July 10th, expressing non-opposition, presuming that Middle Fork meets its burden here today, and again, we believe we'll do so. No other objections or responses were received in this matter. With that, I'm ready to begin with my first witness. Ms. Schuster, would you please state and spell your name for the record and then also your business address?
Yes, it's Allie Schuster, A-L-Y, Schuster, S-C-H-U-S-T-E-R, and my business address is 1401 Wine Coop Street, Suite 300, Denver, Colorado, 80202.
Thank you. And can you provide the board with Middle Fork's corporate and bonding status?
Yes, Middle Fork is a Delaware limited liability company in good standing with its principal place of business in Denver, Colorado. It's a wholly owned subsidiary of Coda Holdings, LLC. Middle Fork is duly qualified to conduct business in Utah and fully and appropriately bonded with all relevant federal and state Utah agencies.
Okay. And what is the relationship between Coda and Middle Fork?
Coda shares its personnel with Middle Fork.
Okay, thank you. I might have missed that. I apologize. I'm going to show you slowly, what have been submitted in this cause as Exhibit C through G. Exhibit C, D, E, F, and G. Do you recognize these exhibits?
I do.
And were they prepared by you or under your direction or supervision?
Yes.
Okay. Exhibit C. This is the regional locator map. Can you orient the board as to where they are?
Yes, so Exhibit C shows the regional locator map reflecting the general location of our requested DSUs. They're approximately 23 miles southeast of Vernal.
Okay. And for the board's reference, the matter heard earlier is about 4 townships north of this, as another reference point. Exhibit D.
Exhibit D is a zoomed-in plat of the 3 DSUs and surrounding areas. Drilling Unit A includes Section 17 with the east half, the northeast, northwest, the south half of the northwest, and the southwest quarter, as well as all of Section 20. The northwest of Section 17 is excluded from Drilling Unit A because it is included within the Wansitz Valley Unit Agreement and subject to the terms of the governing unit agreement.
Okay.
Drilling Unit B includes Sections 29 all and Section 32, except for the southeast of Section 32. This was excluded from Drilling Unit C because it remains unleased due to a federal title conflict and dispute. And it remains unleased. And Drilling Unit C includes the south half of Section 16, all of Section 21, and Section 28 north half. And the ownership in the oil and gas in all 3 units is entirely federal or state and subject to federal and state leases as outlined in the application.
Okay. So to clarify for the board, there's one of these that's a 1280, and I don't even know if it's 1,280 acres, but that's a standard 1280, and that's Drilling Unit C. Drilling Unit A and B both have slight carve-outs. Drilling Unit A has one because those lines are already committed to a federal unit. And Drilling Unit B, there's a title dispute that just can't be resolved to include at this point in time.
Correct.
Okay, thank you for that. Moving to Exhibit E, can you quickly hit on the working interests?
Yes, Exhibit E shows our working interest. We're 100% working interest owners in Drilling Unit A and Drilling Unit B, and we are majority working interest owner in Drilling Unit C.
Okay. Exhibit F, if I could, and this one, we're going to kind of take some time with, if that's okay. I want to help orient the board and division onto what we're talking about here. This shows, it's labeled historic spacing orders, and that's true, but it also might be misleading. These are the current spacing orders, is that right? Okay. And I guess let's start, if you can help orient on colors, kind of where things are, and we can go through one by one.
Yep. So Order 173-16 is showing section 32 there. It vacated numerous spacing orders applicable to Section 32, among other lands, so as to allow an approximate 40-acre well density for the development and production of gas and associated hydrocarbons from the Wasatch Mesa Verde Formation. However, no stratigraphic definition for subformation was provided in the order, and it is therefore uncertain whether it includes any portion of the subject formations. So to the extent it does, the 173-16 order is requested to be partially vacated in favor of and to the extent inconsistent with Drilling Unit B.
Okay. So the problem with 173-16, or the partial vacation, is the stratigraphic definition, and that is confusing, and it's impossible to tell really whether it covers the same formations
Correct.
here. So to the extent it does,
Yes.
without us deciding that, that's the part to be vacated.
Yes.
Thank you. Next
Okay.
one, Order 18709.
18709 modified the general well location rule so as to allow approximate 20-acre well density for the development and production of gas from the Wasatch Formation and Mesa Verde Group as it relates to portion of subject sections 16, 17, 20, 21, and 29. The formations covered by this order overlap with the subject formations, and consequently, this order is requested to be partially vacated in favor of and to the extent inconsistent with the requested DSUs.
Okay, so slightly different from the 173-16 order. This one has definition, and the formations simply overlap.
Yes.
And so the 18709 order, the request here today is to vacate that to the extent it overlaps with this one. Okay? 18712.
18712 modified the 18709 order to allow the drilling and production of oil, gas, and hydrocarbons from the subject formations from up to 32 wells within all of subject section 16. Consequently, 18712 order is requested to be partially vacated in favor of and to the extent inconsistent with Drilling Unit C.
Okay. And I think the key from that would be, it sounds like that the 18712 order you're discussing modified the 18709 order with
Correct.
the overlapping stratigraphic definition.
Correct.
Okay. The 18713 order.
This authorized Middle Fork to drill the proposed MK wells as pilot long lateral horizontal wells within the west half of sections 14 and 23. The surface is in the northeast in section 15. The approval was conditional upon Middle Fork reporting back to the board no later than 1 year regarding the results obtained and analyzed from the well. And due to the pandemic, as you touched on earlier, and for other internal business reasons, those wells have not been drilled, but the same justifications for their proposal are applicable in the requested DSUs. So that's just shown in blue directly to the east of the proposed units.
Okay. That makes sense. Thank you for that. 47506. This is the last of the orders I'll make you walk through.
Yeah, 47506, similar to 18712, modified the 18709 order to allow drilling and production of oil and hydrocarbons from the subject formation for up to 30 wells in section 29, and consequently 47506 is requested to be partially vacated in favor of and to the extent inconsistent with Drilling Unit B.
Well, so let me try and sum these up. There's two sets of orders then, it sounds like. The 173-16 order has a squishy definition, we're not sure. So to the extent it overlaps with these spaced lands, that's to be vacated. The 18709, 18712, and the 47506, those are all based on the same stratigraphic definition, which does overlap with the drip. Okay, thank you. I'd also like to ask you and just clarify, are these requested DSUs overlapping? And what does that mean?
Yes, so it's important to emphasize that our requested DSUs are overlapping and pertain only to long lateral horizontal well development. Production allocated from the existing wells remains the basis of these existing orders, and correlative rights are protected, the proposed setbacks, as Mr. Zabak will address later.
Okay, thank you. Exhibit G. Can you please tell the board what this is and why this hearing today
Yes,
is
so
implicated?
Exhibit G shows a plat of our required CAs. Our communitization agreements are going to be required for all 3 DSUs due to federal ownership. And Middle Fork, in my experience, is that the board spacing orders are required by the BLM for CA approval.
Okay. Finally, let's talk about notice. I'm going to, again, just refer you to the certificate of service. It's a pleading on file. It was prepared by our offices and submitted in this cause. Are you familiar with that pleading?
I am?
And did you review it before this hearing?
Yes.
Okay. What names appear on that, or to whom did you mail notice?
They're the names of all of the production interest owners and requested DSUs. Also, both state and vernal field offices of the BLM and SITLA, which supervise state oil and gas leases.
Okay. And how did you get the addresses for these parties?
They were compiled by a mix of our internal land records and a search of the county records, as well as BLM and SITLA files.
Okay. I'd also like to note, as mentioned earlier, Exhibit Z, as supplemented, it contains the return receipts for the mailings of the RAA. That was prepared and submitted by our offices. With that, I don't have any further questions for Ms. Schuster, and I'll subject her to cross-examination from the division.
Division?
Thank you, Ms. Schuster. I have one quick question on the little carve-out that we discussed in the southeast portion of Section 32.
Yes.
And proposed drilling unit B. I noticed in Exhibit F, it didn't look like that was carved out in the same way.
Oh.
Is that just a...
That was just an error on my
Okay,
part.
I just wanted to make sure. And
Yes.
then Order 173-16, as discussed, it looks like it does cover that portion, but is there any concern?
No, I don't think there's any concern. I would have to just double check. That might have been an error on my part as well.
Yeah, no worries.
Oh yeah. I'll clarify to the extent that 173.16 does cover that southeast of that section, it wouldn't be subject to the request because it's not part of the lands. So that little corner would be subject to whatever 173.16 was and is as of today, if that helps.
Yes, thank you very much. And then the north section of 28, I see some like hash marks in there. Is that just from it being a proposed drilling unit, or is it subject to a order as well? That's not.
That's just from
reflected.
being a proposed drilling unit.
Wonderful, thank you. Perfect. And then Mr. Doucette has some questions for you. Don't mind.
Yeah, Dustin Doucette for the division. If you could go to Exhibit G, that's fine. Yes, that'll work. So just maybe a follow-up on the unleased track. Can you give a little more history as why that can't be leased and what the probability of it being leased in the future? And is there any, I mean, part of the concern is, is that party going to be harmed? And is there any way that that party can protect themselves if we carve this out?
Yep. So according to the most recent lease SRP page with the BLM, that lease was nominated in 1989. There was an objection received in 1991. And then the objection was due to a title dispute. And it appears that there's a title dispute between the BLM and the, Hill Creek portion of the Uncompadre Reservation. And in 2018, they expired the lease. And then we have not been successful at nominating it again. So due to that title dispute, that lease has not been issued and is not able to be penetrated by wells, which is why it is excluded from our unit. However, relief would be able to be sought by the BLM by imposing a compensatory royalty agreement on us if they felt that they were being drained in that particular section, and we can work with them on that.
So you feel they would be have the ability to protect themselves?
If
in
they
that?
felt they were being adversely drained, yes, I do.
Okay. And just on this exhibit as well, just for the visual portion of it, that unit C is a little offset there. So maybe part of the concern is, can we do, is there going to be some stranded resources being able to develop this horizontally? So specifically the half section to the north until you get into the White River unit, is there plans to develop that area? And part of this may be more Mr. Zabak's testimony, but maybe as far as a land legal discussion, are there plans to develop that area to the north, and that wouldn't be a stranded resource if the board approved this as kind of that offset pattern?
Yes, so one of the reasons that this unit is kind of in an offset setback right there is due to the topography of the area. That was one of the only places we could place a pad. So that's kind of what led to the specific placement. As far as being able to protect the correlative rights of the north half of section 16 right there, we will be working with the BLM on ways to develop that in conjunction with the White River unit and what the best way to do that is going forward. And I think Rob can speak to that a little bit more when he's testifying, but the main reason that it's offset to begin with is just because of the topography out there.
Okay. If you could go to Exhibit F.
Mm-hmm.
So maybe just a clarification on what's meant by vacating as far as these things overlap and are not consistent with one another. So my understanding is these orders have all been Wasatch Mesa Verde orders for vertical development. Is that correct?
Yes.
And so when you're requesting to vacate partially, what are you vacating, I guess? Is the ability to develop in the Mesa Verde, since all these orders did have Wasatch Mesa Verde components to them, is Mesa Verde development vertically still able to happen in these areas, or is that off the table? I guess that's...
I think and Rob might be able to speak to this as well in his testimony, but the goal is that they are vacated to allow for the horizontal development. So they're vacated in that manner, but we're wanting to keep the optionality open of still being able to drill the vertical wells pursuant to these as long as the setbacks are maintained between this application and those.
And I think that probably is a better question for Rob, or a more satisfying answer you'll get from Rob. But I also just wanted to, it kind of dovetails to the question you asked earlier about that southeast protecting itself. I'd like to remind you the setbacks in this one are much bigger than what we see in most of the spacing, and the reason for that primarily is because of that squishiness in what we're talking about here. So there's pretty substantial setbacks that'll be discussed as part of the reservoir testimony.
Yeah, just so I'm clear, for regulatory, clarity and also administrative, how are we going to permit these things in the future? What can we allow? What can't we allow? The current request is for horizontal in Mesa Verde Mancos, Upper Mancos. None of the others allow horizontal development, so if they came in a Mesa Verde, we could not allow a Mesa Verde horizontal. Is that kind of the thought process here under those other?
I'll try and take this. So if someone filed an application for permit tomorrow, citing order 17316 as justification and proposed a long lateral horizontal, you wouldn't be able to, no matter where they located it. if they came in tomorrow and submitted an APD, with cause 47010 as the justification for that long lateral, and it meets that stratigraphic interval, then the division is in a position to approve that. The question I think you're getting at is there a concern with liability between these parties and those parties? And I honestly don't know that that's, I don't think that's something that is necessary to decide when issuing the permit. I think that's what the board hearing's for. And I think this is a discussion we've had a little bit offline. Middle Fork's sensitive to the division's concerns. They're really key, good concerns. How do we practically apply this? And I think to the extent Rob's testimony will explain, hopefully, what those setbacks look like in practice, and how those will do it. And it'll be an iterative process, hopefully, in figuring out how to make the order functional for the division in those close calls.
Well, and I have a follow-up question that may help alleviate some of the concern. As far as ownership, are there differences as stratigraphically, so deep and shallow rights, for example, or is it all consistent, from surface, or at least from the Wasatch through the Mancos? Is that consistent ownership, or are there split ownership rights?
In units, let's see, let me make sure I reference the units correctly here. In units A and B, it's 100% Middle Fork surface to basement on the working interest. For unit C, there is some stratigraphic separation. There are other parties in there, which also shows the majority working interest by Middle Fork, but other operators are in there as well.
Okay, but a horizontal, if this was approved, in Mesa Verde, Upper Mancos would be shared according to this agreement. Anywhere else vertically, it would probably fall under the other orders in place. Is that correct?
That's my understanding of how, and Rob's testimony hopefully will clarify that for us.
Okay, I think that clears it up for me. And hopefully Rob will follow up with some additional info. That's all I had. Thanks.
That's all from the division for Ms. Schuster.
Board, any questions for this witness? Yes, Mr. Church.
So, Ms. Schuster, you've explained why the delay was on the pilot wells with 187.13. So what is the impetus today for Middle Fork coming in and asking for these additional spacing orders without those other wells being drilled at this point? Is there a plan in your drilling schedule that moves these forward ahead of the other ones?
Rob might be able to speak to that a little bit more as well, just being more in line with the planning of newer horizontal wells. But we are looking at putting these in the schedule in the next year or so, and being able to look at this maybe a couple years, just depending on being able to do some of these more risky tests, and having optionality out here is kind of what we're looking to be able to do.
Okay, is there any concern with lease expirations or those
These
kinds
are
of
all
things?
HBP leases.
They're all HBP?
Yes, sir.
Okay, thanks.
Maybe a follow-up that his question made me think was, is Middle Fork abandoning the 187.13 order? I mean, are you switching gears and not going to drill those, or is this just an additional?
These are just an addition too.
Okay, thank you.
Any other questions from the board? Yes.
If you were required to come back to the board and report on those wells, and that didn't happen, do you need to file anything stating why you didn't come back?
It was my understanding, and again, I wasn't part of that or the preparation for this, but it was my understanding that reporting period is triggered after you achieve production. And so I don't think it's 1 year after the order entered, otherwise.
Gotcha. Thank you.
Yep.
Any more questions? Seeing none, back to you, Mr. Mayo.
Thank you. With that, I am done with Ms. Schuster for now, if you wouldn't mind staying close back there. And I'll call my next witness. Mr. Babcock is appearing remotely. If we could get him up on the screen as well. Oh, there he is. Hey, can you hear me okay, Ken?
Yep, I can hear you.
Okay, perfect. Ken, I'm going to have you start off by stating your name and spelling it and stating your business address for the record, please.
Yes, it's Ken Babcock, Ken, and then Babcock. And then business address is 1401 Wynkoop Street, Denver, Colorado, Suite 300, 80202.
Okay. And your current position with Middle Fork, would you please describe that, and especially as it relates to these lands here today?
Yes, I'm the geoscience manager, and I oversee all the development of our acreage here in Utah.
Okay. I'm going to show you what we've submitted as exhibits. Let's see. Exhibits H through K. We've got exhibit H here, I, J, and K. Do you recognize those 4 exhibits?
Yes, I do.
And were they prepared by you or someone under your direction or supervision?
Yes.
Okay. Exhibit H, the type log. Will you quickly tell the board what this demonstrates in this area and kind of educate them as to the stratigraphy here?
Sure, yes. So this type log is taken from one of the units that Ali just referenced in section 20. And on the type log on the left there, you can see it extending from the Mesa Verde down through the Mancos B, which it defined for the stratigraphic definition of the Mesa Verde and Upper Mancos. The Mesa Verde group formations include the Castlegate and Sego sandstones, and the Blackhawk, Tusher, Braid, and Neslin formations. These formations were primarily deposited within a fluvial to marginal marine environment, interfingering with the Mancos Shale, which is a more distal marine facies. The target intervals will be sedimentary units below the top of the Mesa Verde, and will include the uppermost Mancos Shale, which is more marine. Such development will be in close proximity to the hydrocarbon source rocks, which are interbedded with the reservoirs, as opposed to a more migrated play in the overlying Wasatch Formation.
Okay. Thank you for that. And you referenced the Wasatch Formation. You know, the board is fairly accustomed in the basin to hearing about the Wasatch, Castle Peak, Uteland Butte. Where are those just in relation to these formations? Are they shallower, deeper, just so you can kind of give the board a sense?
Yeah. So for instance, a lot of these Green River units are quite a bit shallower that produce oil. So that's going to be shallower upwards towards more like 5,000 feet range, whereas we're looking at kind of 8470 as the top of the Mesa Verde on this type log that we're using to define the unit.
Okay. So the formations they're used to seeing are shallower than the ones you're targeting over here.
Yes, that's correct.
Okay. Exhibit I guess that dovetails right into the targets. You identified on the type log a bunch of information. Are there specific targets Middle Fork is planning to target with this wells in these units?
Yes, you can see on the type log on the left, we have a few potential targets, but the main ones where the arrows are pointing, the blue arrows on the exhibit point to are the Neslin and the Blackhawk formations. And those two formations have been targeted horizontally and offset acreage positions not too far from here.
Okay. And you said targeted horizontally. With horizontal wells, those have been?
Correct.
By Middle Fork or by another operator?
Middle Fork has targeted the Neslin formation as well as QEP or Questar drilled a number of Neslin horizontal wells in the Redwash unit. And then EOG has drilled a couple Blackhawk horizontals previously just south of here.
Okay, perfect. Thank you for that. Geologic cross-section. Can you discuss the formations kind of as they progress across these lands?
Yes. So the formations are continuous across the area. So this is a south to north cross-section running from A to A prime on the base map there, and it's grabbing wells that are through the units that we are proposing. So you can see on the cross section it's flattened on a Castlegate, but you can see the continuous nature of the formations that makes horizontal drilling conditions favorable for successful hydrocarbon recovery.
Perfect. Thank you for that. And finally, Exhibit K, the the fracture orientation. Can you just help the board understand how the fracture orientation in this area matches with and works with both the orientation and the setbacks you've requested?
Yes, yes. So, yeah, the fracture orientation is pretty persistent across the area. So similar to the last hearing, here you can see FMI data from 2 wells that are pointed out on the base map nearby. And on those rose diagrams, you can see that the natural fractures are striking west-northwest to east-southeast at north 70 degrees west, which would be aligning with the maximum horizontal stress. So by doing north-south or stand-up drilling unit orientations, we'd be perpendicularly intersecting the natural fractures.
Okay. And I guess as sum up, in your expert opinion, Mr. Babcock, do the subject formations constitute one common source of supply in this area?
Yes.
And are the subject formations underlying the subject lands continuous such that they favor long lateral horizontal development?
Yes, they do.
Okay. And finally, in your expert opinion, does the fracture orientation favor stand-up drilling orientation, and are the setbacks proposed here protective of correlative rights?
Yes.
Okay. With that, I have no further questions for Mr. Babcock and would subject him to cross.
Thank you, Mr. Babcock. The division's expert would like to ask you a few questions, if you won't mind.
Yeah.
I don't know about expert. I was just curious about your definition of the Mesa Verde. Where you guys put the base of the Mesa Verde? Is it at the top of the Mancos B, or is it somewhere within the Blackhawk?
Yeah, in terms of how you define it, I mean, typically, like a Mesa Verde only well we would drill from where Mesa Verde, or we call that the Tusher, the top of the Mesa Verde, down to like the Sego. And then we typically refer to the Blackhawk, would be where the Blackhawk shows kind of at the base of the Castlegate there, where you start to get more marine shore faces showing up. And then you're kind of from there down to the Mancos B, or more marine shale. That helps.
Oh, it does. Sorry, I've introduced myself. I'm Peter Pinky with the division, but Dustin's helped me out here. Okay, yeah. I was just curious where you guys, because the Mesa Verde's kind of ambiguous towards the base.
Yes.
There. Just kind of curious what you guys would call that.
Yeah. Typically, kind of Sego Castlegate is where we'd consider kind of the base of the Mesa Verde from a production standpoint.
Perfect. Thanks.
That's all the questions the division has for you.
Board, any questions for this witness? Seeing none, back to you, Mr. Mayo.
Thank you. Mr. Babcock, you're done for now. If you wouldn't mind just staying on, you can mute yourself. We may have some follow-up questions for you down the road.
Okay, great.
Thank you. And finally, I would like to call the last witness for Middle Fork here today. Mr. Zabak, could you please, are you ready? I didn't mean to rush. Could you please state your name and spell it for the record, and then also state the business address, if you could.
Name Rob Zabak, R-O-B, Z-A-B-A-C-K. Business address 1401 Wynkoop Street, Suite 300, Denver, Colorado 80202.
Okay. And your current position with Middle Fork is reservoir manager. I'm assuming, does that cover responsibilities over the lands at issue here today?
Yes, it does.
Okay.
Excuse me, can you please turn your mic on?
Sorry. My voice usually carries.
I'm going to walk you through the couple exhibits we've got here for you to discuss, submitted in this cause as exhibits L, M, N, and O. Do you recognize those exhibits?
I do.
And did you prepare those or have someone under your direction or supervision do it?
I did.
Okay. Exhibit L, we'll start off there with the horizontal setback illustration. Can you kind of identify the productive intervals and the number of wells requested and why, if you could?
Yep. So I think everyone's familiar with, you guys see a lot in the Central Basin on the wine rack development. And so really what we're showing here on the right is looking into the formation. And so those dots are going to be horizontal wells. And so you just have a wine rack development where we're currently looking at 2 different benches within that Mesa Verde Mancos group that Peter and Ken were just talking about. And so what we're showing there is we have a handful of offsetting vertical wells. One thing I'd like to point out, in all three of the DSUs we're looking at, you see a lot of wells on Ken's map. The majority of those wells are producing out of the Green River and Wasatch. There's only a handful of wells within those three DSUs that are actually penetrating down into the Mesa Verde, and even less when we get down into the lower Mesa Verde and Blackhawk, which are really where our target horizontal intervals are that we're looking at right now. And so that's where the offset of 300 feet east-west, so that's offsetting a horizontal that is, or a vertical that's completed within that same interval. And I'll go over kind of where that 300 feet comes in. And then we look vertically based on what we see from our microseismic and RTA modeling, which I'll show again on the next slide on the horizontal. We look at kind of 300 feet below those vertical wells to protect correlative rights for all of the existing vertical wells, since they are paid on a different lease basis or unit basis, depending on where it's at, for all of those. So that's to protect the correlative rights of the existing vertical wells. And then if we look at just within the section, so top-down view on the left there, looking at section, again, this is not drawn to scale, in case anybody was wondering. But so we have 2640 between wells and then 660 foot, so honoring the existing setback, offsetting the boundary of the DSUs. The 2640, so unlike a lot of our central basin brethren who have drilled thousands of horizontal wells at this point and have a really good feel for spacing, and they've done some of the down spacing tests, we have 8 wells drilled in the Neslin within the Redwash unit. We just drilled 2 wells and are currently completing them. Those wells are actually 2,000 feet apart, so tighter than what we're currently requesting in the spacing order. The point there is just to make sure we're protecting correlative rights. The expectation would be, as we get better understanding of what we're looking at, doing some spacing tests within the Redwash unit, we would come back to the commission with a plan for maybe tighter development, but we want to have the ability to come in and drill a well or two within these DSUs in the meantime, and so that's kind of where the 2640, it's a very conservative estimate, and you'll kind of see it from the OGIP and the economics that I'll show here in a minute.
Okay.
So jumping on to the next slide on that horizontal drainage expectation. So what you're looking at on the right, I know a lot of numbers there. I guess the focus is, this is RTA, so using RTA analytical model, this basically gives us an estimate. So what I used was one of our existing lower Neslin horizontal wells that's in the Redwash unit, modeled that well, and then model the drainage parameters basically. So your XF, your effective hydraulic fracture half length, what does your drainage look like? And what you see on the bottom right there is my tie to production. So the red is going to be your gas production, and then we actually use a pressure. So match the pressure, and then it puts where the production is there. And so you can see very strong tie to the production with the parameters that I've used. And then jumping over to the left side of the screen here, that's kind of justifying where the setbacks are, or just how conservative I guess the setbacks are. We see roughly a 250 to 300 foot fracture half length. And so that's where being 300 foot off the vertical wells to protect relative rights, that's where we came up with that number. Then after 5 years, you get into kind of a 350 foot. North-south, I've spoken to you guys before, Mesa Verde has very high stress anisotropy, so we don't see a lot of fracture growth between our fracture planes. So each stage we'll see very little. You can see 150 foot drainage after 5 years kind of on that north-south. We see it the same with our development. We're drilling wells 330 feet apart and not seeing any communication between wells on that end. So, and again, on the angle there, I'm showing the north 70-degree west that Ken was discussing earlier from the roads diagram.
Okay, that's a lot of good information, and let me just see if we can circle back and kind of highlight a couple things that are key to this. You're only requesting 4 wells, and the setbacks for those are very large.
Yeah. I mean, when we look at our internal modeling on some of these zones, we're looking at like more like 4 to 8 wells ultimately that we could potentially get, but without any tests at this point. Want to honor conservative nature, basically.
And I guess that makes sense. So this is the most conservative approach that Middle Fork could put forward to kind of start the process.
And it's really to protect correlative rights, and I know Dustin had a question on kind of where our spacing was with the units. So if you want to go, if we just want to jump and try to address that question for the board and the division.
Back to the one that he was asking questions
yeah,
about?
if we just
Okay,
wanna-
I just want to point out before we do that, the heel-toe setbacks are 660, is that
Yep.
right? Okay, so then we'll flip back to this one I believe we were looking at, let's say. Was this questions about the?
Yeah, so
That
if we
corner?
just look, so we have the units on the slide, so you can see, will you go to the one? that has
Drilling
the
unit
numbers?
B, there we go. That's-
All right, so A, B, and C there was kind of the questions on where C's set up. So topographically, you really can't get it north of there just because of the topography of this area would not allow us to do DSUs purely on section lines in several of the areas. But here we also have that White River unit. So we met with the BLM yesterday. So both the White River unit and Wasatch Valley unit are all depth units. And so to drill horizontally through that, we need to work with the BLM on doing some depth severance and then additional work to just discuss how best to allow us to develop this area horizontally. And so that's why these DSUs right now are really staying outside of that while we work with the BLM to figure out what's the most optimal way for us to kind of combine all of this. Because you see, those are the two all depth units that cover these two formations, but we also have several other Green River secondary recovery units that are around this area, east of Wasatch Valley, north of Wasatch Valley, and then actually across that Unit A. And so we are currently in the process of working with them to figure out the optimal way to bring in some of these federal units and able to do this. Where we sit here, this is the most optimal stuff we could put together because that's going to take a little more time. So this would give us time to kind of do those tests I talked about, get an understanding of the rock, the reservoir, production performance, make sure it's consistent with our expectations from our modeling, and then hopefully come to you at some point in the future with a more integrated plan where we've worked with BLM to figure out how they think we can best develop this.
Okay. And it remind the board that section north of Unit C that Dustin had, Mr. Doucette had questions about earlier. Do you have concerns about becoming stranded if this unit is granted here today, or do you believe it's going to be developed, just maybe not by a 1280 well that's...
Yeah, no, I mean, it's in our best interest, as everyone knows, to develop all of this, since we are 100% working interest owner over all of those areas. So that's where I say the discussion with the BLM comes in. We're going to work with them. We know we can, I think 2-mile laterals have kind of been the norm out here, but in North Dakota, we're drilling 3-mile laterals right now as a company. I think there's definitely a potential to look at different options like that where you could have a larger DSU there. But it's really going to be working with the BLM to figure out an optimal development plan out there.
Okay. And it's unified mineral ownership in a lot of these lands, if not all of them, right?
Yeah.
Okay. This is all federal, tribal?
Federal, state, and I don't think, I would have to ask Allie on how much is fee out in this area.
Okay. That makes sense. I'm sorry for asking you a land question. That was my bad. Are we good on that?
Yeah,
Okay.
I think we can,
and just
if
to,
there's more questions, we can address it.
No, the only other question, it kind of ties back into what Mr. Doucette said about that southeast of B that's omitted. He asked how can they be protected. Essentially, any horizontal well drilled down to that would have to land, the last perforation would be no closer than 660 feet to that. Is that right?
Correct.
Okay.
Yeah, so you see from my drainage that I think the BLM would be hard pressed to say that we are draining that area of there. All right, so if we jump on to the next slide, recovery factor, just showing that we have the gas in place to support what we're kind of saying we're going to go out there and do. So this is the total interval, roughly 1,400 feet. I want to thank Ken. Ken put most of these numbers together. So porosity there, you can see the gas saturation, but so you have roughly 800 BCF in place over 1280 DSU. We're talking about the 4 10,000-foot wells, 80 BCF roughly. We risk it on the economic type curve, but our expectation is roughly 2 BCF per 1,000 feet, which is what we saw in our better wells over in Redwash. That would put you at a 10% recovery factor. I would get fired if we ultimately end up with that recovery factor. So that's why I would say we'll be back here discussing kind of what an optimal development looks like going forward.
That makes sense. And Exhibit O. Are these
so
wells economic?
Economic well parameters. You can see well costs. That's our average well cost that we've seen we've only done 2 wells, so I actually expect that to get a little better. There's a risk type curve, so 1.7 BCF per 1,000 versus our kind of internal expectation of 2. That's our working interest NRI average over this area. Oil price just ran $65 flat, $3 gas, 40% rate of return, 1.9 DPI, and a roughly 2-year payout. So definitely something that we can fund. Our big focus on economics has always been profit to investment. So we look at that over anything else, and so 1.9 is very strong.
Okay. In your expert opinion, are these wells as proposed here today economic?
Yes.
Okay. And are 4 wells that are requested here today per drilling unit sufficient or likely insufficient to drain to fully recover the resource under the drilling units?
I think we'll ultimately need more wells, but I think it'll protect the correlative rights as we get a better understanding of what the spacing should look like.
Okay. And finally, in your expert opinion, do you believe the setbacks, especially with the drainage modeling completed, offer sufficient protection for correlative rights and still maximize resource?
Yes.
With that, I'm done with Mr. Zabak, subject to cross.
Division?
Just one question for you, Mr. Zabak. On Exhibit M, you mentioned that it was based on a model of the red wash unit. And it was in the Meslin formation as well, right?
Yep.
How close is the red wash unit, and how much does it reflect what the unit, these 3 units?
So if we look, so the red wash unit is just straight north. So if you go to Unit A, like the White River unit, those words are actually in the red wash unit. And so where those horizontal wells are is roughly like, I think the one I modeled is, well, no, it would be from sea, it's about 7-8 miles. So not too far away, similar to the cross section that Ken showed, where geologic consistency across this area. The Mesa Verde is very consistent across this area. Blackhawk changes a little bit more geologically, but we don't anticipate drilling any Blackhawk wells up in the red wash unit. So.
Excellent, thank you. I believe that's all the questions from the division.
Mr. Board, any questions for this witness? Yes. Church.
So, Mr. Zabek, what is the GOR on the gas here?
So I think of it the other way, I guess. I'd have to do the math to get to, I think of it as oil yield, right? Because it's a gas play. So,
Yeah, it's a gas play. So what kind of associated fluids do you have? with
yeah,
it?
so our oil yield with our Neslin horizontals is 8 to 10 barrels per million. And then our water yield, in our core area, it's about 80 to 100. As we come down here, the Neslin does get a little wetter. Some of the isolated tests we're doing right now in some vertical wells, we're seeing anywhere from 200 to 400 barrel per million. So you're seeing a decent amount more water, which is part of the reason we think we have to go horizontal here versus what we're doing in the red wash field going vertically.
So what's interesting to me is how the drainage relates to the frac half lengths and things like this of gas versus oil, where you've got a gas field. Do you have an expanded drainage area, or is there contribution from the country rock beyond what you frac?
I'm not an expert on the Central Basin stuff, so I can't speak completely to what like OVINTIV had shown in the previous testimony, but we do have a natural fracturing component that definitely drives a little bit there, and then any gas and oil play, just permeability. Relative permeability of gas to oil, right? I would expect a gas well to always drain a little bit differently than an oil well just due to the fluid properties.
So generally it would be more expanded probably than an oil. So setbacks, if we're talking in the gas plays, we're probably going to be wanting to see a greater setback than we see in the oil plays.
Yeah,
Is that
like as you see, we didn't ask to tighten up the 660 at all that's existing, right? So.
Okay, thank you.
Any other questions?
Does Middle Fork operate both White River and Monset Valley?
Yes.
Units? And are you just gonna communitize these 3 areas? You're not gonna try to unitize or anything with the BLM? Are you just going to go off CAs?
I do not know yet.
Okay.
That is, what, sorry, I do not know yet. That's part of what we're trying to discuss. That was, I would say we're in the early innings with the BLM of figuring out what makes the most sense.
Thank you.
Any other questions? Seeing none, back to you, Mr. Mayo.
With that, I think it's probably appropriate, I'm done with my witnesses, to move for admission of exhibits in this cause, specifically exhibits A through O, and exhibit Z as supplemented.
I'd like to move for admission of those exhibits. I guess I should pause.
And any concerns, division?
No opposition from the division.
Board? Seeing none, exhibits A through O and supplement to exhibit Z are so entered.
Thank you. I'll just briefly conclude. This is a slightly different presentation than what you see in the Central Basin all the time, but the statutory and regulatory requirements have been met. This is a unified play in a sense. Middle Fork has a stranglehold on working interest, and most, if not all, of the minerals are shared by institutional parties. This is an area that is, as you've seen, is there's a word I'm looking for. It's gone. I'll save it. All regulatory and statutory requirements have been met here. Notice was provided, and the request should be granted as pled. And on that, I'd submit.
Do we need to step outside before we vote? In that case, I would entertain a motion.
So I would move that we approve this request for agency action.
I'll second.
All those in favor say aye. Aye. I want to backtrack because I did not let you say your piece, and I apologize for that. And please strike that vote. You may say something which changes everything to us, and I apologize deeply. Division, it is over to you.
For drama purposes, I wish I had something to change everything. But no, I think the division is satisfied and was happy that the experts answered our questions. The division is not opposed to this request for agency action.
Okay, I still feel we should probably start over on that process. So
I move once again that we approve this request for agency action.
I will second.
Any last comments from the board? No snide comments about the chairman. Seeing none, all those in favor say aye. Aye. Let the record show that it was unanimous, and again, accept my apologies. And that concludes this matter. It's just shy of noon. Yes, thank you. Mr. Mayo, could you please prepare the order?
I'm happy to do that. Thank you.
Okay. In that case, we truly concludes this matter, and I believe we should break for lunch, so we will go off the record and let's restart. Let's restart at 12:45 because I just have a suspicion the next one might take a bit longer than these last two. So I will see you all at 12:45.
Thank you.
Welcome back, and we are back on the record. Item number 3 today is docket number 2023-027, cause number 132-19, in the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Moon 112 4-3-7-8-7H well in the drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River-Wasatch Formations. Before I ask for appearance of counsel, I believe Mr. Moon needs to make a statement.
Yeah, so I need to disclose that my family has interest in this well. So I propose that I fully participate in the hearing, but not vote.
Is there any objection to that? On anyone's
No
part?
objection from the petitioner.
Yeah, Mr. Moon, just a quick question, just for clarification. And the interest your family has is a leasehold interest, is that correct?
Correct.
No objections?
No objections from the division.
Okay, I will now ask for appearance of counsel.
Thank you, Chairman Borden. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner in this matter, OVINTIV USA, Inc.
Anthony Hunter for Bro Energy LLC.
Elizabeth Harris from the Attorney General's Office for the Division of Oil, Gas, and Mining.
Thank you. I will turn the floor over to you.
Thank you. Chairman Borden, I actually forgot. I've got co-counsel here with me on this matter, and I forgot to introduce her or make her appearance. Ginger Utley, also with Lear & Lear, on behalf of OVINTIV. Ginger was co-counsel with Fred McDonald on this matter from the beginning and will be instrumental when it comes to argument, but will largely be staying back during the presentation of the case in chief.
Thank you for that. So back to you again, Mr. Mayo.
Thank you, Mr. Chairman. As I said, Mitch Mayo, Lear & Lear, on behalf of the petitioner, OVINTIV USA, Inc. in this matter. With me today are two witnesses, Mr. Jordan Lair, Senior Land Negotiator, and Mr. Kendall Brown, the Manager for Uinta Reservoir Engineering. I'd like to ask that both of these witnesses be sworn in again, to the extent they're not.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you for that. Resumes of both of these witnesses have been submitted as part of Petitioner's Exhibit A in this cause. If asked, they would confirm them as true and accurate. Both of these parties were admitted as experts in their respective fields. Excuse me. Mr. Brown was admitted as an expert in his respective field, petroleum reservoir engineering, earlier today. And Mr. Lair has been recognized by this board on multiple occasions as an expert in petroleum land management. Based on presumed stipulation and on an understanding of stipulation with response counsel, I'd ask that they be recognized as experts in their field for this cause.
Mr. Hunter, any objections?
No objections or qualifications, Mr. Borden.
Thank you. Division?
No objections from the division. Thank you.
Any concerns from the board? Seeing none, they are recognized as expert witnesses.
Thank you. Also, I plan to move for the end of my, or to move for admission of my exhibits at the end of the case in chief. To kind of back up a little bit, this is a matter that is in some ways as straightforward and simple as all the force poolings you've seen this year, and in some ways it's incredibly complicated. And so we're gonna go through this in kind of a hybrid of both fashions, if I can. We're gonna proceed as if it's a regular force pooling hearing and kind of present all the evidence that you're used to seeing. But I'd like to remind the board that Bro has lodged a timely response to the REA, and we will be discussing that, and Bro will be cross-examining the witnesses at a later time. So the procedure will probably feel familiar for the first little bit and may kind of go off the rails from what you're used to. Toward the later part of it. Finally, I just want to confirm receipt of the board and point out that we filed a supplement to Exhibit HH on Tuesday. And that's the return receipts. This cause, as I mentioned, involves compulsory pooling. Compulsory pooling of a drilling unit established for Lower Green River-Wasatch production comprised of the entirety of Section 7 and 8, 4 South, 3 West, in the U.S.M. in Duchesne County. That drilling unit was established by board order entered on August 20th, 2021 in cause number 130-07. A true and correct copy of the 130-07 order was submitted as Exhibit B. The 130-07 order expressly provides production allocation from existing well, converts to the two-sectional drilling unit basis, effective as of the first day of the month following first production of the first long lateral horizontal well drilled. In accordance with the 130-07 order and APDs approved by the division, OVINTIV drilled the Moon 7H LLHZ well, with a date of first production of April 8th, 2022. It was the first and only well located within Section 7 and 8. As alleged in the RAA, and as will be established by Mr. Lair's testimony today, several parties were sent the requisite notices of opportunity to participate, but they failed to properly respond within the 30-day time period set by regulation. As such, OVINTIV seeks to compulsory pool them in the Section 7 and 8 DSU and to declare them as non-consenting owners. The notices provided were identical in form to those the board ruled in cause number 132-15 in March, and which order was just entered formally in writing last week, as legally sufficient under the current applicable regulations. However, recognizing the board's preference stated at that March hearing, OVINTIV agreed to prospectively, for any notices that had not been mailed out as of the March board hearing, to prospectively include in such notices the party's specific interest in the drilling units and the specific owner's share of estimated costs included in the AFE. As Mr. Borden noted on the record in that, it would be unfair to require OVINTIV to re-mail those notices and give mineral owners a chance to re-elect. As further alleged in the RAA, Intermountain Resources, Inc. was a record oil and gas owner, but it became defunct. A deed executed by a purported member of its board of directors and its purported vice president assigned 70% of the company's interest to the Utah State Treasurer, State of Utah Unclaimed Property Fund. However, OVINTIV's title counsel has questioned the validity of that deed. In an abundance of caution, the state treasurer, in that capacity, was sent the requisite notice of opportunity to lease or participate, but never timely responded. In addition, pursuant to this board's order on May 16th, a notice of opportunity to participate relating to the Moon 7H well, as required under 649-2-9A, was published in the Uinta Basin Standard for 2 consecutive weeks, but no party has responded to that notice or has otherwise tendered his or her share of costs for the well. Consequently, OVINTIV seeks the compulsory pooling of all such successors of Intermountain Resources not already leased and to declare them as non-consenting owners. The board may recall this is a similar situation as addressed a year ago in cause number 132-05 involving the Wolf well, and in March of this year in cause 132-14 with respect to the LaPrey well and their respective associated drilling units. 2 of the parties to whom the notices of opportunity to participate were sent and who failed to timely respond are James Reeder and Patricia Eubank. They subsequently, Mr. Reeder and Ms. Eubank subsequently leased to Bro Energy, LLC. OVINTIV seeks to pool all 3 parties and declare Bro as a non-consenting owner in the Moon 7H well, including the declaration that it is responsible for paying its lessors the difference between the lease royalty of 20% and the average weighted landowner's royalty during the recoupment period. As the board is aware, Bro timely filed an objection to the RAA in this regard. Finally, some of the fee leases were granted by parties claiming by, through, and under the estates of certain deceased parties, as identified in the RAA, for whom no confirmatory probates have been filed or seen in Utah. As such, although OVINTIV believes it has most of those successors leased located, there's a possibility of some unknown party claiming through those estates who is unleased and not pooled. Consequently, as to those potential owners of interest in those estates, OVINTIV, again, pursuant to this board's order on May 16th, published notice and an opportunity to participate to those parties. No party has responded to that notice on behalf of the unlocatables inheriting from those estates. The proof of publication to all parties claiming through Intermountain Resources and the unknown heirs or successors, was submitted as replacement exhibit BB. As to the non-consenting parties, OVINTIV seeks imposition of a 300% risk compensation award, standard practice before the board, and the terms of a JOA materially the same as those signed by other working interest owners in this drilling unit, and which terms have been previously deemed unjust and reasonable by this board in numerous prior causes. During the recoupment period, the unleased non-consenting owners will be entitled to a 19.588979% cost-free royalty, representing the average weighted fee landowner's royalty, almost 19.6%. That acreage-weighted fee royalty was calculated at the time of spud of the Moon well. As previously noted, Mr. Reeder and Ms. Eubank will receive their full 20% interest, with Bro responsible for payment of the difference between that 20% interest and the average weighted landowner's royalty of 19.6%. The board has jurisdiction over this matter pursuant to Utah Code Ann Section 40-6-6.5 and implementing regulations 649-2-8A and 649-2-9A. A copy of the request was mailed certified mail to the known parties to be pooled and mailed regular mail to all other production interest owners within the drilling unit at their last known address of record, including the Division of Forestry, Fire, and State Lands, who owns mineral interest or manages a mineral interest owned by the Utah Department of Transportation within the subject unit. In addition to the published notice of opportunity to participate in the Uinta Basin Standard previously mentioned, notice of the filing of the REA and this hearing was also published by the board in the Deseret News on June 2nd, Salt Lake Tribune on June 4th, and Uinta Basin Standard on June 7th. On June 12th, Emily Lazama, trustee of the Noble Family Trust, dated June 22nd, 2022, filed a letter objecting to the compulsory pooling of her interest. However, she has since leased to OVINTIV and considers her interest to be voluntarily pooled, and OVINTIV considers her interest to be voluntarily pooled and no longer seeks to pool her at this hearing. Also, on June 12th, 2023, Bro filed its objection to the REA. On June 15th, the division moved for a 1-month continuance of the hearing due to staffing issues and workloads and requested additional time to file a response to OVINTIV's REA and to Bro's objections. The board granted the request by order entered on June 20th. Pursuant to that scheduling order, entered on July 11th, and the subsequent stipulation of the parties, the division filed its response on July 12th, objecting to the REA. Bro filed its reply to the division's response on July 19th, and OVINTIV filed its reply to both Bro's response and the division's response on July 20th. We presume, and based on discussions prior to this, that the legal arguments portion of this hearing will be largely, as much as possible, reserved to the end of the hearing, and the presentation of the factual basis for the underlying pooling request will be heard first. As none of the other alleged remaining non-consenting parties filed a timely response to the REA, pursuant to Admin Code Rule R641-104-150 and R641-108-400, we'd like to move to enter order of default against them. And the board may wish to withhold judgment on that pending the resolution of this matter. Do I just agree or do I have to give anybody else?
So entered.
Thank you. With that, I'm ready to begin with my first witness.
Proceed.
All right, let me. Mr. Lear, will you please state and spell your name and then state your business address for the record, if you could?
Sure. My name is Jordan Lehr, Jordon, last name Lehr. Business record, or business address, I'm sorry, for OVINTIV is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380. My position with OVINTIV is a senior land negotiator with responsibility over this drilling unit, among others.
Okay. And Could you please, for this record, provide OVINTIV's corporate and bonding status?
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with the appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production Incorporated.
Thank you for that. I'm going to show you what, and you've got a lot of exhibits. You're going to be here for a little bit.
Correct.
I'm going to walk you through them kind of in bunches. So the first we're going to look at is exhibits C through E. Do you recognize those exhibits?
I do.
And were they prepared by you or under your direction or supervision?
They were.
Okay. Exhibit C is what we're typically calling the regional locator plat. Can you kind of help locate this unit for the board?
Sure. So the drilling unit is just south of US 40 near the Bridgeland community. It's in Township 4 South, Range 3 West, as shown with the red outline there.
Okay. And Exhibit D.
So Exhibit D is a plot of the well location and the oil and gas ownership tracts. It shows generally the location of the Moon 7H well in sections 7 and 8 as it traverses the north half of the drilling unit. So it's the black line kind of, in the northern part of the drilling unit there. As outlined in the RAA, pursuant to the 130-07 order and an APD approved by the division, the Moon 7H well was spud on December 29th, 2021, and completed as a producing oil well with productive intervals within the U.S.M Butte member of the spaced Lower Green River-Wasatch Formation. The date of first production was April 8th, 2022. It's the first and only well located in the subject section 7 and 8, and as shown, there are 16 different oil and gas tracts in the DSU. Aside from a 50% mineral interest in tracts 9 and 11, which are owned by UDOT and administered by DFFSL. The remaining tracts are all owned in fee.
Okay. And just to clarify, Utah Department of Transportation?
Correct.
DFFSL, Division of Forestry?
Division of Fire Forestry, what is it, State Lands? Sorry.
And it may be the other way around, Forestry, Fire, and State Lands, but we're somewhere in the ballpark. As provided in the compulsory pooling statute, how are you going to treat DFFSL's leasehold?
So we were able to, in the January, which I'll speak to later, but in the January lease bid, we were able to, through a broker, obtain a lease as the high bidder, and we're currently in the process of having that lease assigned to us. So we will seek consent of the lessor to pooling, and we, essentially move to consider that party to be voluntarily pooled.
Okay. Did you include the DFFSL tract in the calculation of acreage-rated royalty?
We did not.
And why not?
Because that is only inclusive of fee interest within the DSU as of the date of spud.
Okay. Perfect. And the remaining tracts, you said 50% of tracts 9 and 11 are owned by UDOT, managed by DFFSL. The remainder of the tracts are owned in fee?
Correct.
Okay. Exhibit E, quickly, working interest breakdown.
So the exactly what it says it is, it's just a breakdown of the working interest for the compulsory pooled DSU, showing that we are the majority lessee / working interest owner in the DSU and the operator of the Moon 7H well. I do need to point out that there are some minute errors in the working interest shown for OVINTIV and the compulsory pooled interest. The working interest for OVINTIV should be 64.4023%, and the total compulsory pooled interest should be 4.351109%. If the board would like, we'll obviously submit a correction to this exhibit reflecting that was an error on my part.
Okay. And you said mistake. Was that simply there's been leasing since this exhibit was prepared, or is it just an oversight in calculation of a lease?
It was a bust and a spreadsheet that was calculating this, so it was simply kind of a manual human error there.
Okay.
Obviously didn't change the material representation here and the ownership. It's just kind of a decimal slip type of an event.
I think for completeness of the record, we would want that correction. Thank you.
Okay, so OVINTIV is clearly the majority working interest owner. Are there any additional lessees, working interest owners that have voluntarily committed?
Yes, so the additional lessees / working interest owners in the DSU were / are WEM Uinta LLC, WEM Uinta 2 LLC, Salt Creek Oil and Gas, Kaiser Francis Oil Company, Broughton Petroleum Incorporated, Uinta Mineral Holdings LLC, JC Petroleum Incorporated, BAP Interest LLC, Paul L. McCullis, Richard Miller, and Derek Miller. One thing to note, as kind of the footnote is trying to display here, is that WEM and WEM 2 assigned all right, title, and interest in the DSU to OVINTIV effective January 1st, 2023, and all of the aforementioned parties have signed JOAs with OVINTIV, the terms of which contractually govern well elections, including the elections made on the Moon 7H well.
Perfect, thank you for that. Now I'm going to move on to a big batch of exhibits, and I'm going to refer you to them. I'm not going to make everyone flip through them individually. This is what's been submitted as Exhibit F. There are a series of exhibits identical to this for different owners. Exhibits F through Q, S through U, and Y through AA. And I'm going to show you a handful of those, see if you generally recognize them, and maybe we can discuss. Let's see. So this is Exhibit Q, so Exhibit F through Q, and then we've got Exhibit. Do you recognize these exhibits that I'm showing you? Oh, that's not it.
Yes, I do.
Okay, and what are these exhibits?
These are the notice of opportunity to participate that were sent to the unleased mineral owners.
Okay, and there are a lot of them.
Correct.
Are you familiar with these exhibits, and did you examine them before the hearing here today?
Yes, I did.
Okay, and are these official business records of OVINTIV?
Yes, they are.
Okay. Each notice, as you said, this letter was part of the election packet that was sent with proposals. What was included with those?
So each of these notices contained not only the proposal letter here that we're seeing on the page, but also an AFE, a plat, which is shown as Exhibit Z here of the location of the well. Obviously, the authority or authorization for expenditure, AFE. I believe that's it.
Perfect. Exhibit F. I think and actually, I think it's probably appropriate to maybe take a 5-minute break and confer with counsel, if that's okay.
That's fine.
Thank you. Okay.
Mr. Chair, we're live in 5, 4, 3, 2, 1.
And we are still on the record.
Okay, perfect. Thank you for that. I really appreciate it. We're entering the phase of the hearing that can get a little dry and repetitive, and in an effort to save time, what we're going to do is we're going to go through one of the letters, discuss the information, and then council of all stipulated division, respond, and board council have stipulated that we'll submit this evidence as an exhibit after the fact to save 25 minutes of
So as a
repetition.
bundled?
We're going to get them as a bundle.
Okay.
So if the board's comfortable with that, we'll proceed.
I think we'd be comfortable as long as they truly are all substantively the same.
It's
as far as the information that was transmitted.
As far as the information that's going to get, that we're looking to get on the record here, these exhibits have been authenticated, they're here, what they say is different. The information we're looking to get, you'll see with Mr. Woodrow Noble, it's just their ownership percentages essentially for a clear understanding of what they own proportionally in the unit.
Okay, and everyone else has agreed this is okay? Mr. Hunter?
The respondent has no objection. The division suggested a supplemental exhibit submitted after the hearing, and Bro supports that.
Yeah, the division's only concern is that the ultimate findings are supported by the evidence in the record. So if we can do that as an exhibit, I think that probably addresses that issue.
I think it makes it much more efficient, so I'm supportive.
Okay. Perfect. With that, we'll proceed, and we'll do one as an example, and then we'll just summarily. Exhibit F, Mr. Lair, I'm going to turn you to that. This is the letter, the election letter that was mailed to Leland Woodrow Noble Jr., is that right?
That's correct.
Okay, and what's important about this for the board's sake?
Well, I mean, I think this is documenting what was sent to an unleased mineral owner in terms of satisfying the definition of a notice of opportunity to participate. It is evidence of what information was contained or provided to that owner at the time. It sort of speaks for itself, I would say.
Okay, and what about Mr. Noble Jr.'s interest in the unit or well?
So as far as this individual's ownership, he's the owner of an unleased 0.021759% interest in tracks 1 through 4, as well as tracks 13 through 16, which equates to a 0.016516% gross working interest in the DSU.
Okay, and can you confirm that he received this letter?
Yes, I can. The receipt was confirmed on November 2nd, 2022, and no response conforming to the regulations was received by OVINTIV.
Okay, one last question if I could. Did you participate in cause 13215 as a witness, or are you familiar with 13215?
I am familiar. I do not believe that I was a witness in that cause.
I don't actually know that there were witnesses in that cause, because I think at the hearing examiner hearing, it got truncated before witnesses were presented, so that was a misleading question.
Mr. Chairman, brief point of order. During that cause, there were witnesses sworn. I believe it was Peter Burns. I don't think that Mr. Lair was sworn in at that time. He may have been present via telepresence, but Mr. Burns was sworn in and provided some context and testimony for the board in that matter.
Noted, thank you.
Yeah, I believe Mr. Hunter's correct on that point.
Perfect, thank you. But you are familiar with the 13215 cause?
I am.
And did you see the order the board entered recently?
I did.
Okay. I guess just a background question, without getting into the meat too much. Did OVINTIV change its letters between this and then? Is this the same letter as was utilized in the?
This is materially the same form of letter that we've utilized up into the point of that hearing where we were made aware that this is not the board's preference for what we send out in terms of notice of opportunity to participate.
Okay. But the letter's substantively the same?
It is, correct.
Okay. And it was sent, correct me if I'm wrong, prior to that March 2023 board hearing?
Correct.
Okay. Were all of these letters sent prior to the March 2023 board hearing?
That's correct.
Okay. With that, testimony on exhibits G through Q, S through U, and let me double check why. S through U, we're going to summarily move for admission of an exhibit after the fact that identifies the working interest they own in which tracks, just to make a followable order.
Make it so.
Thank you. However, there are a couple of those exhibits that I do want to address with you. Exhibit Y, Exhibit Z, and Exhibit AA. And we'll go through those fairly quickly. Exhibit Y is another one of those election letters, the last of those included in exhibits by my count. It's addressed to Intermountain Resources / Utah State Treasurer of Utah Unclaimed Property Fund. Can you discuss a little bit about this since it's a little unique interest compared to the other mineral owners?
Sure. Kind of as you had alluded to at the opening of this is an interest that we've dealt with in prior hearings for the LaPrade and Wolf wells. And due to a deed that's filed of record which attempts to convey 70% of the shareholder interest of the dissolved corporation to the Utah State Treasurer of Unclaimed Property Fund, that is the basis for why this letter was sent out. But as we've noted, we've also, delivered notice through publication as we view that 70% shareholdership to be unlocatable at this time.
So OVINTIV's position, based on title counsel's analysis, is that that deed is of no effect or questionable effect at best.
Correct.
And so it's OVINTIV's position that the shareholders, whoever they may be, of Intermountain Resources, now defunct 20-plus years, are likely entitled to the interest owned by Intermountain Resources.
Correct.
Okay. And you may have said this, but will you repeat for me, if you did, what that 70% share means in terms of percentages in the unit?
Sure. So to get more succinct down to their ownership in this particular drilling unit, Intermountain Resources owned of record an undivided 3.089472% interest in tracks 1 through 4 and 8 through 16. That 70% share equates to a 1.901994% gross working interest in the DSU.
Okay. So almost 2% of the.
Correct.
Okay. Can you confirm receipt that the State Treasurer's Office received the notice of opportunity?
Yes. Receipt was confirmed as of August 15th, 2022.
And did they respond or reach out to lease or participate?
No.
Okay.
We received no response.
Did you also publish notice related to this interest?
We did.
And did you get any sort of response from that published notice?
We did not.
Okay. Moving on to Exhibits Z. You said this was included with the election letters. Will you tell the board what this is quickly?
Sure. This is a surveyed plat showing the well location for the Moon 7H. Kind of goes back to the mineral tract plat as well. It just shows that the well is located in the north half of the DSU.
Okay. And Exhibit AA, which you said was also included with the election letters sent to each of the owners in Exhibits F through Q,
Correct.
et cetera.
So this is the AFE sent with each notice. As Mr. Brown will later testify, the AFE was a fairly close estimate of the actual costs incurred in the drilling of the Moon 7H well.
Okay. Now, again, to kind of go quickly, there's additional parties being pooled here today, and those are unlocatables or potential heirs, successors to interest of estates. Can you go through and name the estates that OVINTIV is seeking to pool here today?
Sure. So those estates would be the following deceased record mineral interest owners, which are Gordon Joseph Van Wagner, Alan Q. Callister, Christopher Dukes, Jeffrey J. Noble, Craig Beal, Jesse Darrell Beal, Darlene Beal Gilbert, Jesse R. Beal, Dwan Taylor DeJournet, Kendra K. Gardner, Denise Hardinger, Kip Lynette Beal, Eric Marvin Beckham, Kirk Hardinger, Harley B. Markham Sr., Lillian May Moley Markham, Ruth McCormick Markham, Hallie B. Markham Jr., Hallie Bruce Collins Markham, Mary A. Eves, Nancy Eves Nicora, Rick Beal, Stephen O. Beal, and Vicki Lynn Beckham. And as we've mentioned, either no Utah probate for the estates have been initiated, or if filed, they are incomplete in that there has been no proper distribution made to the heirs of these devisees or devisees.
And OVINTIV, again, is confident that it has most of these parties tracked down through the generations and leased, but without probates, you can't be certain. Is that right?
Correct. So based on airship affidavits or other inquiries and research done by OVINTIV's lease broker, and except for the parties that, we've identified in the notices that we've just spoken to, to be compulsory pooled and declared as non-consenting owners, OVINTIV believes it or the other voluntarily pooled working interest owners have leased all of their successors. However, without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interest.
Okay. And you said these unlocatables were included, these heirs or successors were included in the published notice, and the proof of that is recorded or filed as Exhibit BB?
That's correct.
Okay. Now let's talk about the DFFSL lease a little bit. You've hit on it briefly, so I just want to make sure we go through the terms. You talked about them owning a 50% interest in tracks 9 and 11, and that it's been leased. Are there any updates? Has it been leased? Has a lease issued?
Yes, so the lease covering the 50% interest in tracks 9 and 11 was issued to Venture Energy LLC as the successful bidder for an oil, gas, and associated hydrocarbons lease in the January 2023 lease offering. The lease has been awarded. It's mineral lease number SLA 00823, which was granted by the state of Utah acting by through DFFSL as lessor. The lease is filed at entry number 566806 with the Duchesne County Clerk as of May 9th, 2023. The lease does provide for a 12.5% royalty. And as of last week, Venture and OVINTIV have submitted a mineral lease assignment to DFFSL to assign the lease to OVINTIV.
Okay, and the 12.5% royalty, was that negotiated or is that statutory?
I do believe that is statutory.
Okay. Utah code requires DFFSL's consent in writing to pooling. Is that right?
That's correct.
Okay. So although you consider them based on this lease to be voluntarily pooled, will you be seeking their consent in writing?
We will. I guess just experientially, or to speak to my experiences with this, we've never had an issue with obtaining that consent as far as pooling the interest on the basis of the drilling unit that's been approved.
Okay. And now, if I may, we'd like to get into some of the meatier stuff here. Exhibits, I'm going to show you what's been submitted as exhibits V, W, X, and also rebuttal exhibits 1 through 4. First, I'm going to show you V, W, X. Let's see. Do you recognize this exhibit and this exhibit? And this exhibit?
I do.
Okay. And exhibits V and W, are those official business records of OVINTIV?
They are.
And exhibit X, it looks like an oil and gas lease that's recorded in the county recorder's office. I guess it's appropriate to ask the board to take administrative notice of that lease. I don't know if you need to see the rest of it.
So noted. It's a little difficult to read. Could you tell us the dates of each of those documents when they were produced?
Absolutely. We'll go through each one in detail if you'd like. And you're talking about the letters, each of those. And
Yes,
we'll try and lay out as much as we can the facts about these.
Okay, thank you.
In fact, let's do that. Let's jump right in.
Perfect.
Exhibit V. I'll go back to that. Exhibit V, you testified earlier, these are election letters that you sent out. And this looks like it's addressed to James C. Reeder. It's fair to say this is the election letter OVINTIV sent to James Reeder.
That's correct.
Okay. And what is the date at the top of this that the letter was sent? Or
it's August 12th, 2022.
Okay. And can you talk about the ownership? James and Patricia, thank you. What they own collectively, individually in this drilling unit.
Sure. Collectively, James Reeder and Patricia Eubank own an undivided interest in tracks 14 through 16, which equate to a total of 1.004314% gross working interest. So approximately each owns a 0.5%.
And the total is 1%.
Correct.
Okay. The notices were sent, as you see, dated August 12th for Reeder. Let me look here for Eubank and have you tell the board what date was this sent?
The same date, or to the extent the letter is dated, the same date of August 12th, 2022.
Okay, so both letters were sent on or around August 12th, 2022 to Miss Eubank and Mr. Reeder.
Correct.
Okay, and do you have confirmed receipt of these letters, and when would that have occurred for each?
We do. Confirmed receipt was received for Mr. Reeder as of August 16th, 2022, and for Mrs. Eubank, August 18th, 2022.
Okay, so the letters were mailed August 12th, and confirmed receipt August 16th by Mr. Reeder and August 18th by Ms. Eubank.
That's correct.
Okay. Now I'd like to refer you to rebuttal exhibits 1 through 4. These were submitted as attachments to the reply called for in the stipulated scheduling order by the parties.
Pardon me, Mr. Chairman.
Yes, Mr. Hunter.
Bro will object to the examination and admission and discussion of exhibits 1 through 4 submitted by OVINTIV, their rebuttal exhibits, on the grounds of authenticity, relevancy, and hearsay within hearsay.
Would you like to respond to that?
Yeah, I mean, a couple of responses. Relevancy is a tough one. These are, I mean, it couldn't be more relevant to the issue raised by Bro, so relevancy is a tough one. The board rules actually explicitly allow the consideration of hearsay. And as far as foundation, that's kind of what the testimony's here for, right? Mr. Lear is going to lay foundation, and if you guys don't believe him, you can disregard these or give them no weight. If you believe him that these are actual emails and OVINTIV didn't create them, then you can give them whatever weight you'd like. But that's the board's job. So that would be my response, is highly relevant because it goes to the heart of the issue raised by Bro. Hearsay is expressly allowed to be considered in these proceedings. And the foundation and experts' credibility can be weighed by this board, absolutely.
May I offer a brief response?
Yes, Mr. Hunter.
On the authenticity issue, if you can just even direct your attention to what's on the board right now, you'll see that it's from a Gmail account, kennygrainer@gmail.com. Mr. Grainer is not here to testify about his email account. Mr. Lair is here to testify about Mr. Grainer's email account. There is no one with personal knowledge present here under oath today that can authenticate the origin, maintenance, and presentation of this record. On relevancy, the relevancy issue is that Bro's objection is that the notice of opportunity to participate was defective the minute Mr. Reeder opened his mail. Anything that comes after that is not relevant to the outcome of the case. When the NOP was sent, it was bad. And so anything that's contained in this email between Mr. Grainer and whoever the other party is, who is also not here to testify about it, is irrelevant to the outcome of the case. And finally, on the hearsay issue, this is hearsay within hearsay. Mr. Lair can testify as to his out-of-court statements for the truth of the matter asserted, but Mr. Lair's statements are not in Exhibits 1, I believe 3, and 4. Yes, 1, 3, and 4. Mr. Lair can testify as to his statements that are contained within Exhibit 2. Exhibit 2 has a different problem. Its record was provided by Ginger Utley. That's the name at the top of that email. And Miss Utley is entered appearance as counsel. She's not a witness. If she'd like to withdraw her entry of appearance and be sworn under oath to authenticate this exhibit, I suppose that's okay. But Mr. Lair can testify as to the contents of what's in the email, but the email itself cannot be admitted as evidence.
I think the board would always like to hear more, even if it may be peripherally pertinent rather than less, so that we can make the most informed judgment possible. I would ask the board to take some of Mr. Hunter's concerns into consideration as we hear any discussion of this, these exhibits, but overruled on your objection. Thank you.
And appreciate that. You know, the truth is, it's going to be just like any other exhibits you see, right? We'll present them, we'll explain what OVINTIV's position is. If someone else weighs in and disagrees, then the board will weigh that. Starting with Exhibit 1, can you please, I guess we'll start from the beginning. Exhibits 1, 2, 3, and 4, we're going to authenticate individually. Okay. Exhibit 1, it appears to be an email string involving Kenny Grainer and Mike Keller, principally. Do you recognize this exhibit?
I do.
And is Kenny Grainer, who is Kenny Grainer? What is his relationship? Actually, is this an official business record of OVINTIV?
It is.
Okay.
I think it's worth pointing out that on the notice that we had gone through, and apologies for not having the exhibit to reference, but Kenny's name is present on the notice, and so this is an email correspondence directly in response to the notice received to the party identified on the letter.
Okay. So the election letter said, contact Kenny Grainer, our agent.
Correct.
Okay. So Kenny Grainer is land agent for OVINTIV.
Correct. As we've discussed many times in various causes, Lone Wolf Energy is our primary land broker within the Uinta Basin, and Kenny Grainer is an independent landman working for Lone Wolf Energy. As you can see on the email, it was addressed to ken@lonewolfenergy.com.
Okay. So not Gmail.
I think this was forwarded through a Gmail, and I do think that they have some redundancy in the way that their email system works, where both emails are actually copied.
Okay. Can you confirm that Kenny Grainer is authorized to use his Gmail or his Lone Wolf Energy email to the extent he feels it's appropriate to do his contract land broker services?
He is.
Okay. Could you please read for the board? It might be easier, and I don't know if you can see it or if you'd like me to share my computer, what that top block says, the first email there at the top that you can see.
Well, that's why I brought my glasses. Mike, it was good talking to you. Jim and Patty each own 6 point. I may need to.
I'll just give you this if you think you can read it from there. But we're plugged in, so you got to scoot closer to me.
Whoops. Much better. Sorry. 6.66334 net under the southeast quarter of Section 8, Township 4 South, Range 3 West. The moon well was spud 12/27/21. Their gross working interest under the well is 0.502157%. Our proposed leasing terms are $2,500 per NMA, meaning net mineral acre, and 20% royalty. Please let me know if you need any more information. Thanks for the call.
Okay. Perfect. That's very helpful. Now, could you please read the date at the top of that, the date that email was sent?
Sure. The date is Wednesday, August 17th, 2022.
Okay. And the email also references, what does it say, Liz and Pat? Jim and Patty. Who do you know those people to be, or who do you assume those people to be?
So that's a reference to James Reeder and Patricia Eubank.
Okay. And at the last phrase in that email from Kenny to Mike says Thanks for the call.
Correct.
Do you understand from talking to Mr. Grainer that Mike Keller reached out to Kenny Grainer to discuss leasing or participation?
That's correct.
Okay. I'd like to remind the board, if you could, the date that those election letters were received by James Reeder and Patricia Eubank.
Sure. So it was received by James Reeder as of August 16th, 2022, and Patricia Eubank on August 18th, 2022.
Okay. And on August 17th, between those two dates, they had retained counsel who had already contacted OVINTIV's agent to begin the process of negotiations.
That's correct.
Okay. Thank you for that. Moving on to well, actually, before I move on, I'm gonna scroll down to the bottom part, and I'm gonna read this and ask you to confirm that you understand it. Save us time. Kenny, good morning. This is an email dated August 22nd at 11:14 from Mike Keller to Kenny Grainer. Kenny, good morning. I forwarded your 17...
Mr. Chairman, I think the court reporter might be having some difficulty hearing Mr.
Sorry. I was bending down to read.
Thank you, Mr. Hunter.
Thank you. Kenny, good morning. I forwarded your 17 Aug 2022 email release terms to my clients for their review. I am writing regarding Lone Wolf Energy Inc.'s attached 12 Aug 2022 letter to my clients sent on behalf of OVINTIV regarding the Moon 1-12 4-3-7-8-7H well proposal. The letter states OVINTIV proposes the drilling and completion, in quotes, of the subject well, but it appears from the records of the Utah DOGM that the well has already been drilled, completed, and is in production. We request the operator provide an updated AFE or actual well cost, as the AFE provided with the letter is several months old, and the well has apparently been completed and is in production. Do you recognize that?
I do.
Is that your understanding of Mr. Grainer's conversation that he had with Mr. Keller?
It is.
Okay. In addition to that, Mr. Keller goes on in that email and says, we also request the operator provide the net amount, share of cost less production, that would be owed by my clients, should they elect to participate. To sum up this string of emails, the day after receiving a notice of opportunity to participate, Mr. Reeder contacted Mike Keller, we can assume, to reach out to OVINTIV through their land agent and begin negotiations.
Mr. Chairman, I'm sorry, I'm going to object to the form of the question at this point.
Could you restate the question in a way that may be less
I
contentious?
can. Would you agree that, would you agree that it's clear to you, in your expert opinion, that the notice of opportunity to participate was successful in accomplishing its goals?
It would appear that the notice of opportunity did functionally perform as it was intended, meaning that the letter was received by the unleased mineral owner and they immediately, it would seem, day after receipt of the notice, contacted Kenny Grainer in accordance with what was on the letter itself.
Okay. Do you see in these emails any objections to the sufficiency of that letter they received?
I do not.
Okay. And did they request additional pieces of information to help them make their decision?
They did.
Okay. Let's move on to Rebuttal Exhibit 2. Before I begin, were the objections, Mr. Hunter, to all 4 exhibits simultaneous, or?
Yeah, it's a slightly different objection to Exhibit 2. The basis is the same with authenticity and relevancy, but the hearsay within hearsay doesn't apply here because Mr. Lair was a party to this conversation. It's just hearsay, which is admissible by rule, but I'll get to the problem with that during later arguments.
So I believe that I'd requested that we would like to see all 4 of these pieces of evidence. And
Yeah.
I assumed
that was
we
my
addressed
understanding
that
of
as
the
a
of the chairman's rule, yes.
Okay.
I was just clarifying, I know there's some intention to set a record, so I want to make sure that I'm helping accomplish everyone's goals here at the same time. Exhibit 2. Can you help, oh gosh. We're gonna share this. Can you please tell the board what this email is, this email string?
Sure. So as we had shown in the prior exhibit, there was a request for updated well costs as of what provided through here August 22nd, 2022. So this is my correspondence directly with Mike Keller to provide those costs. I'll read it verbatim here. Okay. Mike, sorry for the delay as I've been busy on a few other things, but I've managed to pull costs through 8/22/2022, which total $7,644,736.40, including LOE as shown in the breakdown below.
Okay. And did Mike respond to that email?
He did. He did confirm receipt of that.
Do you know what he said? Can you read that into the record, please?
Thank you, Jordan. I appreciate you providing that information.
Okay. So during the election period, the Readers and Eubanks not only reached out to begin negotiating, but is it also fair to say that they requested additional information of OVINTIV?
That's correct.
Is it fair to say that OVINTIV provided that information when requested?
That's correct.
Okay. Moving on to rebuttal exhibit 3. Let me get to there. Objections have been lodged and overruled at this point. Can you please walk us through this correspondence? This email is dated September 27th, 2022.
Correct. So this is continuing correspondence between Kenny Grainer and Mike Keller regarding the lease offer. I'll just read it verbatim as we've been doing thus far. Good morning, Mike. I have received approval for the $3,000 per net mineral acre price for the Reader leases. I am attaching our lease form for your review.
Okay. And to clarify, it says Reader leases. Isn't it true that their full names are James C. Reader and Patricia Reader Eubank?
That's correct.
Okay. So it sounds like this email, according to what you read, OVINTIV capitulated and was offering a higher lease bonus in response to their negotiations on their offer to lease.
We did, and it's fair to say, and I would like to, present this in front of the board is, OVINTIV's desire in all of these situations is to negotiate an agreeable lease with all of these unleased mineral owners to remove the necessity for compulsory pooling. And so that is sort of evidenced in this email as we are attempting to reach agreement with them by agreeing to the bonus that they had requested.
Okay. And the last of the rebuttal exhibits, rebuttal exhibit 4. It looks like this email starts with an email from Kenny Grainer at his Lone Wolf Energy email account, dated October 11th, and it's sent to Mike Keller. Can you read that and the response as well to that for the record, please?
Sure. Hi, Mike. Just a quick follow-up to see where we are in regards to the Reader leases we have been working on for OVINTIV. Mr. Keller then responds, Kenny, the Readers declined the OVINTIV lease and leased to another company.
Okay, and what's the date on that email?
So the original email from Kenny to Mr. Keller was Tuesday, October 11th, 2022, and Mr. Keller's response was Wednesday, October 12th, 2022.
Okay. Now, let's go back through some of these timelines and make sure everyone's clear on exactly what we're talking about. The notices, it's your testimony here today that the notices, the election letters, notice of opportunity to participate, were mailed to the Reader and Eubanks on August 12th of 2022. Is that correct?
Correct.
Okay, so mailed August 12th. And your testimony so far has been that they were received on August 16th and August 18th, respectively.
Correct.
Okay, so 6 days later, roughly, they were received. Under the under the regulations that are applicable here today, when would that 30-day election period expire according to your calculations?
I believe it would have expired on September 15th, 2022, and September 17th, 2022, respectively.
Okay. So August 18th, confirmed receipt. September 15th to 7th. August 16th and 18th, confirmed receipt. September 15th and 17th, election deadline passes.
Correct.
Okay. Your testimony on rebuttal exhibit 1 is that the readers and Eubanks reached out to OVINTIV's named agent on August 17th, the day after receiving the notices.
That's correct.
The day before receiving the Eubank notice.
Correct.
And that discussions continued up to and including September 15th and 17th, the expiration of the notice deadline, or the election deadline.
Correct.
And they continued on to October 12th. So would it be fair to say that moments after, shortly after receiving this terribly confusing and inadequate notice of opportunity to participate or lease, they reached out and began the process with Oil and Gas Council to negotiate participation in this well?
That's correct.
And would it be fair to say that they, in some ways, used OVINTIV's offer to get a better deal with another operator?
I can't speak to what terms they were agreed to, but I could speculate that, you know, if they were willing to lease to a different party, it was probably for a greater amount of consideration.
Based on those facts, receipt, no concerns expressed about the sufficiency, negotiations, and ultimate leasing, regardless of the election's deadline. Can you talk about why OVINTIV kept trying to lease them after the expiration of the election's deadline?
Yeah, as I previously just stated, I mean, our intention and desire is to lease all of the unleased mineral owners, if possible, in these drilling units that we operate. Effectively, as I understand the statute to operate, you know, compulsory pooling an owner does not eliminate their ability to participate in future wells, and so there is an incentive for any party to, you know, lease an interest even after the passage of the 30-day opportunity to participate, on the basis of that future, you know, development and participation therein.
Okay, that makes perfect sense. Just to be clear, did OVINTIV ever waive the 30-day election period with the Readers and Eubanks or Mr. Keller?
We did not, and again, maybe not completely fact-specific here, but in general, in my experience as a landman with OVINTIV, anytime we are subject to another operator's proposal, whether we are an unleased mineral owner or a working interest owner with a leasehold, we will expressly via email or in writing request an extension, and that's fairly common practice back and forth, just because obviously you would want to document the granting of such in writing.
Okay. And there is no evidence that you've seen in OVINTIV's possession that shows a granting of a waiver or extension?
That's correct.
Okay. And to be clear, did OVINTIV receive a signed AFE or letter outlining any objections to the proposed JOA from Reader or Eubank during the 30-day election deadline?
We did not.
Okay. Thank you. Now I'm going to move back, if I can, hopefully back to a little easier presentation, to the Bro lease, Exhibit K. Exhibit X. Do you recognize this lease?
I do.
Okay. And what is this lease, generally speaking?
It's, as it's entitled, a paid-up oil and gas lease granted from James C. Reader to Bro Energy LLC, covering his interest in Section 8, southeast quarter of Township 4 South, Range 3 West.
So this is the lease that we've been talking about?
Correct.
Okay. Were copies ever supplied to OVINTIV by Bro or the Reader Eubanks?
They were not.
Okay. How did OVINTIV obtain this lease?
In response to the email that Kenny received from Mr. Keller, the last email there in October, Kenny then proceeded to check the records with the county clerk, Duchesne County clerk, and found the lease here that we are showing as Exhibit X.
Okay. And just to help kind of address some of the questions the board asked earlier, I'm going to walk you through and point to a couple things that I want you to highlight, dates that are important for the board. I'm going to go down to the egg. Well, let's start off the beginning. That first line, can you tell them what date this lease is dated?
Sure, I'll read it verbatim. The lease agreement is made of the 23rd. Am I reading that correctly?
It's the 23rd.
23rd, yeah. 23rd day of September 2022.
By and between James C. Reeder.
By and between, yeah, correct.
Bro Energy. Okay? So it's entered as of September 23rd.
Correct.
Can you remind the board when the election deadline expired for both parties?
Sure. So again, it was September 15th, 2022, and September 17th, 2022, respectively.
Okay. Now I'd like to point out in the acknowledgement, if we could, there's some more dates. You can see this acknowledgement here at the bottom. Can you see what day that says it was signed, actually signed by Mr. Reeder?
The notary here is indicating the foregoing instrument was acknowledged before me on the 30th day of September 2022 by James C. Reeder.
Okay. And the recording date. Can you tell when that is and read that out?
The recording date appears to be October 11th, 2022.
That's right. And one final provision. There's a paragraph right above the signature line that says lessor, whether one or more, and immediately above that it starts in witness whereof. Can you read that? Do you want me
I
to?
may, yes, thank you. In witness whereof, this lease is executed to be effective as of the first day of production for the Moon 1-12, 4-3-7-8-7H well, API 43-013-54177, or March 1st, 2022, whichever is earlier.
So if I'm not mistaken, it's pretty clear this lease makes clear that the parties there too were aware the Moon well had been drilled.
It would appear so.
Okay. And it was, again, to confirm dates, dated September 23rd, signed September 30th, recorded October 11th, and fully acknowledges that the Moon well has already been drilled.
That's correct.
Okay. I appreciate that. With that, there are no further questions, and I will move on to the JOA. And Mr. Chairman, members of the board, there's not going to be probably many natural breaks for a little bit, so if there's a point you need one, just let us know.
Yeah, then I'd ask the board to give me a note or a high sign if you do need to take a break.
Until then, we will
Don't drink anything.
proceed. Okay, I'd like to show you what's been submitted as Exhibit CC. It's also submitted as Exhibit 1 to the RAA. It's the JOA that OVINTIV is seeking to impose here today through forced pooling. Do you recognize this exhibit?
I do.
And is it an official business record of OVINTIV?
It is.
Okay. Is this JOA good? What form is it? Is it respected in the basin?
Sure. So this is a form utilized. It's a standard industry form supplied by the American Association of Professional Landmen. It's Form 610, as noted at the top of the document here. This is the 1989 version with modifications to address horizontal wells. And as you stated, this is materially the same form sent with all of the mailed notices previously outlined.
JOAs change. But would it be fair to say operators like to have one set of contract obligations to keep track of rather than disparate contract obligations in every unit?
That's correct.
Then it's your testimony that this is substantively similar, identical to JOAs in prior causes.
That's correct.
The terms and conditions in here, including the modifications that you've made, non-consent penalty, et cetera, overhead, would you say these are consistent with JOAs entered into in the basin?
Yes, I would.
Okay. Has OVINTIV signed JOAs with terms like this as an operator?
As an operator, or do you
As
mean
a
as
non-operator?
As a non-operator, yes. And obviously, as an operator, this is the form that we've proposed be used.
So in this drilling unit, obviously, you've signed it.
Correct.
Have you signed this as a non-operator in other drilling units with other operators?
Forms materially the same as this, especially with regard to the non-consent penalty.
Couple quick provisions to get on the record. One, exhibit page 7 of the JOA. This addresses the non-consent penalty, and it's probably incredibly difficult to see on the screen. I apologize for that. This area here, the board has seen numerous times. This addresses the non-consent penalty. Can you describe the modifications you guys made to that and what non-consents you're holding the JOA parties to?
Sure. As you can see there are 2 blanks, the first of which we filled in at 100%, and the second of which we filled at 300%. And as I've just said, it's the same as contained in JOA signed by U.S.M and other parties in this drilling unit, and consistent with what we have signed as a non-operator throughout the basin.
Okay. And what non-consent risk compensation award are you seeking here today?
300%.
Okay. Exhibit C. Can you please tell the board what this is generally?
Sure. So this is the accounting procedure. It's the COPUS form. It's, again, a standard industry form, almost universally utilized. It's similar to other JOAs in the Uinta Basin.
Okay. And with respect to Article 3B, what does it discuss?
That sets out the interest rate to be charged, and that is the prime rate as published in the Wall Street Journal plus 3%, which is fair compensation to encourage timely payment of chargeable costs and expenses.
Okay. And what is the interest and where is it provided for in this JOA? Interest payable on late charges? I mean, where's the overhead charges allowable under this JOA?
So you can see it here on this page, C9, which outlines, as we're discussing the overhead charges, there are, again, 2 blanks. The first one is filled out at $10,900, which is the overhead cost for a drilling well, and then $1,090, which is the overhead cost for a producing well.
Okay. And in your expert opinion, are the terms and conditions of the proposed JOA submitted by OVINTIV fair and reasonable and consistent with those accepted by other working interest owners in this DSU and commonly accepted across the basin?
Yes.
Okay. Moving on to average weighted fee landowner's royalty. Can you please help the board understand what this is and get to what the acreage weighted royalty is to be imposed here?
Sure. So this is...
well, sorry, before you go, did you prepare this?
I did.
Okay, thank you.
So this reflects the calculation of the average weighted fee landowner's royalty for Sections 7 and 8 of the drilling unit as of the data spud of the Moon 7H well.
Okay, and it doesn't include the DFFSL lease, as we said earlier. Is that correct?
That's correct. So
Okay.
this is only as to the fee landowner royalties within the DSU as of the data spud.
And what is that ultimate acreage weighted royalty to be imposed here by the board if they grant the request?
So the average weighted fee royalty is 19.588,979%. And again, as we've said, it does not include UDOT or DFFSL's royalty per statute.
Okay. And remind the board that in Exhibit X, what's the lease royalty under the Reader Eubank lease to Bro?
The lease is provided for a fifth or 20% royalty.
Okay. So there's about a 0.4% difference between the two.
That's correct.
Now, I'd like to refer you to the certificate of service on file in this cause. It's a pleading prepared by us. Are you familiar with that pleading?
I am.
And did you review it prior to this hearing?
I did.
Okay. The people identified on there, who are those parties and how did you determine they're entitled to notice?
Sure, the persons shown on that are all of the production interest owners within Section 7 and 8. The address is derived from a title opinion effective as of March 29th, 2022, as updated by a search of the county records by Lone Wolf and by OVINTIV's internal records.
Okay. I'd also like to just refer you, the board, to Exhibit HH as supplemental. Contains true and correct copies of the return receipts and the certified mailings submitted by our offices this week. With that, I am, done with my direct examination of Mr. Lair, subject to cross-examination by everyone.
All right, thank you. Mr. Hunter, do you have any questions for this witness?
I have a number of them.
Oh,
But
okay.
again, I'll reiterate Mr. Mayo's suggestion that this could be a while, so if we want to take a break, that might be a natural break.
I think we're ready to press on.
Ready to go? All right. Gave you the chance. Mr. Lair, wanted to start with a question for you about the proceeding here. It's hard to tell with the pylon in the way, but were you reading from a document during the early part of your testimony?
That's correct.
And was the purpose of that document to perhaps refresh your recollection about some of the facts and items you're going to testify today?
I would say it's more of a guidance for how we would like to present the exhibits.
All right. And you probably practiced or rehearsed or discussed with counsel what you'd like to present. Is that correct?
Correct.
And you maybe made a document that memorialized those preferences.
Objection, I'm not entirely sure. I think it will take a long time if this is the line of questioning, just to be clear.
Well, I can jump right to the rule.
That would be great, some
Okay.
legal analysis. Thank you.
So, under the board's rules, the board is required to use the Utah Rules of Evidence as guidance. And under the Utah Rules of Evidence, Rule 612, any writing that's used to refresh the recollection of a witness during a proceeding is entitled to be examined by opposing counsel. I can put that up on the screen, but we'll have to take a second to switch cables and stuff so I can get my screen up on here if you want to go through that.
Where are you going with this?
I'd like to take a look at what he was writing and then what he was reading and then cross-examine him on it.
Mitch or Mr. Mayo?
Honestly, to the extent the rule says what Mr. Hunter says, which based on the briefing, I have a hard time just accepting outright. But to the extent it says what he says, it is guidance. The rules of evidence are guidance. And this board has typically taken the position that we want to allow people to come in here and tell us what's going on. And the truth of the matter is, if you want board hearings to get longer and more confusing, make notes that the parties testifying to discoverable to the other party. That will be the surefire way to make these excruciatingly long hearings that are not connected to the record very well. So my objection would be they are guidance. I don't see how that's beneficial. I think there's plenty of questions for Mr. Hunter to ask, and I don't think an hour recess for him to review Mr. Lair's notes makes any sense in this proceeding.
Overruled.
Thank you, Mr. Chairman. Mr. Lair, let's talk for a second about identifying the players. You spoke for a little while about Kenny Grainer. If I remember correctly, you said he was an independent contractor working for Lone Wolf. Is that right?
That's correct.
And Lone Wolf is an agent for OVINTIV. Did I have that right?
That's correct.
All right. You also testified that the exhibits, most pertinently the NOP exhibits, the letters you sent out to the notice of opportunity to participate, those were not prepared by you. That's right, isn't it?
That's correct.
And I'm going to go ahead and assume Mr. Grainer prepared those letters. Do I have that correct?
Various members of the Lone Wolf Energy Incorporated brokerage would have had a hand in preparing them.
Right. So you're not entirely sure that Mr. Grainer prepared all of them, but he may have prepared some of them.
Certainly.
All right. And do you supervise those independent contractors for Lone Wolf Energy personally?
I do oversee the work that our brokers do on behalf of OVINTIV.
Well, that wasn't my question. Do you oversee them personally?
Objection to relevance? I don't understand. Does he need to sit in the office to hire someone as an agent? I'm confused on the line of questioning.
I can respond briefly.
Please do.
Mr. Lair testified that these exhibits were prepared under supervision or control or direction. I want to find out exactly what that means.
So to succinctly answer your question, sir, we do provide the form, we do provide the title, and as is the case with a lot of documents that are forms, a third party that is doing work on behalf of OVINTIV will take the information provided at my direction and include them in the letter.
That was indeed succinct. Thank you. So on that line of questioning, does OVINTIV provide the addresses, or does Lone Wolf or an agent for Lone Wolf provide them itself?
It is a process by which we utilize the last known addresses that would have been supplied through deeds filed of record. Thereafter, Lone Wolf will attempt to make contact with these individuals to confirm addresses. And in the event that they're a party that we may have a current address for, as they are a lessor of ours, we would supply it. So hard to speak to specifics here, but it's, as we've kind of attested to, it's a variety of records that provide that address.
All right. And Mr. Grainer is a part of that, but not the only part of that in preparing these exhibits today.
Correct.
All right. Thank you. I want to step on to identify someone else. You mentioned that a leasehold was acquired prior to the hearing, but after the request for agency action from the state. Is that correct?
Prior to the hearing. So the bid was prior to the hearing. It was nominated prior to the hearing. The lease was granted prior to the hearing, and we're currently in the process of having that lease assigned to us.
And that work was done by a broker, is that right?
Correct.
Was that Lone Wolf Energy?
Venture is an LLC that is, I believe, the registered agent and manager of that LLC is an employee with Lone Wolf Energy.
Do you know the identity of that employee?
His first name is Michael, and I cannot recall his last name right now.
Are you aware of anybody else with a beneficial ownership in Venture LLC?
I am not.
Right. So if I told you that a person named Talbert Trent Sizemore was also a beneficial owner of Venture LLC, do you have any reason to argue with me about that?
I have no knowledge of the ownership of that LLC.
Mr. Hunter, is this line of questioning leading somewhere that's pertinent to the issue we're discussing
I have two more
today?
questions, and you'll see where I'm going, Mr. Chairman.
Okay.
Do you know who owns Lone Wolf Energy?
I do not know the shareholders of Lone Wolf Energy.
Objection to relevance. It doesn't matter who owns them. Lone Wolf is retained as an agent.
I need one more question. You'll see where I'm going.
I'm going to let him have his one more question, so you're overruled.
Understood. Thank you.
Would you have any reason to argue with me if I told you that Talbert Trent Sizemore was also the beneficial owner of Lone Wolf Energy?
I am familiar with Trent Sizemore, so yes, that would not surprise me.
All right. So the common ownership, there's common ownership between Venture and Lone Wolf.
I'm not able to confirm that. As I've just said, I do not know the
Mr. Hunter,
ownership.
your question didn't enlighten me as to where you're going yet, or perhaps the rest
I'll
of the
move
board.
on.
But thank you.
I would like to talk about the fee interest on the date of SPUD. You testified there was a decimal slip that needed some correction?
That's correct.
Okay, and that it wasn't material to the thrust of that exhibit. That's also correct?
That's correct.
All right. there was the series of exhibits. Oh, actually, we discussed that already. I want to talk for a moment. Mr. Mayo asked you about the previous board matter where I think you may have been present in the room but not sworn regarding the notice of opportunity to participate. Is that right?
That's right.
So you're familiar with that testimony and how that matter proceeded?
Yes.
Would you agree with me, or disagree, that when the board expresses its preference about the NOPs, that doesn't bind OVINTIV to anything? Or agree or disagree?
I do not believe that it binds us to anything.
All right. And were you present then for Mr. Burns' testimony as well, when he said to the board that it was OVINTIV's preference to omit the AFE working interest percentage rather than submit something that may be wrong in the future? Do you remember that testimony?
I do.
All right. I'd also like the board to take administrative notice of the testimony during that hearing. Mr. Peter Burns at approximately 1 hour and 5 minutes to 1 hour and 8 minutes in the prior hearing.
So noted.
Thank you, Mr. Chairman. I want to talk about the unique interest of the state treasurer on Exhibit Y for a moment. Mr. Mayo.
Objection. I'm not sure that Mr. Hunter represents them, or is his job to make sure that the pleading is sufficient other than with respect to his responses and his concerns. So if we can tie this back to Bro, then I'm happy to let him vet the entire request.
Mr. Hunter, because so many of your questions don't seem pertinent to me, could you give us maybe a thumbnail sketch of what you're trying to demonstrate here with this disparate
The thrust of my
topics?
question, of course, Mr. Chairman, the thrust of my questions are that Mr. Lair provided inadequate supervision and control, and that there were potentially other interfering influences that interfered with his supervision and control. For example,
we'll stipulate to the fact that they'll make that argument. I mean, I don't think we need to lay foundation for the fact they make that argument.
There's one particular pertinent fact on this exhibit that I wanted to discuss. And it's a direct example of what kinds of errors can creep in.
Okay, so I'm going to give you a little more leeway, but please cut to the
understood, Mr.
chase.
Chairman.
I've got paying work coming up in 5 hours.
And
I've
Mr.
got
Hunter,
I've got to leave at some point.
Exhibit Y. We're going to try to cooperate on technical things here. So Mr. Mayo is going to bring up Exhibit Y for me.
If I can find Y, I will bring up Y.
Thank you, Mr. Mayo. Mr. Lair, would you take a look at the address line on this letter, please? 350 North State Street, Suite 180.
Okay.
And as your earlier testimony, maybe you're not sure where that address comes from, but it comes from a variety of different sources and methods. Is that right?
Yes, sir.
Okay. Mr. Mayo, would you scroll forward to the FedEx envelope?
Forward.
Yeah, it should be just, I think, 2 more down. It's 2 pages down. Oh, sorry, 1 more, 3 pages down. And would you look at the address line on the mailer? That's, looks like 4501 South, 2700 West, Taylorsville.
I do see that.
All right. That's a different address than what's on the letter, isn't it?
Correct.
All right. So do you know for sure, based on that discrepancy, whether or not the Utah Department of Transportation got actual notice?
I do not, but what I would say is that as we've testified to, we do believe that the relevant parties that we were attempting to notice via what we were talking about here are actually unlocatable and were also serviced via publication.
But you're not sure how those addresses got mixed up, are you?
I don't see the relevance here.
Objection. They're for different named people at different addresses. I'm confused.
Sustained.
Thank you.
So are you trying to get that they misdelivered to James Reeder or Patricia Eubank, the people that sort of are tied in with
No,
this whole issue, or are you going off somewhere else?
Mr. Chairman, my objection is to Mr. Lair's testimony, or the thrust of my argument is that Mr. Lair's testimony is that these exhibits were prepared under his supervision or control. And my thrust of my questions is, he lacks the knowledge to state that truthfully, that these exhibits are trustworthy and they were prepared under supervision or control. That's the thrust of my entire examination that people have been having a problem with. And I'm done with it now.
Okay, then we're on to the next topic. Thank you.
Mitch, if you continue to help me out here, Mr. Mayo, with Exhibit Z.
I will. Exhibit Z?
Exhibit Z.
Let me see if I can pull that up for you.
We can take a minute to switch over if this isn't working for you.
Oh, goodness, no, I don't want you to find my mistakes on my computer. Let's see, Exhibit Z.
Hopefully it's just the next one after this one.
It is not,
Oh,
but
okay.
we will find out.
All right. Mr. Lair, will you take a look at Exhibit Z for me and go into the upper left-hand corner? I believe best way to describe it located is in the most northwesterly dashed line up there. Do you see that up there?
I do.
All right, and you've got what looks like the surface location marked with a black dot. Is that correct?
That's correct.
This is the plat for the Moon 7H well. Is that correct?
That's correct.
Is the Moon 7H well the only well that's on that surface location, to your knowledge?
Where the surface hole is being depicted,
correct.
That is the only well right there.
Is there anything nearby?
There are multiple wells drilled off that same pad, which I think is the point you're trying to make.
Correct. And is the Powell well one of those wells?
It is.
All right, thank you. Moving on to Exhibit AA.
Oh, sorry, you want me to?
If I can switch over anytime you want to, Mitch. Yeah, thank you, Mr. Mayo. Can I look at Exhibit A here? Will you read me the print date in the upper left-hand corner?
I can read it for the record. It's December 16th, 2021.
December 16th, 2021, I think. Is that correct, Mr. Laird?
Tony?
Yeah, is that correct, Mr. Laird? December 16th, 2021?
That's correct.
All right, and then if you'll go to the next page, Mr. Mayo. And one page after that. And the total AFE is approximately $6.3 million as of December 16, 2021. Is that correct?
That's correct.
The spud date for this well was late December or early January of 2021 or 2022. Isn't that correct? Somewhere within the last week of December or first week of January timeframe? December 29th, according to the RAA, and I think January 7th, according to the notices that you sent out?
I believe that's correct.
All right. Go to, and just another more general question. When Mr. Grainer and Mr. Keller were speaking, and when you were testifying, you testified that the combined Reader and Eubank leases gross about 1.04% of the total net revenue interest to the DSU?
I believe it was 1.004.
2 zeros, my mistake,
Yes,
thank you.
sir.
And if we can talk briefly about the emails that I objected to. You testified that the Gmail account and the Gmail records were official business records of OVINTIV. Is that correct?
That's correct.
Wait,
So-
no, sorry. I think that was a misunderstanding in the question.
Okay.
I don't think there was any part of him that said.
If you'd like to clarify that, Mr. Mayo, I mean.
I'd like to clarify the question.
Okay,
Yeah,
sure.
Is that all right?
Yeah, you will go right ahead.
What he asked was, did you testify that that Gmail account is your business property, is OVINTIV's business record?
It's clearly not.
I think that's the question, is does OVINTIV own and control that Gmail account?
We do not.
And
Thank
if
you
you
for the
need, thank you, Mr. Mayo, that works out nicely. And if you needed to acquire those Gmails from Mr. Grainer, you only can get them through Mr. Grainer himself. Isn't that correct?
I think as I spoke to earlier and was shown on the email.
Sorry, I'm going to cut you off. Objection.
Mr. Hunter, are you suggesting the emails have been fabricated?
I am not. I am just establishing under Rule 803 that these are not business records of OVINTIV. They are not under their dominion or control, nor can they acquire them, achieve them, or inspect them at their leisure. Nor are they made in the ordinary course of business, because in order to get them back, they have to ask Mr. Grainer for them. They're not OVINTIV's records.
So they're not business records, are they hearsay?
I've already stated that they are, yes, but
Okay.
this establishes they're not a hearsay exception.
I guess I'm not understanding. The objection to these exhibits was lodged multiple times and resolved multiple times. So if the point of this is to establish the objection and how good Bro believes the objection is, I think we can say it's been settled in this matter. If we need to hear the objection again, I'll defer to the board. But I believe we've heard the objections.
Speaking for myself, I did find the emails very helpful to my understanding of the situation, and I think I've also, and I did counsel the board to take them, under consideration that you had some objections to maybe the control of that documentation.
Mr. Chairman, all I need for the clarity of the record on appeal is my 803 business exception objection has been overruled.
Multiple times conceded. Yeah.
Okay.
Thank you,
Proceed.
Mr. Chairman. One of the topics of conversation was that Mr. Reeder had already retained counsel, and that counsel was Mr. Keller. Was that your testimony?
That's correct.
And who is Michael Keller?
I believe he's an attorney with Fabian Vancott, who represented to Kenny that he was employed by Mr. Reeder.
Are you aware of
Suve.
Mr. I'm sorry to cut you off. Did you have anything else?
No.
It's hard to see you behind the pylon. I apologize. And are you aware of Mr. Keller's expertise or previous experience in front of the Board of Oil, Gas, and Mining in the Supreme Court of Utah?
I am not.
So you wouldn't have any reason to argue with me if I told you he's one of the preeminent leaders in the field?
I would not.
And that he has direct experience in appealing board rulings like the Hegarty case to the Supreme Court?
Objection. I'm not sure Mr. Keller's resume is at issue. We
Sustained.
stipulate that he's appeared.
Perhaps we need a little break. I know I do.
I think that would be beneficial.
Maybe a 5-minute break, and we'll go off the record.
Thank you.
Thank you. All right, we are back on the record, and Mr. Hunter, back to you to continue your question of this witness.
Thank you, Mr. Chairman. Want to talk to you for a moment, Mr. Lair, about your discussion with Mr. Keller just in general. He asked you for revenue data, and in your last communication with him that we saw on the screen, you said you'd get back to him. Did you ever get back to him?
I do not recall.
Don't recall. So you can't tell us one way or the other whether you got him the revenue data he asked for or not.
I don't recall.
And let's talk about the other side of the coin here. You also stated that there was no complaints, no concerns expressed to you about the sufficiency of the notice. Is that correct?
That's correct.
So are you aware of anybody else who received concerns about the about the sufficiency of notice?
I do believe that one of the UMI, unleased mineral owners, did respond to the request. I assume that's what you're referring to.
Well, I guess my question is more to the fact that if there was a complaint, it could have gone to somebody else. Isn't that right?
I could speculate, but
you don't know one way or the other.
Just to remind the board, Mr. Lair is here not testifying in his individual capacity. He's here testifying as the land manager for OVINTIV USA Inc. So his testimony is about OVINTIV USA Inc., just to be clear.
correct. So I can say with certainty, I never received any complaints that I'm aware of, and Kenny Grainer never communicated to me any complaints that he would have received.
Thank you, Mr. Lair. Want to continue on to the JOA form. You testified that this was a 1989 form, is that right?
That's correct.
Are you familiar with the 2015 form?
Somewhat.
Are you aware, or would you have any reason to argue with me that Article 7 in the 2015 form is materially the same as the Article 7 in the 1989 form?
I would need to see the two side by side.
So you can't say one way or the other?
Do not have the language in front of me.
All right. And I want to talk again about the royalty table that you referred to. If I could enlist your help again, Mr. Mayo, I believe that was exhibit acreage-weighted royalty. Yes, that's correct.
Yes, let me try and find that.
I believe that's DD.
Perfect, there we go.
You got it. All right, so this is the average weighted royalty table, and you testified on direct that the average weighted royalty must be calculated as of the date the well was spud, or prior to the date it was spud, is that right?
It is all of the fee leases that were entered into prior to the date of spud.
But I believe, and correct me if I'm wrong, I heard you testify on direct that you're aware that the average weighted royalty must be calculated prior to spud of the well. Is that right? Did I get that right?
The calculation is based on those leases that were entered into prior to the date of spud, not that it needs to be calculated prior to the date of spud.
So if there was a lease out there that was not in effect as of the date of spud, that shouldn't be counted in the calculation. Is that right?
That's correct.
All right. Mitch, if you go to DD4, appreciate that. And if you kind of go down the line there to 204, I think it's the fourth one down.
Covey Minerals, Inc.,
The one right above it, I'm sorry.
Roberta F. Noble.
Roberta F. Noble. And would you read me the date of lease number 204 for Roberta F. Noble?
It shows January 27th, 2022.
Now, correct my memory if I'm mistaken, but that's after the date of spud, is it not?
It is. However, I would need to review the lease to make sure that it was not entered into prior to the date of spud. The data is often pulled from our system, and there could be a mix-up at which the effective date or the date that the lease was entered into was prior to the date of spud. So I need to review the accuracy of that.
Sure, okay, and so we probably need to forward to DD6 and look for lease number 109, which is, I think, in the, where did 109 go? Let's see, I've got my highlighted on mine.
I can see it.
Did you find it? You found it before me. Would you go ahead and read me the date on that one?
5/12/2022.
All right, and that's after the date of spud as well.
That's correct.
And 147.
5/3/2022.
All right, so that's 3 leases that were included in there that were not on the date of spud, is that right?
It would appear so.
All right, let me scroll to DD6 there, Mitch, if we could, thank you.
I'm sorry, which one?
DD7, next
Oh,
page,
okay.
last page. I want to focus your attention on Exhibit B, JOA royalties. Do you see that heading there?
I do.
All right, let's talk about Exhibit B, JOA royalties. What does that mean?
These are the JOAs that were entered into by the parties that are shown there prior to the date of spud. And it is the royalty provided in Exhibit B of the applicable JOA with those parties.
Right, and what do you typically find at an Exhibit B of a JOA? What's there physically?
A lease.
Sorry, what?
A copy of a lease form.
Copy of lease form, not an actual lease.
Not an actual lease.
Right, and no actual lessor's name on there?
No, but per regulation, or per the statute, that is something that should be calculated into the average weighted royalty.
But you don't know what the actual lease royalties underlying that are?
It's stipulated in the JOA.
Stipulated for the purposes of the JOA. Does that stipulation bind the state of Utah?
Objection. Are you saying these lease royalty rates aren't correct or are correct? What are you?
I'll rephrase the question.
Yeah, please.
All right. If your understanding of the statute is it requires a lease royalty calculation of leases, isn't that right?
Correct.
And you've stipulated between yourself and Bright Rock about the amount of leases, isn't that correct?
The amount, I'm sorry, I don't follow.
I'll try to rephrase again. The statute requires the calculation to use actual leasehold royalties. Is that your understanding?
That's correct.
And the Bright Rock stipulation doesn't have actual leasehold royalty numbers. Isn't that correct?
Wait, objection. Bright Rock stipulation, is that an issue here? Is there a party here that can address Bright Rock's stipulation that may exist or may not exist?
Sustained. Could you tell me where you're going with this also?
The statute.
I'm sorry I'm so dense. But,
No, not at all,
this
Mr.
is-
Chairman. Not at all, Mr. Chairman. The statute requires a calculation. An important part of OVINTIV's case in chief is to find out what that number is. The statute says you shall calculate it this way. They've already busted that 3 times with the misstated leases, and here again, they're not using actual numbers to calculate the leases. They're using a stipulated or agreed to or made up number.
Objection, Your Honor. This is irrelevant. And honestly, it's at this point, it's becoming insulting to OVINTIV. This is an operator who is a Fortune 500 company, is here before the board on a regular basis, and does not make up Gmails, does not make up stipulations with opposing parties and present them as evidence. Do they make mistakes? Yeah. In a schedule of 7 pages of leases, is there a chance there's a typo? Sure. Can we correct that? Absolutely. But I think it's time to move on from the OVINTIV is lying, they don't actually have authority to represent on behalf of, etc. Broader objection, if you would, for maybe a little less patience.
Sustained.
Thank you.
Let's cut to the heart of your argument and get some real substantive stuff out before us to actually think about, please.
I want to talk finally about the notice of opportunity in general. Back in, if you can testify from memory, the notice of opportunity did not contain an offer with lease terms in it, did it?
If we could bring up the exhibit, I think just reading the highlighted language is probably.
Exhibit V would be where we would go with this, Mr. Mayo, if you could help me.
Exhibit F. I think
Exhibit F would work too. That's fine too.
Exhibit B is the space
V,
order.
sorry, V is in Victor.
Oh, B is
Or F works too. Any one of those is fine. They're all materially the same.
Okay, well, I lost my page number in the flurry. Let's see, 30.
So as it states in the highlighted language.
Sorry, so would you repeat your question now that I
Sure.
took a minute getting that up?
Absolutely, thank you. So is it your understanding of this that the lease offer does not contain any terms that are material to an oil and gas lease.
What I can say is it directs the party who's a recipient of this letter to contact Kenny to discuss the lease terms, being bonus and royalty consideration in exchange for leasing the interest.
But there's no bonus consideration actually offered here.
That's correct.
There's no leasehold royalty actually offered here.
There is no express quantum of the two.
And in your experience as a landman, can you have an oil and gas lease without that expressed quantum?
I can testify to the fact that this has been functionally demonstrated to lead to a party receiving the quantum of bonus and royalty sufficient to enter into a lease.
To your knowledge, does the rule allow for functionally successful?
Objection, it calls for a legal conclusion.
I just asked him if it was to his knowledge, if he knows the rule, if the rule allows it.
I don't have clarity as to that.
All right. No further questions.
If I can quickly ask just a few, and we'll kind of keep this really quick, Mr. Lear. So I'm just going to represent to you, and if you want to go look at it, we can go look at it, but for time, maybe I can just represent to you. When I reviewed the evidence, I found that the request for agency action had a spud date of December 29th, 21. The emails that we've reviewed, I think Exhibit 1 had a spud date of December 27th, 21, and the notices of opportunity that were sent had a spud date of January 27th, 22. And I believe you testified that the spud date was December 29th, 21. I'm just wondering if you can clarify for me which was the spud date.
I would need to review that a bit, but what I would say is I do think that there may be some confusion as to the definition of spud here, as it's potentially the case that surface would have been spud on multiple of these wells, and then the rig would have come back to that specific surface location, potentially at a later date, to finish the drilling of the well.
And to the extent it's appropriate, I mean, we're all trying to get to the truth here. There's clearly some discrepancy that needs explanation. I'd ask the board to take administrative notice of the well file for the Moon well, including the well completion report, which will spell out the spud date that legally we're obligated to follow here.
Sure. And
So
the only,
noted.
oh, I'm sorry, go ahead. And really, my main concern is, would you agree that under the regulation, you're supposed to calculate the average weighted royalty prior to the spud date?
Correct.
Okay, so I'm just curious, could you tell me what date you were using to calculate that average weighted royalty?
I would need to refer back to my spreadsheet where I calculated it.
Okay. Based on, it sounds like there might be a surface spud date versus later drilling. Typically, what do you use as the date? What event?
I would use the earliest spud date possible.
So when they disturb the surface?
Exactly, when the actual rig comes in and spuds the well, as far as, bit turning to the right with any rig of any size.
Okay, and so you're calculating that average weighted royalty as of the day prior to the surface disturbance. Is that accurate?
I believe it would be up into the date of spud.
Okay, to and including. Thank you.
And just to, again, clarify, Mr. Lair's position and what the regulations say are probably different. I think that the spud date in the well completion report would probably be what would govern as far as this, but without confirmation. Just want to clarify.
Okay.
Yeah.
I just want to make clear what we're relying on when we're looking at that average weighted royalty calculation. And then if I'm reading it right, these notices of opportunity did not go out until, I believe, August 12th, 2022. Is that correct?
That's correct.
So are you aware, did OVINTIV lease any of unleased parties in between the spud date and August 12th, 2022?
Off the top of my head, I could not confirm that.
Okay. And I believe I have no further questions. Thank you.
Board, any questions for this witness? Mr. Moon.
So what was your engagement with Reader and Eubank, like pre-drilling? Were they kind of lost in the shuffle till later, or did you have discussions early and then you got ignored and then finally got their attention with the notice of opportunity to participate? Just curious.
Can't speak to it directly because I wasn't involved with the negotiations pre-spud. What I can speak to is this is an area that OVINTIV or Newfield, its predecessor, has leased and operated in for a number of years, and this is obviously, as we've testified to, the first well drilled on these lands. So again, speculation here, but they're a party that has been leased in the past in other areas, and so I was not directly engaged with them until the notices had gone out, and only in the capacity of speaking to their attorney.
Okay, so you're comfortable saying they were engaged with pre-drill at some point, and
I would have to assume that over the years there have been many lease offers made to them on these interests.
Thank you.
Any other questions? Back to you, Mr. Mayo.
Okay, well, sorry. Believe it or not, I think with that, I can let Mr. Lair sit down and relax. Don't go far because we will probably have you back up here. I've got one additional witness and it should be fairly quick. And after that, we'll be in a position to kind of figure out where this goes next. Mr. Brown, welcome back. Would you please state, and no need to spell, your name and your business address for the record, please?
My name is Kendall Brown, and the business address is 4 Waterway Square, Suite 100, The Woodlands, Texas, 77380.
Okay. And your current position is manager of the...
Yes, I'm currently the reservoir engineering manager. I'm responsible for the development of the Uinta Basin.
Okay. I'm going to show you a couple of exhibits that you've... Exhibit EE, up on the screen here. Do you recognize this?
Yes, I do.
And was it prepared by you or under your direction or supervision?
Yes.
Okay. And what does Exhibit EE demonstrate?
Exhibit EE demonstrates the cumulative capital and operating expenses incurred on the Moon 7H through April of 2023.
Okay. And what are those actual total costs that you can tell?
The total cost all together is $8,428,687.78.
Okay. Are you familiar with the AFE expenses that Mr. Lair talked about in detail?
Yes, I am.
Okay. Is the actual cost to date through April, so essentially, if my math's right, essentially a year of operation of the well, roughly?
Yes, just a little bit more than a year.
Okay.
But pretty much right at it, yep.
Are these within reasonable variance from what the AFE estimates would have been?
Yes, I think they are within reasonable error of drilling wells and completing them.
Okay. In your expert opinion, were these costs fair, reasonable, and necessary?
Yes, they are.
Okay. And was the well drilled deemed economically feasible according to you guys at the time of drilling?
It was.
Okay. I'd like to ask you a couple questions about plugging and abandoning costs. OVINTIV in the past has used an estimate of $75,000 per well. Is that still OVINTIV's estimate at this hearing?
Yes, it is.
Okay. And that's based on 100% working interest ownership of the well, the total cost?
That's correct. And in similar testimonies in the past that, again, this well has multiple other wells on its pad, so has some shared costs in reclamation.
Okay. Thank you for that. Moving on to exhibits FF and GG. These are the last two exhibits I've got for you today. Exhibit FF and GG, do you recognize those?
Yes, I do.
And did you prepare those or have someone under your direction or supervision prepare those?
Yes.
Okay. What does FF show?
FF is essentially a bird's eye view of wells that existed at the time of the Moon 7H coming onto production. You can see the wells just to the south of here came online a matter of months before the Moon. Those wells are obviously drilled in a different orientation than the Moon. Upon OVINTIV drilling the Phillip and Alice wells, we collected data to inform our subsurface team on the stress orientation here, necessitating testing the drilling of east wells to increase recovery of the reserves. These wells shown here, the Moon 7H being one of the four, were the first long lateral horizontals that OVINTIV drilled in this area.
And I'm guessing that ties into Exhibit GG. Can you talk about the risks, pre-spud drilling risks?
Yeah, so the drilling risks are fairly consistent, really anywhere in oil and gas. The comment here about vertical wells and depletion, it's not necessarily speaking to existing wells, but when we drill multiple wells off of a single pad, there can be get quite close to each other, which can cause some issues with contamination of mud. The Utland Butte itself has a clay content. Every formation within the Green River has clay content that can cause the hole to collapse on us, having to sidetrack, etc. Fortunately for this particular well, we didn't have any major drilling operation issues or completion operation issues. The thing I would like to testify to, though, in drilling for oil and gas, there's really three key risks to drilling. The first is we have a good idea, but we don't fully know exactly how much the well is cost. The time it takes to drill and complete dictates the cost substantially. The other thing we don't know is we don't know exactly what the well is going to produce when we drill these wells. If we did, it would make my job significantly easier. And then the third thing, which is really the most important risk that we take on as an working interest owner, is really what the price of oil is going to be over the 30-year life of that well. That's the single-handed biggest risk we take on. Significant reductions in oil price, which we don't control, can drastically change the economic outlook of wells.
And the macro oil market is known for wild fluctuations from time to time. Is that right?
Absolutely.
Okay. In your expert opinion, for these reasons and based on the risk anticipated and actually incurred during drilling of this well, given the limited well control nearby for lay-down horizontal wells, do you believe a 300% risk compensation award is justified in this cause?
I do.
Okay. And with that, I will subject Mr. Brown to cross as well.
Thank you. Mr. Hunter, any questions for this witness?
Yes, thank you, Mr. Chairman. Mitch, if I could actually, if you stay on GG, well, maybe we'll just go backwards. That might be easier. Mr. Laird, you just testified that. Oh, sorry, I apologize, Mr. Brown. One-track mind. Mr. Brown, if you've got here two risks listed as pre-spud risks. These are the risks that OVINTIV knew about prior to drilling. Is that what that means?
Yes, so these would be really the execution of the drilling and completion challenges.
Could you generally characterize them as engineering and geological risks? That'd be fair to say?
I would say so, yes.
All right. And you testified about two other risks, and correct me if my notes are wrong here, but one of them was the overall cost burden of the well. Is that the first one?
That is correct.
Okay. And the second one was market fluctuations. That's correct.
Second one I said was the actual production we will get out of the well.
I apologize. Would that be like a marginal well?
Not every well produces the exact same amount. The rock changes substantially, so the amount of oil we would expect to ultimately produce fluctuates significantly from area to area. That's what I'm referring to.
Sure. And that risk isn't listed on here?
That is not listed on this exhibit, correct.
Okay. And neither is the first type of financial risk. That's also not listed on here, is that correct?
That is correct.
All right. How about drilling a dry hole? Was that a big risk with this well?
Depends on how you think of a dry hole. We have high confidence that there is oil and gas in the Uteland Butte member that we targeted here. There is risk that we potentially are unable to drill a 10,000-foot lateral like we seek to do. But the risk of dry hole would be low. I think geology and offsetting wells would support that oil and gas exists in the formation.
Right. And so that kind of overlaps then, doesn't it? The dry hole risk kind of merges into the marginal well risk. Maybe you can't quite complete your geological plan.
I'm not sure I understand what you mean by marginal well.
I'll rephrase the question. You kind of stated during that your entire answer there that the dry hole risk itself was low, but you might not be able to execute your geological plan, your drilling plan, and that might not allow you to recover as much oil as you initially anticipated. Is that fair to say?
That's fair, yes.
And that all kind of blends into one. Is that fair to say?
The cost and the performance, I would say they are somewhat disconnected.
All right. But to summarize, you've got basically two kinds of financial risk and one kind of geological and engineering risk. Is that correct? Is that fair to say?
Yes.
All right. Let's move on to, if we could move backwards one, Mr. Mayo, to the Powell well plat. I'm sorry, the well plat. And I just want to direct your attention, Mr. Brown, to the Powell UT 1-12. It's kind of top towards the middle. Does that well share a pad with the Moon 7H well that's the subject of this?
Objection, relevance. This is a forced pooling for the Moon well. In no way relates to the Powell unless there's a way to connect it through Mr. Hunter's explanation.
Sustained. Could you?
That's the only question I have, and then the relevance of it is that my witness is going to testify that oil prices came from the Powell well.
Okay. I'm going to walk back that sustaining, and you may proceed with that question.
And I believe I've already. I'll wait for an answer then, unless you need me to repeat the question.
The Powell well does share a pad with the Moon well. That's correct.
Thank you. And now mentioning back one to EE, please. All right. So you testified on direct that the well was deemed economically feasible upon drilling. Is that correct?
That is correct.
When did it pay out?
I do not have the exact payout in front of me.
Objection, relevance.
Mr. Hunter, where are you going with this one? Huh?
Mr.
Is this about the 300%?
Not exactly. Mr. The question was raised during Mr. Lair's exhibit that one of the emails said Mr. Keller wanted more information, especially about revenue. And on cross-examination, Mr. Lair admitted that he didn't recall whether or not that financial information ever got out. Whether or not the well paid out was material to Mr. Keller's inquiries during that negotiation. And so whether or not that well has paid out was brought up by OVINTIV.
Okay. I overruled on your objection, but please, we can't stay here till midnight.
I understand, Mr. Chairman.
Thank you.
Mr. Chairman, if I may respond to that.
Yes.
To be clear, he didn't ask when the well paid out. That's something Bro and Mr. Hunter are interested in, but he asked for the production results. Now, to be clear, operators are entitled to keep their production results confidential for a certain period of time under the rules, and this was well within that period of time. So, although, again, it's this idea that OVINTIV is intentionally hiding things from people seeking it out, even according to Mr. Hunter, the preeminent oil and gas attorney in the state, Mike Keller, OVINTIV chooses to obfuscate rather than immediately respond, provide information. And so I'd just like to continue that objection to the tenor of this. If this is aimed at pointing OVINTIV as making things up to try and confuse, I'd like to remind them, the board, that payout is irrelevant to anyone but Bro's potential appeal of this issue to the Supreme Court. It is not relevant to this proceeding in any way. It had no bearing on that, and the reader and Eubanks were not entitled, as a matter of law, to that information at that time.
Thank you for that, and I'm also a little uncomfortable with the tenor of the whole proceeding, but proceed with your questions, but please let's take note of all these concerns.
Mr. Brown, could you tell us at what point, I see you've got a number of months there, starting in December 2021 when we think it was spud and at some date in that range, all the way through, looks like April 2023. Is that correct? Or is that March?
What part are you,
I'm sorry, the last section, the last table there.
It goes
the second to
through
last,
April.
actually. Goes through April. At what point in there did the completion, drilling, and facilities cost exceed the AFE amount of $6.3 million?
Objection. That's a different way of asking when it paid out.
That is not at all the same question. The exceeding the AFE is different than actually paying out.
Okay.
Go ahead and ask your question.
I'll repeat the question if you need me to.
Yeah, that'd be great.
At what point in that chart and on that monthly chart did the costs for completing, drilling, and the facilities cost exceed the estimate in the AFE?
Objection. Relevance. I have no idea why that matters to this proceeding as to whether a force pooling is appropriate.
I can explain the regulation if you'd like me to take a brief break. I was instructed, or the presumption was we'd be saving legal arguments for the end, but I can do it now if you'd like me to.
I think you just have to one sentence tie this to something that's relevant to the hearing. I don't think we need the full legal explanation.
We would all appreciate, how much longer on this line of questioning?
This is the end of my line of questioning.
All right, well, let's, please proceed. I'm going to let him proceed, so.
And just a brief explanation for the board's information. There's a requirement in the regulation that the AFE be made in good faith. It has to be a good faith estimate. If the OVINTIV knew via this chart.
Withdraw my objection. That's perfectly succinct way to tie it to something relevant to the hearing, so I appreciate that. Thank you.
Okay.
I can repeat the question again for you, Mr. Brown.
No, I've got the question.
Okay.
To answer your question, though, I don't know the exact month without summing up the numbers, which I currently have not done that to figure out the answer to your question. So a short way of saying I at this point in time, don't know the answer.
But if someone did take your numbers and sum them up, you would say that's a reliable way to determine at what point the AFE was exceeded by the actual costs?
That's fair.
Thank you. No further questions.
Division?
The division has no questions for this witness. Thank you.
Board? Yes.
Just one question on the original AFE. What is the contingency number that you use on your original AFE?
I do not know off the top of my head the contingency of the AFEs. I would have to have a conversation with our drilling and completions team to get that number.
So there's no consistent percentage. It could vary.
There could be a consistent percentage. I do not know what that percentage is.
Thank you.
Any other questions for this witness?
Yeah, I do. I've got two things. Okay, so would it be surprising to you that, if you compute the difference that you're talking about between the AFE and the actuals, it was 10.25%? Is that a surprising thing in the oil and gas business?
That is.
I'm sorry, Mr. Walker, are you taking the actual cost to date?
Well, the actual, okay.
Because those include a year of operation costs in
Okay.
addition to the AFE,
Well,
if
his
that's
question
confusing.
was correct.
Oh, sorry, maybe I'm misunderstanding. I thought,
Okay, I saw a number of 8.4 million and the AFE was 7.6 million. That was 10.25% difference.
So
if you notice, and let me just clarify before you answer, at the bottom of that table, at the bottom, the line says CapEx and OpEx. So it's capital
Okay, so
expenditures
you got some
and
OpEx in
operating
there.
expenditures.
that's
Oh,
correct.
okay.
The total CapEx listed is $7,054,000. That is the CapEx portion of it.
Okay.
And the AFE, I believe, was for 6.3 million. So it is within roughly 10% error,
Okay.
which, to answer your question, is actually closer than most wells would get to the estimate cost.
Okay. All right. So, and I can't read that table, nor can I hear. Are royalties built into that long column there as far as your that payout?
These are
question?
only expenses and capital, which a royalty owner would pay neither of those.
Mhm. Okay. Okay, thank you.
Any other questions? Seeing none, back to you, Mr. Mayo.
Thank you so much. That is the conclusion of our presentation of our case in chief. I believe it's appropriate to move for admission of our exhibits at this point in time, but it sounds as though Mr. Hunter has a full case to present, so if the board has a different understanding, I'm happy to.
Okay. We'll reserve the admission of those till after we hear everything, I guess.
Thank you. Then for now, I'm good, and turn the time over to, I guess, Division or Mr. Hunter for presentation.
Okay, thank you. I believe we will go to you, Mr. Hunter.
Thank you, Mr. Chairman. I'd like to call my first witness. I'll go ahead and skip the opening statement.
And who is your first witness?
I'm calling up Nate. There was a little bit of finger pointing back here.
Sorry, I thought you were.
The plan was for Mr. Wixom to come up, and then maybe that might change.
This pylon is really difficult.
It really is.
isn't it?
It really is a detriment. All right, Mr. Wixom, I'd like to have you sworn in by the court reporter.
Sir, do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, Mr. Wixom, would you please introduce yourself to the board and give your address for the record?
Nathan Wixom. Can you hear me?
Nope.
Oh, here we go. Nathan Wixom, 4834 South, Highland Drive, Suite 200, Salt Lake City, Utah, 84117.
Thank you. Have you been a witness before the board before?
Yes.
Were you an expert witness at that time?
No.
All right, well, you should probably go ahead and start with your experience in education. Would you tell me where you went to school?
Here in the University of Utah.
All right, and did you get a degree from the university?
Yes. Major in math and a minor in computer science.
All right, and after you graduated, did you go find yourself a job?
It was actually during.
Tell me about that job.
I worked for a market research firm that did high-end analytics for large corporations, and I helped integrate interactive decision tools and help optimize and help these basically take large data sets, complex issues, and simplify them in a way that an executive can make informed decisions and based on forecasts and things like that.
Mr. Chairman, the only matter that we were able to conclusively resolve before this hearing was that we would withhold our objection to Mr. Wixom's expert qualifications if it sped things up. And I feel as though we're now going to qualify Mr. Wixom as an expert, which means I may just re-invoke my right to object to his expertise. So if they'd like him as an expert, I say they just assume he is one, ask for permission, I will stipulate, and we'll move on.
Mr. Chairman, allow me to do a brief proffer. And that way, we'll just get it out in the record so it's built so that if there is a record on appeal, we got it. It'll take about 2 seconds.
Stipulation withdrawn. Thank you.
Okay, go ahead.
Okay.
Mr. Wixom's resume is part of the record. If he is stipulated, admitted as an expert, there's no reason for a proffer. If you would like to proffer, I will voir dire him.
I'll accept Mr. Mayo's stipulation then.
So.
All right, we'll accept Mr. Mayo's stipulation.
Stipulation agreed to. Huh?
All right, Mr. Wixom, then I'd like to ask you about your experience analyzing the information here today. Were you able to take a look at the actual costs? Mr. Chairman, I'm going to need to beg a brief recess because I don't think Mitch has my exhibits. I need to go through my exhibits. We'll need to get the technical side switched over so I can actually display my laptop on the screen.
Couple minutes would be great.
Couple minutes.
Okay, that seems reasonable. Huh? All right, we are still on the record. Before we turn it back to you, Mr. Hunter, I think some of us up here on the board, and I don't know, perhaps the division also, we also want to know what sort of expert witness are we agreeing to here? Is this, what's discipline, computer science?
Mr. May and I had a brief conversation on that record, and what we've agreed to is that Mr. Wixom is an expert in the field of petroleum land management.
Are there any concerns on your part?
I mean, you know, the truth of the matter is, in my practice experience before this board, the rulings made today are pretty consistent with the way they rule, right? They want to hear from people, and they want to consider their opinions. Now, a lot of efforts have been made today, despite what this hearing looks like, to try and keep this hearing shorter, cleaner, more concise, and to the point. And so, you know, OVINTIV obviously would like to test the expertise of Mr. Wixom a little bit because he has never been admitted, and I think it's appropriate for the division to object to his expertise or voir dire him. They didn't stipulate, as far as I know, to his admission as an expert. It's appropriate for the board to voir dire him if they'd like. But we were asked repeatedly to try and find ways to truncate this hearing, and we are doing everything in our power to try and truncate this hearing. And honestly, although Mr. Wixom may not be an expert in my opinion, this board is going to listen to his testimony, and ultimately it's going to be down to the board to decide whether Mr. Wixom or Mr. Lair has a better idea of OVINTIV's wells.
Thank you. And division?
The division has no objection to Mr. Wixom testifying. I think there may be questions as to the evidence that is presented in the testimony, but I think we can look at that as it goes. The division has no objection to him testifying.
Okay. And I think the board would appreciate just a very thumbnail sketch of your experience as a landman then. Don't need to know about your broader life experience. And over to you, Mr. Hunter.
Mr. Wixom, would you care to answer Mr. Chairman's question?
Certainly, Mr. Chairman. For the last, I guess, 18 years experience in petroleum landman and with International Petroleum, and also as a contract consultant for Pro Energy in negotiating oil and gas leases, in acquiring and divesting assets, and seeking out opportunities to lease and find and help those people be able to be leased.
Thank you.
All right. Mr. Wixom, I'd like to turn your attention to the board here and the screen, actually, and look at what I've marked as Bro Exhibit 4. Do you recognize that?
Yes.
What is it?
It is, it's a financial timeline that has a lot of elements that I tried to simplify it and make it so that...
Objection, foundation?
I'm laying the foundation currently.
Well, let's let him proceed.
Instead of 4 pages, I just used 1 page. And so there's a lot of data, but hopefully we can explain what it means.
And you said you're trying to organize and synthesize a lot of data. Did you look at that data personally?
Yes.
And when you were organizing and synthesizing, did you apply your landman reliable principles and methods to that organization?
Absolutely.
And this exhibit was created by yourself, is that correct?
Yes.
All right. Let's move on to actually talk about it then. I want to start with along the bottom there, you've got something marked as cum BBLS. What is that?
The cumulative barrels, according to the DOGM's website, so I pulled publicly available data to populate that bottom row so you could see how many barrels were produced for each month. And then it's the aggregate, so as time goes on, it keeps getting bigger.
And where does that start and where does that end?
So the production data was available April 2022 all the way to March 2023.
Now you say the production data was available starting in April, but is that when the production data was reported to DOGM?
No, it was reported on September 15th, the
And-
first 4 months of production.
All right, so that would be April, May, June, and July were reported on September 15th, 2022.
Yes.
Were you here for the testimony of Mr. Lair?
Uh-huh.
Do you recall him saying that the expiration date of the NOP to Mr. Reeder was September 15th, 2022?
Yes.
All right, let's move on to the green bars. Can you describe what the green bars are?
Okay, so the green bars, that is my calculation for what the revenue would be less the landowner royalties, and the given royalty from Exhibit EE, average weighted royalty. So you'd have to subtract out that and then multiplied by the cost per barrel. So the barrels multiplied by the cost per barrel that month, and I got that from an adjacent well that International Petroleum's in the Powell well on the same well pad. So it should be substantially similar to the well.
Objection. This is for information for a unit that isn't even at issue today and should be substantially similar.
Where are we going with this one?
This one is, we're going to the actual revenue realized by OVINTIV, and that's part of our argument about payout.
You know, if I can vet a couple questions on this, it might help the board understand whether this exhibit really helps anything. I mean, if this is all taken from publicly available information and estimations of OVINTIV's oil and gas price contracts or their transportation costs or their marketing costs or whatever it is that may or may not be included in this, then I think it makes sense to spend time discussing it. If not, if it's just publicly available data and the best projection that he could come up with, then I think we see it as illustrative and we probably can move on. So I hate to interrupt, but
If I could respond briefly, the green bar is the revenue, the blue bar is the costs. The costs come directly from OVINTIV's own exhibit. And I'm done talking about the green bars at the moment, so.
Okay, let's punch
Okay,
forward
let's
and
go.
get to the
Mr. Wixom, would you tell me about the blue bar?
punchline.
That is from Exhibit EE, all the costs that Mr. Brown testified to. And so I just put it in a table and populated it with all the costs that were on Exhibit EE.
To be clear, those both include the CapEx and the OpEx, is that right?
Correct.
All right. And so let's talk about that orange call-out, well payout.
That is when a well reaches, when it exceeds the amount you paid for the well, that's the payout or the break even, and it's a significant thing in the oil and gas business.
Why is it significant?
Because there are contracts that occur on occasion to have before payout interest, after payout interest. And so as a landman, you need to keep track of that. So it's a significant thing, and once you reach payout, you're glad because you didn't lose your money on the well.
So as a landman, it's
There's no risk.
Oh, I apologize for interrupting you.
No, you're fine.
Go ahead and say that last part again.
Once you make your money back, you have no risk.
Thank you. I apologize for interrupting you. Now, you just said a second ago that as a landman, it's important to know when a well reaches payout. Did you happen to look at OVINTIV Rebuttal Exhibit 5?
Yes.
And on that, did you see a reference to after payout and before payout as one of the requirements in those boxes?
Yes.
All right. Is it important for a landman to know the status of after payout and before payout of his well?
Yes.
Were you present for Mr. Lair's testimony?
Yes.
Did he answer the question whether it paid out or not?
No.
Thank you. Let's move on to the red line, the red dotted line across there. Well, what's that signify?
I just titled it.
Objection. I think at this point, I have to sustain the objection. We've now gone through seeing why this information is important to Bro. I think the truth is what we're looking at now is a regurgitation of the well costs submitted by OVINTIV with Bro's testimony about estimations. I think the truth of the matter is there is no evidentiary value here. If this is considered an illustrative exhibit, I will withdraw my request. But if this is an evidentiary exhibit, we have to establish what pieces of information went into this. And I still haven't heard anything sufficient about, other than we got this information from a well nearby that should be similar, and every landman knows this information, both of which are really good pieces. But is this OVINTIV's actual revenue information? Does he know OVINTIV's oil purchase contracts and agreements? Does he have any idea whether transportation and taxes are included in this? And so I don't want to spend 20 minutes going over something that is likely an incorrect version of the actual costs submitted by the operator.
Is this for illustrative purposes only? Is
Just
this
to be clear.
This is an analog, not a complete, it's not.
Just to be clear, Mr. Mayo may have only heard about the Powell Wells oil prices, which is our proprietary records of IPLC. Mr. Wixom already testified that the barrel amounts and the production figures were from DOGM's publicly available information, and that the blue bars are based on OVINTIV's own exhibits. Exhibit EE, it's right there at the bottom. So that's not speculation. That's either publicly available data or OVINTIV's own information. If the board wants to consider the green bars as illustrative only, that's fine. But the rest of that is based on publicly available or evidence that OVINTIV has submitted.
So it would be reasonable for the board to view the green bars as illustrative.
That is correct.
Objection withdrawn.
Thank you. Mr. Wixom, I believe my last question I asked you was, would you explain the red dashed line?
That is the AFE costs that they received on, or that they printed off on December 16th, 2021.
And let's draw your attention to the May 2022 column in that blue bar.
Yes.
What's the number in the white box there, if you can read that for me?
6,810,455.
All right. Now, did we review those numbers a little later on?
Yeah.
And is the number there 6.8 million, or is it something a little bit lower?
Oh, you mean the AFE when it's just the AFE part?
Yeah.
Yeah, it's 6.5.
Right. And the reason for that was the LOE costs were included in this bar, but they're not traditionally included in an AFE situation.
Correct.
Okay.
6.5.
6.5. But it didn't change the material depiction of the chart that in May 2022, AFE costs exceeded the AFE estimate.
Yes.
And would you remind the board when the notices were sent out?
August 12th.
Of?
2022.
All right. That's about 4 months later. Is that right?
Yes.
Thank you. I'm going to turn your attention to this letter, and we'll put that over here on the screen. All right, I'm showing you what's been marked as Bro Exhibit 8, and would you identify this, please?
This is Bro Energy's election to participate in the Moon 7H well.
And what's the date on that?
May 18th, 2023.
And when, in relationship and in significance to this well, why is it May 18th, 2023?
It was the date that we sent it.
And did Bro receive notice of this hearing matter shortly before that date?
Oh yeah. If you read below, it says May 15th we received, and then a few days later we send our election to participate.
So there in the next paragraph, it says that you intend to participate in the well and prepared to send a check immediately for $80,000. Did I read that correctly?
That's correct.
All right. And there's a table down here. I'd like you to talk about that table for a second and why it's important.
So basically on the AFE, it was $6.3 million. And so when you receive this offer to participate, a landowner might think that what is due to them, it says other interests, and it shows 45.33% to the readers. And so you could assume that you're liable for up to $2.8 million, which would intimidate someone to sign.
Just to clarify that, you're saying that the range of possible interests on the JOA that was enclosed was up to perhaps 45.33%.
Yeah.
And
so if you didn't have any knowledge of your own interests, 1% is only 62,000. So that's more doable for.
Objection. By the time of this letter, the reader in Eubanks had heard out their exact percentage from OVINTIV, from his agent and from their landman, more than a year in advance of this. So the theoretical discussion as to whether it could possibly confuse someone that it did not confuse in any way is probably a waste of time.
Sustained.
When you said a year, how many months is in a year?
We'll go ahead and move on.
Okay.
We'll go ahead and move on. I want to turn your attention to Borough Exhibit 9. I'll put that up on the screen. And would you identify this, please?
That is the estimated check for our participation in the well.
And to your knowledge, was that check ever cashed by OVINTIV?
No, not as of yesterday.
How did you transmit this check?
We sent it with other joint interest billing checks, and those were cashed, but this one is not.
So just to be clear, that in the same envelope, there are other routine joint interest billings that you sent in. Those were cashed. This one remains uncashed.
Correct.
Do you know where this check is now?
No.
All right. No further questions.
Mr. Mayo, do you have any questions for this witness?
I do. I have just a couple here. To go back, Mr. Wixom, we didn't dive deeply into your expertise as a landman. It's been established in this cause. But as an expert in petroleum land management, I'm assuming you would have a pretty clear understanding of what types of information are necessary or advantageous to try and acquire prior to leasing someone. Would you say that's fair?
Yes.
Okay. Do you believe that before you take a lease from someone, it's relevant whether a well has been drilled on those lands?
Yes.
Okay. Do you typically, as an expert in petroleum land management, ask an interest owner whether there's been a lease proposed or drilled on their lands before executing a lease with that owner?
Yes.
Okay. And so in this case, with the reader in Eubanks, based on your testimony, you reached out to them prior to executing the lease with the reader in Eubanks and asked them whether the Moon well had been drilled and whether they'd received an election. Is that correct?
No, that's not the direct sequence.
Okay, so your expert testimony is that you would do it in all cases, but in this one you didn't do it exactly. Is that correct?
Maybe if I explain.
I don't want an explanation. I want you to answer my question. The question is, did you do that in this case? Did you reach out to the readers and say, hey, has a well been drilled and or have you received an election to participate in this well? Yes or no?
He volunteered the information before. I didn't have to ask in that case.
That's fair. Thank you for that qualification. So you did, at the time you were executing this lease, you knew that an election letter had been sent and received, and you knew that the Moon well was in existence. Is that correct?
Say that again.
It sounded like a compound question. If you split it up, that might help.
Reader in Eubank contacted you, reached out to you, either through their agent, which we are willing to stipulate is their agent, or them themselves reached out to Bro. What you said was they offered to you the information that I had asked, that the Moon well had been drilled and that they had received, the reader in Eubanks had received an election letter. Is that correct?
I think it might be easier if I told you more of the sequence.
That's not the purpose of this hearing.
Okay,
I'm sorry.
restate the question, sorry.
Okay. You testified moments ago that as an expert in petroleum land management, you would always contact an owner and find out the value of the asset you were about to acquire through lease. That's a statement, not a question. So I was just letting that sit there. You then stated, and I'm trying to clarify this part of your testimony, you stated that in all cases you would do that prior to leasing. You would reach out to find out if a well had been drilled, if there was production on those lands, or if an election had been sent. Is that your testimony?
Not in all cases.
Okay. So it's slightly different. In this case, in what cases would it not be important if a well had been drilled?
If you don't know if there's no evidence of a well being drilled, I wouldn't ask.
Okay, so if you didn't see any evidence that someone was being sued, you wouldn't ask them if they were being sued.
Say again?
Objection relevance.
Okay, that's fair. Withdrawn.
Sustained.
I think the point has been made. I guess to fast forward to where we are, at the time you executed the Bro leases with the Reader and Eubanks, Bro was aware the moon well had been drilled. Is that correct?
Yes.
Bro was aware at the time those leases were taken that AFEs had been sent to the Readers and Eubanks. Is that correct?
The defective notices of opportunity to participate were sent.
So is it correct that Bro knew before entering into the Bro leases that the Readers and Eubanks had received election offer letters? Is that correct?
We knew that they received an offer to participate.
Thank you.
It wasn't a complete.
That's, we can reserve the argument for the attorneys. I just
Okay.
need an answer to the question. Are you aware, I mean, as the expert for Bro in land management, I'm assuming you're aware of the terms of the Bro leases.
Yeah.
And you're aware of the in whereof clause in the Bro leases that specifically identifies the date the well was spud for the moon well?
Yes.
Okay. Were you aware at the time you entered into the Bro leases of the date the Readers and Eubanks received the election letter?
Yes.
Okay. Because you have counsel, I think it's fair to assume, but I'll give you a chance to confirm, that you also then knew when that expiration deadline would occur for each of those offer letters. Is that correct?
If it was a valid notice of opportunity to participate.
Sure, that's the board's job. But you knew that 30 days from the date they received, you could calculate that. I mean, you have a degree in mathematics. You clearly knew when 30 days after the receipt date was, right?
Absolutely.
Thank you for that. Okay. No further questions for Mr. Wixom.
Division.
I don't believe the division has any questions for this witness. Thank you.
Board? Any questions? Seeing none.
I have
Yes.
two subjects for redirect. They should both be pretty quick.
Okay, please proceed.
Based on Mr. Mayo's cross-examination, Mr. Wixom, there's a sequence of events here you tried to get out a couple of times with the Reader Eubank situation. Can you briefly go through that for us? How did Bro become aware of this leasehold and all the conditions that are stuck with it?
Yeah, so on September 22nd, my brother sent me an email. He was rummaging through his old emails and saw...
Objection. Who's your brother? And
Oh, sorry.
Yeah, please identify.
The owner of Bro Energy sent me an email of this lease indicating the interest. It was estimated to be 0.6%, so a little bit higher, so different net acre, but roughly the same net acre. So he called Mr. Reader that night, and then the next day he talked to his counsel, and
His counsel is Mr. Keller. I apologize.
Mr. Keller,
for
yeah.
interrupting.
So Brian and I and Mr. Keller spoke, and he...
Objection, hearsay.
Sustained.
Hearsay evidence is admissible. Mr.
No.
Wixom is part of this conversation.
We will we'll acknowledge it's hearsay. Is that reasonable?
Yeah, thank you.
Okay.
So in any event, so it was, he thought that Mr. Reader told Brian about it, but it was Brian that came out of the blue and asked him about it. And so that's kind of a misunderstanding that.
And during that course of that conversation, Mr. Keller told you an awful lot about what he knew about the well. We saw a little bit of that on the emails. Is that right?
Yeah. So when he got the notice, he looked at it thinking, "Whoa, they."
Objection. This is inadmissible hearsay, and the board can admit it for evidentiary weight, but it offers none. He is about to opine on a legal attorney's advice to his own client who is not Mr. Wixom.
Sustained.
Let's move on to the second subject, Mr. Wixom. You were about to say something about the offer was not a complete offer, and Mr. Mayo said, you just answered my question, please. Would you describe for the board what a complete offer would be?
It would be the lease term, the lease royalty percent, and how much per net mineral acre. That's typically on all offers to constitute a real bona fide offer.
And that's as far as an offer to lease, but what about an offer to participate? What would constitute a complete offer to participate?
They would need enough information to make it an informed decision, like what your percentage would be, how much you'd be on the hook.
And if there's something else, I apologize.
No, that's good.
And the AFE number is also important because you'd agree with me, I think, tell me if you don't, that the percentage is useless without an accurate number regarding the cost. Is that right?
Yeah, cost is important, and that was a very old AFE, and the costs were exceeded by the time they received that notice.
So by the time, even if the percentage interest had been provided to Mr. Reeder and Mrs. Eubank, the total number, the AFE number at that time was incorrect. Is that correct?
Correct.
All right, no further questions.
All right. I believe you have another, yes.
Chairman
Mr.
Borden,
Mayo.
I think that opened up just a couple follow-up questions on recross.
Let's just finish this.
I know,
Okay.
I'm going to try and keep this simple.
Okay.
Mr. Wixom, has Bro Energy ever proposed a well?
No,
Has Bro Energy ever drilled a well?
no,
Has Bro Energy ever force pooled a party?
no,
Has Bro Energy ever prepared an AFE?
no,
Are you aware, as the expert for Bro Energy today, that an AFE is by definition an estimate?
correct.
Okay, and can you please identify, you mentioned the... Oh, I apologize, talking the wrong direction. You mentioned that it didn't include what you call a legally sufficient notice of opportunity to participate that needs to identify their interest and some other stuff. Could you please just run through that list of the other stuff that is required to be a legally sufficient, in your opinion, notice of opportunity to participate?
You would want to notify, you want to know
What pieces of information do the statutes and regs require?
I'm not an expert in the statutes, but you'd want to say the legal location, you want to know what zone you're going for, when you're going to.
That's enough. I'm good with that. Thank you.
Okay, we are going to take a break. I believe you have another witness coming, but you need a little break beforehand.
That seems reasonable.
Okay, just a 5-minute break. Everybody can do whatever they need to do. All right, we're back. Yo, 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 yo. So we're still on the record, and I just need to, remind everybody that it's almost 4:30. I have to leave by 6. We have other people, court reporter, others who also can't stay all night long. So that gives us a little over an hour and a half to get through whatever we need to get through. So I'd remind all involved parties that we need to be expeditious, we need to press on, we need to get to the point, and we need to, arrive at some conclusions here and not drag this out. So that said, over to you, Mr. Hunter.
Thank you, Mr. Chairman. Got one last witness. I'd like to call Reed Lambert to the stand, please. All right, Mr. Lambert, would you, we'll get the court reporter to swear you in, please.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right. Would you state your name for the record and your address?
Reed Lambert.
Can you turn your mic on, please?
Oh, thank you. Reed Lambert. My home address is 13012 Grouse Point Cove in Draper, Utah, 84020.
All right. Mr. Lambert, have you testified before the board before?
I have spoken before the board before. I don't remember if it was argument or testimony. It was in connection with a rulemaking procedure.
All right. But you are pretty sure you weren't qualified as an expert during that time?
I was at that point in kind of the same capacity I am now, which is the capacity of someone with some legal training, some experience in the oil and gas business, but more importantly, a member of a family corporation and a consultant to a number of landowners, and speaking more from the landowner perspective.
Right. And your legal training helps you with that, but it's not the only experience you have. Is that correct?
That's correct. Well, it does all mix together, but certainly my legal training helps on the legal issues, and my experience being a member and a consultant to a family corporation and to the extended family, and then in my legal practice to a number of landowners that I have counseled over the years. That's the experience that I have that I think brings a perspective to what we're talking about here today.
All right. So I'd like to ask the board to recognize Mr. Lambert as an expert in mineral ownership and mineral ownership issues.
Mr. Mayo.
I have an objection for a couple of reasons. Mr. Lambert is an attorney here. Not here. He is an attorney. We just went through a land witness, a land management witness who gave Bro's understanding. I think the only purpose this can serve is to try and confuse the board into thinking that this is advice the readers and Eubanks had versus advice that a mineral owner would give to another mineral owner, which again may be helpful, but I think in this hearing we've had enough testimony from experts to probably get established the fact that they disagree that it's sufficient and we think it's sufficient. I think we've kind of established that, and now we can just move into the legal argument without a mineral owner expert. So objection is duplicative and irrelevant.
Before I make a decision on that, could I hear from the division?
We're not going to object. We're just going to be happy either way.
What are your thoughts?
I'm more than happy.
Are you about to tell us about
if you'd like to ask
basis of
Mr.
his
Lambert questions yourself, or I can voir dire him additionally if there's anything that particularly you'd like addressed.
I just didn't hear anything specific to mineral expertise or issues. I just heard generality, so I'm not sure what the expertise is in.
I can ask him 3 or 4 more questions and maybe help you clear that up. Would that be?
One
okay?
question would be good.
One question?
I think also, again, given our time constraints, you know, could we just, this is going to be more of his opinion? Does he have to be an expert witness, or could he be, I don't know if there's.
He needs to be an expert witness because otherwise the facts have to be admissible.
He doesn't have any facts that are relevant to the hearing, so he can't be a fact witness. The only way he can be sitting at that table is if we qualify him as a mineral expert because we believe that in some way that will help inform this hearing.
Okay. Why don't you just brief thumbnail sketch of qualifications and then a very brief discussion, and then let's get into the meat of the subject, because I feel like we've been somehow working out here for the last 4.5 hours, and we still don't even know what it is we're about to argue about. So let's go.
Mr. Lambert, were you paying attention to that discussion there?
Yes.
So if you could clarify for the board what your expertise is and the source of that.
Well, and again, I think that the expertise is based on 2 things, and one is legal training, which does inform everything that's going on.
He's not here testifying as an expert in legal training.
So tell us about your expertise in the area you were an alleged expert in.
Well, and then the other is that I was a member of Lambert Legacy LLC. Lambert Legacy LLC is essentially a legacy mineral owner company. It comes from my great-grandfather, who was a sheep rancher, had acreage in 5 counties across eastern Utah and western Colorado. The interest was divided up among children. We're now several generations later, and there's small interest held by a number of people. I'm a member of one of those entities which is the interest that my mother inherited. I am a frequent consultant to regarding the interests that were held by her 2 brothers. I'm frequently in communication with other members of the family as well. In addition to that, in my legal practice, which not on the law side so much, but I have frequently dealt with individual mineral owners who seek my counsel with respect to issues concerning their mineral ownership. So as I spoke to Mr. Hunter, my understanding of the reason that I would be called here today would be to evaluate the perspective of the mineral owners, of the mineral owners with respect to the transactions, the documents that were the subject of this hearing.
I object. I think this is duplicative to a petroleum landman. Petroleum landman, by definition, deals with minerals and land.
Why don't you?
I feel that this is duplicative to the petroleum landman testimony because by definition, an expert petroleum landman is expert on minerals, is expert on the land. And so I see that you've already had a witness testifying as a petroleum landman. I don't understand the need for 2 petroleum landman experts.
Well, and I certainly wouldn't qualify myself as a landman, and my understanding as to the subject matter of my testimony is that it's something completely different than what we heard from Mr. Wixom earlier.
Well, it may be different, but I don't know how it's relevant because we're dealing with petroleum land man who is an expert. By definition, we qualified him to testify regarding petroleum minerals in relationship to land.
Well, like I say, I think it's different testimony and from a different perspective rather than being the perspective of Burrow Energy and its landmen. It's the perspective of Gelmax LLC, Lambert Legacy LLC, the mineral owners who frequently receive these kinds of notices.
I don't see the relevancy to the.
That's a weight and credit. That's a relevancy question for the presiding officer, which is Mr. Borden.
I think.
If you'd like, I can renew my objection to give you a clear avenue to decide yes or no.
We're going to go deliberate for 2 or 3 minutes, and we will return shortly. We are off the record for a moment. Mr. Mayo?
I believe that's where we are. Are we back on the record?
Well, sorry, we are back on the record.
Okay, we're good.
Now we're back on the record. Is that right? He just said we're good, I think.
All right, we are back on the record. Apologies for that messy start. Mr. Mayo, your objection, does it still stand?
Objection to the witness testimony is irrelevant, duplicative, and otherwise unnecessary.
All right, also based on the board's consensus, we are concerned if Mr. Lambert can be certified as an expert witness in this matter. I know you're an expert in other things. So sustained, and back to you, Mr. Hunter.
That's the close of my case in chief.
I can't remember. I don't think we've done submission of exhibits, and there's a little bit of argument to be had. If there's a preference on which direction and which order, we'll follow.
Do we need to hear from the division? So let's go to the division next, and then we will get exhibits entered.
The division doesn't have a case to present. There is some legal argument we'd like to make, but that can be done as part of our closing argument.
Okay, that's fine now. Mr. Mayo, should we enter your exhibits, and then we'll back to you, Mr. Hunter, for your exhibits.
That would be great. Mr. Chairman, let me see and make sure I've got a clear. It's going to take me a few minutes. Can we do that after the argument? Because I've got to figure out exactly which exhibits I admitted.
Yes.
Thank you.
Mr. Hunter, do you need to say anything?
I can move to my exhibits while Mr. Mayo is going, or
Okay.
I can do my closing arguments, or I can do whatever we want to do to save time. Anything's fine with me.
Why don't you do your closing arguments?
Okay.
And then also enter your exhibits.
Okay, well, we'll do
If you're
the
prepared.
mechanical things first. I would move for admission for Bro exhibits 1 through 12 into the evidence.
Any objections, Mr. Mayo?
Other than those lodged today, no. No new objections, Mr. Chairman.
And the division has no objections.
They are so entered. Oh, board, any concerns? No, okay. You may proceed then.
Thank you, Mr. Chairman. Essentially, I'm just going to run through my executive summary on my brief. It's basically the first page of everything that's there. And in a nutshell, this is what the problem is in this case. Number one, there's 2 JOAs in front of the board today. There's some legal argument in Mr. McDonald's OVINTIV's rebuttal that, no, we're barred by a section of the regulation. That is not correct. The regulation involved includes a 60-day or a 30-day limit and then a 60-day negotiation period, which doesn't apply here, because what I'm asking the board to decide is the meaning of any circumstances. Unqualified, unmodified, any circumstances. Mr. McDonald's argument is there's a comma and an and that means if then. That's not the case. In any circumstances, Article 7, the basic form 1989 or 2015 JOA, Article 7, is the standard in all circumstances. Now, usually, if I objected in time, if Bro had the proper notice, if the readers had the proper notice, then that would have been an I win button for me because of that comma and. But in this case, it's not an I win button. It's just the board gets to decide. That's the difference between my position and OVINTIV's position. So the board, in its discretion, should apply one of those JOAs to govern this. That JOA that we proposed was already deemed just and reasonable in prior board hearings between these 2 parties. We didn't object to the terms as presented in Bro's exhibit. Those are fine with us. And that is it's not a willing contract. It's still going to have to be imposed, but it's as close to a willing arm's length contract as we're going to get in this situation. That's the end of the JOA argument. Next is a statutory interpretation argument. We talked about the importance of the calculation. Number one, they didn't do it right. And yes, it can be corrected, and yes, it can be fixed, but it's not right. Second part of that problem is the statutory interpretation problem, and that's the bigger one. The plain language of the statute says if it's leased, the consenting owners pay royalties, period. Mr. McDonald would like you to read in to the statute, and OVINTIV's position is that you will go back in time, figure out what was going on with the NOPs, when those happened, when they didn't, who got what, whether there's bad addresses or not, all that stuff. Or you can consult the public record, a recorded document, which is self-authenticating and gets put into evidence anywhere in the state of Utah with no objection, and just read the document. Did the document appear of record prior to the hearing where the evidence is admitted? It's very simple, and that's the plain language of the statute. There is no back-in-time provision of it in the statute at all. There's a separate statute about unleased owners. That's where you get the weighted average royalties. That separate statute says the calculation will be determined at the time of drilling. But you only have to calculate if you can't read it in a publicly available document. So the spud date is only relevant. That's the time of the calculation. And that's the only place in the statute that talks about time. And the reason for that is not because drilling is somehow very important. It's because that's when the board decides who's consenting and non-consenting. There are no decisions made until the board hears all the evidence. And so that distribution between leased and unleased, consenting, non-consenting happens at the hearing. That's when all this gets decided. That's the end of the statutory argument. The NOP, the Notice of Opportunity to Participate, it's a regulation. You've got to conform. There's no cure provision in there. You got one shot. As an operator, as a consenting owner, you put it in the mail and you're done. Hegarty, the Hegarty case says that, strict compliance. There's no substantial compliance. There's we fixed it later. None of that. OVINTIV wants a strict reading of the regulation. Oh, it doesn't say we have to put a percentage in there. Okay, let's do a strict reading. Strict reading is, these are the requirements. One of the requirements is an AFE. It has to be an AFE. Let's continue our strict reading and go on to the definition of an AFE. It's an estimate made in good faith about the cost of the well in the future. By the time this NOP went out, the future had become the past. In December of 2021, they thought the well would be 6.3. By the time they sent this out, it was 6.5. Oops. That's not a good faith estimate of what's going to happen in the future. That's a misleading statement of what has already happened. The bad faith AFE taints the NOP, the Notice of Opportunity to Participate. We're done. But wait, there's more. That's the offer to participate. The division already, I'm not even going to go, I'll let the division argue about the missing interest terms. Because by a strict reading, I guess it's not there, but that's material. So let's talk about material offers, good faith offers. A good faith offer has to be one that the parties intend to govern the relationship between them. There's a DCM versus Pinecrest case that explains the whole thing. Mr. Begley will sort that out for you. Sorry, Mike. But what has to happen is that both parties need to be able to say yes to the same thing. So an offeror has to give the person, the offeree, a chance to say yes or no, up or down. If you just tell somebody, call me, we'll talk about it, that's not a yes or no. That's a, I agree to receive your phone call. That's not an offer to lease. And here's the problem with what having such a narrow focus and a technical expertise on the board is that the board, using the word offer, accidentally, I guess, adopted all of Utah law on offers. And so you're stuck with what the state of Utah thinks about offers and contract law and all that complicated business. So when someone has an offer out in the real world, like Mr. Lambert testimony is going to be proffered, it's what do you...
Objection.
It was a
Mr.
proffer.
Lambert was not allowed to testify.
Proffer's on record.
Sustained.
The offer has to be something that someone can say yes to. It has to be on terms that can be broken, and that's kind of key. If you can't tell whether someone has broken their offer or reneged on it or cheated you somehow, it's not an offer. I send you an offer for 3/16 lease for $10,000 an acre, and I send you a 1/8 lease at $5,000 an acre. Hey, we had a deal. If you don't have that kind of certainty, you don't have an offer. So there's no offer to participate because the AFE tainted the NOP. There's no offer to lease because the terms just aren't there. The NOP is bad for two reasons. Either one of them works. Find which one you want and shut it down for either one. And finally, that's it for the NOP argument. And let's just go to the non-consent part. I've already given you my best shot at why the NOP is bad. If the NOP is bad, you can't get non-consent penalties. That's Hagerty up and down all day long. If there's no non-consent penalty for Bro, there's no non-consent penalty for anybody. Because if the notice was bad for Bro, the notice was bad for everybody. Because it's the same notice. And let's talk about the consequences of that. OVINTIV doesn't get a non-consent penalty. On the other side, Bro loses out on its investment. It's as simple as that. By the time the 300% penalty is paid, it's all gone. These wells don't last long. You can see it on the division's numbers. You can see it right there on the chart that's still up. Gangbuster production right up front, and then it peters out not even a year later. Best days of this well are already behind it. So the consequences are very different. To a non-operator, they didn't follow the rules. It's their burden legally to prove that they followed the rules in order to get the penalty. Hagerty. If our burden as the defendant, the respondent, is to say there are problems, and those problems go beyond something that can be cured. Because number one, there's no cure in any of this. And number two, it's because there's a trend, like the division pointed out, of people not giving good faith offers, good faith information. Mr. Keller asked for the revenue, and nobody knows whether ever that got out. Gee whiz. They were all over it when they was asking to lease. They were all over it when he wanted to talk about, what the well expenses were. But that was a crucial piece that Keller needed. He wanted it. And Mr. Lair said, I'll get back to you. Crickets. Crickets right past the deadline. The next time they talked was September 27th, past the September 15th deadline. Hey, did you consider our offer? According to OVINTIV's position, they're already stuck. You're going to take our way or no way. But the NOP was bad. The NOP was deficient. And that tainted it from the very beginning. Nothing that happened after James Reeder opened that envelope matters. Because once he looked at that and it didn't contain an offer to lease or an offer to participate, you're done. OVINTIV can renotice this and then get the non-consent penalty after they renotice everybody, and Bro will come in and propose this different JOA. We'll come to terms on it somehow. That's fine. We'll consent. Actually, we probably won't even object to the JOA because then it'll be a done deal. We'll just be consenting. We'll just agree to participate in the well, and the JOA will be a done deal. That's it. Or the board can send a message that its preferences are actually what the rule is. The rule is you got to send a good faith offer to participate. You have to send a good faith offer. If you don't, we're going to make you have a do-over. That's the way it needs to be, because there's no one else looking out for the little guys. You guys don't hear about problems unless you hear them basically from me. And you don't hear about, just like Mr. Lair never heard any complaints. That doesn't mean there weren't any. Doesn't mean people weren't upset about things. It just means that it never percolated to the top. This is your chance. I yield.
Let's go to you, Mitch.
That's fine. I think procedurally, though, then I'd be able to respond to the division's arguments because we're the petitioner. So if you'd rather go division first and us last, that's probably.
Division, apologies.
Okay. Either way, I'm fine with you getting a rebuttal afterwards if you'd like. Okay. Thank you. Just really quickly, I'd like to address a few things. There was substantial briefing in this matter, and probably a lot of the context is missing, and unless you have read the briefing, I'll try and touch on some of the relevant parts to apprise you of where we're at. Where I'd like to begin, though, is actually a response to OVINTIV's reply memo that was filed on the briefing. And in particular, OVINTIV objected to the division's participation or the way it had participated in presenting legal arguments or on behalf of a party or weighing the evidence presented. And the substance was that the division should be a technical advisor to the board only and shouldn't be making legal arguments. Oh, shoot. Do you mind if I grab the cord? Really
Please,
fast.
go ahead.
Okay. So I just wanted to address that briefly, what the division's role in these proceedings is. And first, I would look to the statute. I was unable to find anywhere in the statute that says that the division is the technical advisor to the board. What I did find was Title 40-6-15 that says the division created, and it says the division shall implement the policies and orders of the board and perform all other duties delegated by the board. In subsection 16, it says duties of the division, 40-6-16, subsection 4, the division shall review and evaluate prior to a hearing evidence submitted with the petition to be presented to the board. Given those directives, I think the division is entirely acting appropriately and within its direction to evaluate the evidence that has been submitted. The division does not have an interest in making arguments on behalf of any party. The division is interested in making sure that any person appearing before the board is complying with the statutes and rules. That's what their interest is in. And to that end, when they are reviewing this evidence that is submitted, they're looking at it, does it comply with how the division understands and implements those orders of the board? And the division's arguments in this case are not on behalf of any party. They have looked at the relevant language in the statutes and opined as to what the division believes Utah law is on that topic, so for the board's consideration, so it can review that and evaluate that in making its determination. A few things. So in this case, Bro Energy did file an objection, and they raised 4 main points. The division looked at those main points and did present argument on them. On the first objection that Bro Energy raised was that the JOA as proposed should not be adopted, and that a different JOA should be adopted instead. The division is not an expert on JOAs. It doesn't have an opinion on that matter other than just to point the board to the statutory directive, which is found in 40-6-6.5, that in adopting the JOA as part of a compulsory pooling matter, the orders shall be made upon terms and conditions that are just and reasonable. So it is the division's position that any JOA should be just and reasonable, and that is a matter within the board's discretion. If you go on to subsection C, it says that the board can adopt terms appearing in a joint operating agreement for the drilling unit that is in effect between the consenting owners, one that is submitted by any party to the proceeding, or one by its own motion. Any of those are acceptable under the statute for the board's consideration. The second issue that Bro raised was they objected, the request for agency action requested that the pooling order provide that Mr. Reeder and Mrs. Eubank would receive the average weighted royalty. Bro objected because under the statute, it read that the statute provides that if they are a leased party, they should, the consenting owners should be paying the royalty interest during the recoupment period, not the average weighted royalty. The division did look at this, and this is the provision at issue. I'll read subsection 5. If a non-consenting owner's tract in the drilling unit is subject to a lease or other contract for the development of oil and gas, the pooling order shall provide that the consenting owners shall pay any royalty interest or other interest in the tract not subject to the deduction of the costs of production from the production attributed to that tract. Subsection 6 goes on and says if a non-consenting owner's tract is not subject to a lease or other contract for development, the pooling order shall provide that the non-consenting owner shall receive as a royalty the acreage-weighted average landowner's royalty. As the division has reviewed this statute, it appears clear that if a parcel is leased at the time that the pooling order is entered, the order should provide that during the recoupment period, the royalty interest of the lease is paid. The division looked for language that tied that specifically to the time that the notice of opportunity was presented and couldn't find any language. It found it particularly relevant that in 6B, it says when you're determining the average weighted royalty, you do determine that at the time prior to the commencement of drilling. So clearly there could have been language included if that's when they wanted the calculation to occur, but it's not in the statute. The plain language of the statute appears to say when you're entering the pooling order, you look at if they're leased or not, and if they're leased, they fall under subsection 5. If they're not leased, they fall under subsection 6 for a non-consenting owner. So the division's position is it would be appropriate for the pooling order to provide that that the consenting owners will pay the lease royalty in the Eubank and Reeder lease. The third objection was an objection to the sufficiency of the notice of opportunity because the notice did not contain an offer to lease. As you may recall, there has been a case, the Utah Supreme Court did look at this statute and the statutory penalty for non-consenting owners, and it's the Haggerty case. And in that case, the Supreme Court said that in order for an operator to get a non-consent penalty against a landowner, they have to strictly adhere to the statutory notice requirements. And specifically, imposition of a statutory penalty demands strict adherence to statutory notice requirements. Therefore, the threshold requirement for non-consent is the establishment of written notice sufficient to trigger the necessity for consent and sharing of costs in a specific well. I researched as part of the preparation for this hearing what strict compliance means when you're dealing with notice, and it turns out there are lots of statutes in Utah that require strict notice compliance. And particularly, there are two types of compliance. You can have strict compliance or you can have substantial compliance. In this case, The Supreme Court says it has to be strict compliance. And that has been defined. This is a quote from Green versus Utah Transit Authority. It's a Supreme Court case 37 P. 3rd 1156 2001. So it's speaking about the requirements of strict compliance, and it says, as outlined above, the legislature has explicitly declared how, what, when, and to whom a party must direct and deliver a notice in order to preserve his or her right to maintain an action against a governmental entity. So this is a lawsuit against the government. And then it goes on to say, compliance with the statute is the determining issue, not the actual notice. In the absence of some ambiguity, we will not disturb explicit legislative requirements and read into the statute an actual notice exception. So as the courts have opined on this issue, whether or not the party received actual notice is not what is required. What is required is strict compliance with what our statutory notice requires. And that statutory notice is found in our rules. And it is the definition of a notice of opportunity to participate. Oh, that didn't work quite as good. Notice of opportunity to participate, and it requires that the notice be provided and include an offer to lease if the owner is an unleased owner, and an offer for the owner to directly participate financially in proportion to the owner's interest in the drilling, testing, completing, equipping, and operation of the subject well. It also requires an AFE for the subject well. And an AFE is defined as a detailed written statement made in good faith by an operator, memorializing the total estimated cost to be incurred. So if the board finds that these notices met those explicit requirements, then the notice was sufficient. If it did not meet those specific requirements, it was deficient notice, and there can't be a finding of non-consent for these owners, and there can't be a statutory consent, non-consent penalty. The third objection that Bro raised was that the notice was deficient because it did not include an offer to lease. The term offer is not defined in our rules, so it doesn't specifically state what that would include. There is a very long-standing statutory construction rule that says that when the legislature borrows terms of art in which are accumulated the legal tradition and meaning of centuries of practice, it presumably knows and adopts the cluster of ideas that were attached to each borrowed word in the body of learning from which it is taken. That's a U.S. Supreme Court case, Morissette v. U.S. 342 U.S. 246. So in other words, if you use a legal term of art, it carries with it all of the requirements for that legal term of art. And in this case, the word offer is a legal term of art. And every first-year law student learns very quickly what the requirements of an offer are. And those requirements are that it be definite enough that you can tell what's being offered, that it is capable of being accepted, and that an offer to negotiate is not an offer that you can accept and bind someone to. So given that that appears to be in the division's opinion, what the Utah law requires is that it actually contain an offer with terms. When the division reviewed the notice of opportunity to participate, it did not appear to comply with that requirement. If you looked at the notices provided, it provided contact information and said, contact us as an alternative to discuss royalty and bonus consideration if you wish to lease, but there was no offer for a 1/5 royalty or a bonus payment. And if this rule requires an actual offer, it does not appear that the offer met the requirements of the rule. Bro Energy also raised an objection about the fact that there does not appear to be a bona fide offer in the notice of opportunity to participate. The division is not taking an opinion, it doesn't have an opinion on that, other than to say that the division, that the board did rule on whether or not the notice of opportunity to participate specifically related to whether or not it needed to include the percentage ownership of each non-consenting owner. The board ruled on that in March, and from the division's perspective, that ruling stands and would apply in this case, that it was sufficient without that information. Finally, Bro Energy objected to the risk penalty amounts, and the division would just recommend to the board that that is a number within your discretion. To the extent that the board determines that these parties are non-consenting owners, the board is required to impose a penalty of at least 150%. If you have a finding of non-consent, you have to impose the penalty. It can be between 150% and 400%, and that number is within your discretion. Finally, the one other point to address OVINTIV's reply. OVINTIV argues that if the board were to find that this notice was not deficient, that would open up all of the underlying orders and past orders to collateral attacks, and there would be no certainty or finality to any of the board's orders. And the division respectfully disagrees. The case law in Utah is very clear that orders are final if they are not challenged on appeal in the direct proceeding that you are in. Once an order becomes final, you cannot collaterally attack it in another proceeding. It is disallowed. It cannot stand. So any order of the board's that is final and was not appealed stays final. In this case, given that the division does not believe that the notice was sufficient because it did not contain the offer to lease, the division recommends that the board require OVINTIV to renotice these parties with a notice that does comply with the rules and come back and seek to compulsory pool at that point. And I have nothing further. Thank you.
Mr. Mayo, to you.
Thank you. I will try and make this brief. There's a lot to kind of recast and encapsulate here, but I'll do it as quickly and efficiently as I can. I guess I'll start with the notices of opportunity to participate in the sufficiency. Mr. Hunter says in his briefing, Bro says in their briefing, it's a complicated, thorny issue that all stems from one defective root, and that's that the NOPs are deficient. And there are two issues that the notice of opportunity to participate are sufficient. They're legally sufficient as a matter of law, as determined by this board, and as should be upheld by this board. And they're factually, functionally sufficient in the fact that not a single person who received this election letter contacted the board or OVINTIV and said, I'm confused and don't know what to do and I can't get the information I need. The only party that we know of who did receive one and contacted OVINTIV was able to not only navigate the process, but outsmart the operator and lease their interest as they should with the best offer they could get. So there is no insufficiency with these notices. They are legally sufficient because they are factually sufficient. And that should end the inquiry. And I also would like to point out something that I do want to apologize for the division. Division has a role in these. They are named a party in these. But I think where the crossover comes in and where the concern comes in from OVINTIV's standpoint is when they say, well, we haven't seen all the evidence, but based on your argument and weighing them, we think that one's more compelling. And I think that's probably something that, it's not inappropriate necessarily, but it's something that almost converts the division into a law clerk for the board, which I think creates a conflict of interest that's untenable for the future of these proceedings. So just to think about kind of that role, big picture, but it's not a concern here. But there is one thing the division said just now that I really want to point out, and
and hopefully explain why some of this kind of frustration at this process is coming through. The division's position now is Order 13215 that we participated in fully, that the division instigated, right? They raised the question sua sponte at the hearing examiner hearing. We don't think these are sufficient. They alone raised the concern at the 11th hour on the hearing examiner date and continued that to the board's hearing. At the board's hearing, we had a full discussion. There were several matters. It was discussed on the record with all the parties, and the board made the conclusion in a 3-1 ruling. And it said, listen, these are legally sufficient. Any that you've sent out to date, it's unfair to have you renotice them because all it does is give people an advantage they don't deserve or another opportunity that they don't deserve. That's not the point. We're not trying to punish you. But we would prefer something that's outside of the rules going forward. And what I object to the division doing is apparently what we're hearing now is, despite the fact these are identical notices of opportunity to participate, the division only felt it was important to raise one of their legal concerns about the insufficiency of it in that hearing. To remind you, that percentage of proportional ownership was not at issue. No one had objected. No one had raised that concern. And so the division went through and did an incomplete analysis, in my opinion, because now they have additional concerns that aren't covered by Order 13215 and that weren't presented to this board solely because the division chose not to do that. And so I do think it's important when we think about the application of Order 13215 that we remember the board entered that order less than a week ago. The board concluded as a matter of law that these regulations and these substantively identical notices of opportunity to participate are legally sufficient. The facts are the regulations have not changed in the last week. And although the division may now be aware of something, I'm sure in a couple of months we'll hear about another insufficient piece of these notices of opportunity to participate. And that's fair to a certain degree, but I also want the board to understand that there's finality in a particular matter and there's finality writ large. And decisions like this have real implications down the line. So Order 13215, we would argue, applies whole cloth. This board just entered it, and it is binding law. But even if the board doesn't want to apply 13215, the NOPs were functionally sufficient. Reeder and Eubank had no concerns. They clearly understood that they had both the opportunity to lease and the opportunity to participate. And they reached out immediately and pursued both of those avenues to their satisfaction. And we know they were satisfied because they're not here today. Despite 2 months of notice, it doesn't matter to them. Reeder and Eubank will be treated exactly the same regardless of what this board decides. The question is, does Bro, who had full knowledge, you heard their expert say, I knew that the well had been spud. I knew that they had received an election letter, but I did nothing about it and I took the lease nonetheless. The fact of the matter is, Bro took the lease subject to the non-consent, and they should be held to that. And if we go on to that JOA provision, for the JOA arguments, you know, the division's right. They express no opinion in their response. They're welcome to weigh in on the evidence here today and the positions, but they've made clear in their response they have no expertise in JOAs and they have no opinion on the JOA. But when it comes to Bro expressed a really clear opinion, and that was, hey, listen, it's a Solomon's choice. There's 2 JOAs before you. You choose which one is most fair, protects the little guy the best. The problem is, it's not a Solomon's choice. There is only one single JOA before you today. And the reasons are clear, and they are, as the board, division, and Respondents' Council have pointed out, they are a strict reading of these statutes. The JOA provision that Mr. Hunter cites, 7A, it's I'll paraphrase the Articles 7A through D of the standard and unmodified AAPL form. Bro's argument regarding the JOA. It hinges on the application of Utah Administrative Code Rules 649 to 8A5. And she showed us what that regulation says, as Ms. Harris showed us. Yes, could you, for the board to follow along? I apologize. It's the 8A5, No. And you may not have it. 8A, 8A5, 649-2-8A. Okay, that's okay. I'm sure I could too. The board doesn't, they would like us to move on. The truth of the matter is, Bro's argument hinges on its application of 649-2-8A sub 5. And Ms. Harris is kind enough to pull this up. It'll help us all stay on track. Sub 5, if you could. Perfect. And this is the provision to which Mr. Hunter points, or Bro, excuse me, points and argues extensively. And what it says is Articles 7A through D of the standard and unmodified AAPL Form 610 operating agreement, which are incorporated by this reference, are deemed just and reasonable under any circumstances. And Mr. Hunter would like you, Bro Energy would like you to stop reading there and forget everything else that's going on. The problem is there's more to it. And if you read the rest of it, and shall be adopted by the board in any JOA dispute under subsection 649-2-8A4. So if we go up to 4, which is obviously what that says, you have to go back to 4 to see if there's actually a JOA dispute. And so if you can scroll up for me, Ms. Harris, I'm sorry, to 4 right there. And it says, an owner who complies with the requirements of subsection 2. That is what creates a JOA dispute where you can impose this. And if you go up to 2, one more time, Ms. Harris, thank you. It says you have to supply written objections to a JOA within the deadline. So to recap, the only way that there's a JOA dispute here today is if you find that there were JOA objections, written JOA objections submitted during that 30-day deadline. If there weren't, there is no JOA dispute. There is one JOA presented, and that's the one presented by OVINTIV and the one that this board has found just and reasonable in multiple prior causes. Second, I'd just like to point out that I think Bro Energy is using 8A5 incorrectly. It's not a sword. You don't get to come into every hearing and say, these are the provisions I want in there. It's a shield. And it was designed during the rulemaking process, as some of the members on this board may see, to accommodate non-operators participating in the rulemaking who were opposed to presenting a cash call, to putting their money up front. And during the time, while there's no JOA yet imposed, there was uncertainty for the operators. And so these provisions were put in. And what they say is the operator, the proponent of the JOA, can use this as a shield. If you include these unmodified, we're not going to waste 4 hours having an argument about whether they're just and reasonable. That's the point of it. But it does not say that anyone can come in at any time and say, I want these to supplant what the operator put in there. That's not what it says. It's a shield, and it's not a sword. And finally, as quickly as I can, the acreage-weighted royalty, I want to be abundantly clear. OVINTIV is maintaining this argument at its detriment. It is a financial loss every second that I speak arguing over this, because this difference, this 0.4% on 1%, on 20% of that 1% is minuscule. We're talking over full payout, a couple of $100. So OVINTIV isn't arguing this issue for its own financial benefit. It's not doing it to get over on someone or even to deprive Bro of what it thought it was getting, right? But the fact is, if this acreage-weighted royalty decision goes the wrong way, there's a real problem in how the pooling rules work as a team going forward. 40-6, 40-6-6.5, sub 5. As Bro points out, I don't think it's necessary, thank you though. As Bro points out, and as the division agrees with in response, this says if a non-consenting owner's tract in the drilling unit is subject to a lease, ... the pooling order shall provide that the consenting owner shall pay any royal interest. And we don't disagree, right? That's clearly what it says, and we know the meaning of those words. But I think it's it's important to remember that it's a part of a set of rules. It's a part of a set of statutes designed to work together, and it's designed to include, by necessity, by designation from the legislature, a set of implementing regulations. And so we can't just look at that, right? What that says is there's no timeline. And Bro and the division say, well, that means the timeline we assume should apply, because there's no timeline, so it must be when the pooling order is entered, which is fair, right? It's not clear. But I think there's a better way to get to the right answer. And that's that, what does it say? It says if a non-consenting owner is tracked. Well, luckily for us, the legislature defined non-consenting owner, right? And it's in 40-6-2. And that definition says, and I'm paraphrasing for the most part, owner who does not consent to drilling or agree to pay costs, quote, in the manner and within the time frame established by the board in rule. And the board did that, did exactly that. After 18 months of excruciating rulemaking, it set up a manner and a time frame in rule upon which someone would become non-consenting. And 649-2-8A supports that interpretation because it says the board shall, there's no discretion, the board shall determine an owner is non-consenting if within 30 days they don't respond and elect to participate. And so the legislature said, listen, if they're a non-consenting owner subject to a lease, if this is a mineral owner who's leased to a working interest owner, to a bro who's being force pooled, listen, you guys have to pay the royalty interest to the mineral owner, right? That's what the legislature said. Operators, consenting parties, you have to pay the leasehold interest of that operator, of that non-operator, but you can pool their interest. But what it didn't say was, but we're accidentally and unintentionally completely reversing course on the fact that we need pooling at all. Because if you take their strict reading interpretation, what it says is in every single pooling hearing that I've been a part of in the last 7 years, I can tell you there's a significant lapse in time, months, between the date the elections are done and final and the date the board order is entered. Because we're not talking about the hearing date, right? We're talking about the date the pooling order is entered, which sometimes can take months. I mean, the 132.15 order was just entered this week, and it was heard in March. So we're talking several months at a time, and the strict reading says, if Reader and Eubank want, they can ignore the 30-day election deadline, they can just not respond to OVINTIV at all, and then at the hearing, they can show up at the hearing, and they can say, oh, we issued a lease to Reader and Eubank operating for a 40% royalty. And the statute says you have to pay that, so I guess you have to pay that. But that's clearly not what the rules were intended to do. That's not what the legislature set out to do when it did this. And I think it's really logical to say, if a statute says, if a non-consenting owner is tracked in the unit subject to lease, we should find out when that person becomes a non-consenting owner. And 40-6-2 says that's when in the manner and time frame established by this board in rule, and you go to that rule, and it says you've got 30 days to object. And so what that tells us is at the expiration of that deadline, that party is a non-consenting owner, and the board has no discretion to determine otherwise. They have failed to make an election timely, and that needs to be respected. And if not, the reality is there will be a lot of operator companies run by mineral owners who lease at the last minute. There would be no incentive to ever respond to a notice of opportunity to participate again. Because you could simply seek someone out the week before the hearing, lease to them, and you're in the exact same position as to whether you'd gone through and followed through on your statutory and regulatory obligations, right? The mineral owners have those obligations as well. Non-operators have those obligations as well. And if we find this way, if we find in favor of Bro on this acreage-weighted royalty issue, the board's following an interpretation that out of all the parties here benefits only one, and that's Bro. But if we follow OVINTIV's interpretation of these rules, it will protect the board's pooling rules for the future and net OVINTIV a couple $100 in the process. And on that, I would really like to appreciate and thank the board for their time and attention to this. And I would ask that you approve the request as granted and as argued here today. Oh, exhibits. I don't know if I did that. I'd like to move for admission of our exhibits A through Q, S as in Sam through AA, replacement exhibit BB, and exhibit CC through GG. As well as rebuttal exhibits 1 through 4.
Any objections to that? I know we.
My objection
on
to
the record. That
my objections to exhibits 1 through 4, rebuttal exhibits, has already been put on the record.
Okay. Division?
The division has no objection. I just want to note, I believe we did decide that you would submit a supplemental exhibit with all of the percentage ownerships as well.
Thank you. Yes, to try and truncate this hearing, we cut that testimony out. We'll add that in. Thank you.
Julianne, did you get that? Because he did, it wasn't a contiguous thing. There were several breaks. Could you say it again slowly for me so
I'm
I can
happy
check
to.
these boxes?
Yes. Essentially, Exhibit R is no longer necessary because we had one party reach out and lease during this process. So exhibits A through Q and S through HH, but replacement exhibit B, double B, instead of simple exhibit double B. Was that any clearer, Julianne?
Oh, no, I think I was talking about the nature of the supplemental exhibit.
Oh, no, I was actually talking about everything, but so it sounds like everything is entered except for R.
That's right, and one of them is a supplement replacement. There's a couple supplement exhibits.
And the rebuttal exhibits, they should be entered into the record because, okay.
As far as the exhibit we'll file after the fact, Julie, and we can talk about that after the hearing if you want. And now I'm done and we'll submit.
So, Mr. Hunter, I'd like to give you 5 minutes because a lot of people have talked since you last talked. And then I guess it would be very helpful to the board. What is the exact relief you're seeking from the board?
I'll confine my comments to that, and I'll take 3.
Okay.
So there's 2 versions of the relief. One of them is in the brief and our reply to the request for agency action, and we adopted in our reply to the division an alternative request for relief. Our brief says choose our JOA. Our brief says impose the statutory requirement of the consenting owners to pay the royalty on the consenting owners, like the statute says. Third, reject the notice of opportunity to participate as insufficient, with the consequence, fourth, because there's no good notice, no non-consent penalty can apply to anybody because the notice was substantially the same to everybody. Those are our requests in the order, in our reply to our response to the request for agency action. Our reply to the division's joint response said an alternative could be order renotice. Just order everybody noticed up again, a new 30-day clock starts. That also could work. And we offered some suggestions of what a good faith notice in Bro's view would include on the offer to participate. And we didn't include anything on the offer to lease because as long as you put some lease terms in there, it's probably going to pass muster. But the offer to participate had some more technical challenges we thought. That's it.
Vision, is there anything last minute you'd like to say? 5 minutes max.
5 minutes max. I think the division will rest on its arguments, other than just to say, I think the division and the board's objective is to ensure that parties are meeting and following the rules and statutes. And to the extent it's the board's determination as to what those require, and that's just the outcome we're all trying to ensure.
Mr. Mayo?
Yeah, a couple minutes just to address the offer to lease. There's been a discussion about offer to lease, and there's a lot of lawyers on this side of the table telling you, well, clearly that means offer the way I know offer in legal ways. But I'd just leave you with this example, right? If I have a basement apartment and I say, hey, would you like to rent my basement apartment from me? I won't post this ad if you would. Would you consider that to be an offer to rent? There's colloquial language and there's as a matter of law language. And I think we have to remember that this is a notice of opportunity to participate. Right? This isn't, you have to give them something that is legally sufficient for them to agree to participate. It's a notice of an opportunity. And I think offer to lease, despite what you've heard, is not a contract offer that is required to be returned, signed. It is, does this party know they have the right to lease? And clearly in this case, they knew that. So on that, I'll submit.
All right. Thank you for all your discussions and information. I know we need to deliberate on this, so we will go off the record and step out for as brief an amount of time as possible to arrive at the right conclusion. Thank you. We are off.
Chairman, you're live.
We are back on the record, and I would entertain a motion in this matter.
Mr. Chairman, I move to approve OVINTIV's request for agency action. Pursuant to the notice to participate given to Reader and Eubanks, the notice required action by the parties to participate or lease within 30 days, or any offer was terminated. Also, based upon the facts and circumstances in this case, the board will impose a 150% penalty in regards to non-consenting parties.
Anyone like to second that?
Second the motion.
Any last comments from the board? Seeing none, all those in favor say aye.
Aye.
Let the record show that was unanimous, but Mr. Moon did not vote as per our earlier discussions on this matter. And one last point. The board would like to direct the division to commence informal rulemaking to modify the existing rules to avoid any confusion surrounding notice of opportunity and offer to lease. So maybe we don't find ourselves in this situation again.
Thank you. Can I ask one clarifying question?
Yes.
Well, my presumption is that you're going to request one of the parties to draft a proposed order, or are you going to do it? Just one of the objections did deal with the royalty interest, and I may have missed a ruling on that matter, on what payment should be made to, whether it's the average weighted royalty or the royalty interest in the lease.
It was the original calculation as per OVINTIV, because that was within their request for agency action. That was our envisioning of it.
Okay, thank you.
Is that clear?
Yeah, just to clarify, the 19.6% roughly acreage-weighted royalty will be borne by the consenting parties during the recoupment period of 150%, and the difference, that 0.4%, will be borne by Bro contractually, not by delegation of this board, because I don't think it's outside their authority, but contractually, Bro will pay that 0.4% under the lease to the Readers Eubanks until that 150% payout.
That was the board's intent.
Okay, perfect, thank you. I'm happy to prepare the order if the board needs.
Actually, I think board counsel, Mr. Begley, is going to, with his ample free time, prepare this order. Okay, that concludes that matter, and I'm sad, but we don't have time for item number 4.
I'd like to make a motion to continue that to next month. And remind the board of the rule, it's been fully noticed, so just as long as that continuance includes the caveat that new notice doesn't need to be sent for this.
Do we need to vote on that or anything? That seems eminently reasonable, given it's almost 7, and my call starts in 6 minutes. All right, in that case, I would entertain a motion to adjourn.
So moved.
We are off the record. Thank you very much.
Thank you all.